Hey, everybody. Welcome. Impromptu Law of Self-Defense show today. How is everybody? Hopefully everything is working correctly. Let me take a quick look here. Yeah, looks a little fuzzy, doesn't it? We are having internet problems at my office today. Hopefully, remember, it looks good. Rumble looks good. Twitter. Come on, Twitter. Is Twitter working for me? It is. Holy cow. All right. That's pretty awesome. So, welcome, everybody. Welcome. We are covering, let me start again. This is, of course, Law of Self-Defense. I am attorney Andrew Branca for the Law of Self-Defense. Thank you. Thank you very much. An impromptu live stream show today that may go for hours. We'll have to see. We're covering the trial of Dean Cummings. This is a guy who used to be a famous skier, I guess. I don't follow skiing, so I don't know. But he's on trial for murder, manslaughter, and a couple of other charges, tampering with evidence, concealing his identity. And he's on trial for those charges in New Mexico. He got in a dispute with a landowner negotiating a property sale. And the landowner, he says, the landowner who was the victim here, the victim, he's Cummings, the defendant says the landowner sprayed him with a chemical irritant, presumably OC spray or something similar, and was trying to kill him. And Cummings grabbed his AR pattern rifle, struggled with the landowner, ultimately shot and killed the landowner. And he's been claiming self-defense ever said, but now he's in New Mexico on trial. This all happened in a trailer, Cummings trailer, which was parked with permission on the landowner's property at the time. But those were the only two people present. The landowner, who's dead, killed by Cummings, and of course, Cummings himself. Nevertheless, the states decided to charge him with murder. Manslaughter is kind of a lesser included, really, here of murder and these other incidental charges. This was brought to my attention, by the way. I was not planning to cover this trial, but yesterday, Law Talk with Mike. He's on Twitter as @LawTalkWithMike. He also has a YouTube channel. I don't know Mike real well, but he was kind enough. He's a lawyer, obviously. He was kind enough to invite me onto his show. He was doing kind of a recap of the opening statements of the case. By the time I saw his invitation, it was too late for me to join him, but I do sincerely appreciate the invitation. And his invitation prompted me to look at the opening arguments for this trial. And the opening arguments were just, especially the states, was just horrifically bad opening argument by the state. And I thought, you know what? This may be such a bad trial that it's worth watching. I don't know. All I've seen is the opening statements. So I don't know what the evidence is. We'll all kind of be approaching this fresh from the same position, but you know, we haven't covered a trial in real time. Now, this is pseudo real time because the opening statements, I'm speaking to you live right now on Thursday, November 3rd. The opening statements were on Tuesday, November 1st. So we're going to play catch up with this trial. I'll start with the opening statements. We'll go through those. They're very short. They're only 15 minutes, roughly 15 minutes each for the state and for the defense. And then we'll proceed there with the state's witnesses, and we'll skip breaks, and I'll fast forward or do it 1 1/4 speed or whatever I can do to try to catch up in real time. It really superficially based just on the opening statement strikes me as a prosecution that should not be happening. Not necessarily that I would know whether or not this shooting was actually lawful self-defense or not, but simply that I just don't see how the state hopes to disprove self-defense beyond a reasonable doubt. And if they can't do that, there ought not be a trial. Now, I don't know to what extent there may be a political dynamic here. There are, well, it's not really different races. I don't know what you would call it, but the victim appeared, he had quite a Hispanic name, Guillermo Arriola. And the shooter, Cummings, the defendant, of course, is a white male. I don't know. This takes place in the Los Alamos area of New Mexico, just west, the county just west of Los Alamos. much of which is very pretty. I've ridden my motorcycle through there many times. Los Alamos and north, kind of that Carson National Forest area is just gorgeous. That top third of New Mexico is quite pretty. The rest of it, you can keep it. But the top third that borders with Colorado is quite nice. So what I'm going to do is step through this trial. We'll start with the opening statements. Again, they're quite short. I'm here by myself, so I did send out some invitations to some of the other lawyers I like. If they'd like to hop in, I'd be more than happy to have them on. This case hasn't really gotten a lot of coverage, so I wasn't aware of it until Law Talk with Mike brought it to my attention. So I'm not sure what the other lawyers in my little social group might know of it or not. Of course, they're welcome to come in regardless. Excuse me just a second, folks. So what I'm going to do, since I am here by myself, if I need to take a break, I'm going to replay the opening statements if I need to take a break. So those will be running in the background, because the opening statements are supposed to be how we get to, what the narratives of the case are. What's the narrative of guilt, the state? What's the narrative of innocence by the defense? And it'll be good to touch base back there from time to time and kind of check what are we getting from particularly the state's witnesses, and of course the cross-examination as well, that would be consistent with a verdict of guilt, meaning consistent with disproving self-defense beyond a reasonable doubt, which is going to be the standard here. So I'm looking to the side because I'm actually prepping the recording for that, so I can play it if needed as kind of a filler if I have to run to the John or grab something to drink or anything like that. Let's see. Put that there. Export that. Actually, I will. I'm going to do a little audio work on it too. So yeah, if it looks like we're doing stuff in real time, it's because we are. So I came in actually at to the office about 6 o'clock this morning to do all this and to start this catch up, because I figured it would take all day, and I didn't have internet in the office. So it took several hours for them to get the internet fixed. It appears to be working now. So I'm going to proceed in the expectation that won't be interrupted during this live stream. This is going to be a long stream, folks. I might be here all day. I'm planning to be here for hours. So feel free to pop in, pop out, let friends know about it. Kind of an experiment. I don't normally, live stream trials in progress, even in catch-up mode myself. Usually I'm on Nick's show. In fact, I had reached out to Nick, Ricardo Law, to see if he would be interested in covering this, in which case I simply would have joined him on his show. But unfortunately, Nick has other obligations today and tomorrow, so he wasn't able to do that. So I'm kind of, I guess, taking up the mantle here. So let me get this over here. And then a departure from our normal practice, I will take questions from all the streams. We're simul streaming right now on YouTube, our YouTube channel, our Rumble channel, our Law Self-Defense members channel, and of course also on Twitter. We just a second time we're live streaming on Twitter simultaneously. So from time to time I'll look for comments there. It's been our more recent practice to only answer questions from our Law Self-Defense members, but because we're going to be here all day, I will say, if you're on YouTube and you're asking questions, they need to be super chat questions. I turned the super chat function back on just for this show. Frankly, I would encourage you to just become a Law Self-Defense member, ask your questions there. Those always get prioritized, and it's cheaper than doing repetitive super chats, but whatever. It's your call to make. Okay, let's see. Let me go here. Give me just a moment, folks. Let me open up a super chat window. See y'all. Okay, no super chats in this show yet, but if you're watching on YouTube and you'd like to have a question answered, that would be the time to do it. Let me pull up this shared tab over here. Now, I'm going to start this video right at where the state starts its opening. We're going to hear a few comments from the judge. He's giving kind of generalized instructions to the jury about things like the opening statement is not evidence and so much and so forth. And then the state's going to go right into it. I see someone asking in the comments, law self-defense membership's $9.95 a month, folks. It's less than $10, less than $10 a month, obviously, about 30 cents a day. And you can join right now at lawselfdefense.com/join and get immediate instructions for joining the law self-defense member dashboard for viewing and chatting and so forth. Obviously, the population of YouTube is substantially larger than the population of law self-defense, so I expect we'll see a lot of questions there. Now, I will say, I was shocked, really shocked at how bad the state's opening was here. It's almost impossible to understand what this case is about from the state's opening. I mean, I gave a brief description of what this case was about in just a few sentences, and I didn't know anything about the case when I started watching the opening. I knew literally nothing. I didn't even know for sure it was a self-defense case. And as you listen to the state's opening, try to figure out from what this prosecutor is saying, what the F this case is about. Because it took forever. It's just meandering. And she's talking about things that aren't really that important without effectively communicating to the jury a narrative. Remember, the jury is supposed to be here like a blank slate too. Right? They don't really know anything about the case either. The first substantive content they're hearing about the case is this opening statement. And the fact that the state gets to go first, folks, and makes the first opening statement, the first substantive communication to the jury is an unbelievably powerful advantage for the state. If you invite me to a debate and you let me speak first, if I get to frame the narrative, the argument, I'm 90% of the way to winning that debate. So, of course, we give the state this advantage because we also burden the state with having to prove guilt beyond a reasonable doubt or disprove self-defense beyond a reasonable doubt, and giving them the opportunity to speak first. And by the way, at closing, they get the opportunity to speak last as well. So the last substantive words the jury hears about the case is also from the state. Two enormous advantages for the state. But this is the state's opportunity to frame the entire trial, the entire legal battlefield where things are going to be fought. And it's unimaginable to me that a prosecutor wouldn't seize that by the throat. But I don't know, maybe this is this prosecutor's first trial. I don't know. It was not an impressive performance. I thought it was awful. But here we go. I'm going to, let's see if I can pull up this window. And like I say, I did invite some of my other lawyer buddies to pop in from time to time. No one's obligated to do that, of course. But I thought some might be interested. Oh my gosh, I have so many tabs over, I can't. Okay, hold on. I think it's this one. It is. Okay. Share audio, share this window, and of course we got it. Man, this new office is driving me crazy. All right, I'm only here 2 years, folks. 2-year lease. Then we will move on. I can hear. We might get train noises and stuff as we go along. Sorry about that. Oh, Robert Barnes. I should invite. I don't know if Robert would be interested in this kind of trial. I'm a big Robert Barnes fan, though. I'm not sure I have contact information for Robert. If anybody does, feel free to let him know to contact me. I'll be glad to send him the guest link. All right, so we're going to start here. Yeah, maybe Nat Lawyer Chick would want to come on. I don't know. I should. Perhaps not. All right. So we're going to start now. The judge is giving some last few words, and the prosecution should be getting up momentarily. that she is the third person from the left here, just next to the woman with the Cabernet colored jacket on. All right, here we go. I think.
Distracted by any member of the news media, you should immediately advise this to the court. The news media has been instructed not to film this jury or any member of the jury, whether in the courtroom or outside of the courtroom. The cameras may be allowed to photograph the testimony of certain witnesses and not others, or only portions of testimony of some witnesses. You should not draw any inference or conclusions whatsoever from this fact. The prosecuting attorney may now make an opening statement. The defendant's attorney may make an opening statement or may wait until later in the trial to do so. What is said in opening statement is not evidence. The opening statement is simply the lawyer's opportunity to tell you what the lawyer expects the evidence will show. State, you may make your opening statement.
Judge sounds a little drunk, huh? I know, they're masks. Well, New Mexico is a pretty liberal state, folks. I can't believe it either. But judge's courtroom, presumably the judge's order.
Thank you, ladies and gentlemen, for your time and attention this morning. I know it's a long morning, and now that you ate lunch, hopefully we won't put you to sleep. So thank you, though, for being honest in your answers so that we can pick the most fair and impartial jury for this trial.
Yeah, one weird thing about the state's opening is she keeps like dropping little things into an opening that are kind of normal for the opening. Like, thank you for giving honest answers, I guess, during the jury selection process so we could pick a fair jury. And there's nothing wrong with that. And I might say it myself, but that's like the least powerful start to an opening you could. I don't know, man. I would prefer to hit them with a bang, not simply polite chatter, but okay.
This is a criminal trial, as you heard, commenced against the state of New Mexico against Dean Cummings. And I'm going to play for you a phone call from a 911 operator to the center.
She also sounds like she's reading. She sounds like she's reading the whole thing. This happened in the Johnny Depp trial too, with Camille Vasquez in her opening. And I like Camille. She was a great lawyer. She did a great job for Johnny Depp. And of course he won. But man, that opening, when she was basically reading off a piece of paper, folks, that's not the way to do it, especially a trial you've had forever to prepare for. And this prosecutor has had forever. This shooting happened 2 years ago, folks. So this prosecutor's had forever to prepare here, but it seems like she's reading. Again, maybe she's new. I don't know.
Sandoval County Sheriff's Office dispatch that was made on February 29th of 2020.
They can't get the 911 recording to play. And another like kind of novice. She thought it was important enough to start with, and then now she's just going to let it go.
I bet my audio's on. Nothing like electronics. Is it on the court thing?
Pardon me?
On the podium thing? Because I have it plugged in.
I mean, there's no reason not to check this stuff out before you bring the jury in.
Is Jason here?
Oh my gosh. Yeah, I know a number of people had brought this trial to my attention, but I didn't really seriously take a look until Law Talk with Mike brought it to my attention yesterday. And many thanks for that, by the way. He has got his own YouTube show. I don't know Mike real well. I haven't watched a lot of his content, but the little bit I've seen is quite impressive, and I would encourage folks to go take a look and see what Mike has to offer. Yeah, this opening was so bad that not only can I only foresee, if that's all we knew was the opening, can I only foresee a not guilty verdict? It may not survive a motion for a directed verdict when the state rests.
That's okay. I'll proceed without it. Thank you for your time and attention, ladies and gentlemen. Nothing like technology to put a bump in the road, right? Ladies and gentlemen, as you heard, or you can guess from what this case isn't about who did it or how it was done. This case, the facts for you to decide are whether or not this homicide was committed in self-defense or whether it was committed with or without sufficient provocation. A second-degree murder is a homicide that was committed without having been sufficiently provoked, whereas a voluntary manslaughter is a homicide committed after having been sufficiently provoked. And the judge is going to give you the definitions to all of these things and what that law means.
See, this is a very poor explanation for a jury of these legal doctrines, murder and manslaughter. What she's really talking about is an unjustified killing would be the murder. Manslaughter becomes a mitigated form of murder if there was, I would say, adequate provocation. Perhaps the language in New Mexico is a little bit different, but it's the kind of murder that might occur after a fight, for example, or a spouse comes home and finds his other spouse in bed with a lover, or you're in hot blood. It's not a cold-blooded killing. And the law says, well, if you're in hot blood, you could not have formed the specific intent necessary for a murder conviction. We'll mitigate it from murder, life in prison, to manslaughter, 10 to 20 years in prison with the possibility of parole. But the way she's explaining these things to the jury, jurors don't know anything about this. And it's just a very, very, so she's describing murder as being an unlawful killing that's not manslaughter, and manslaughter being an unlawful killing that's not murder, but not really defining either of them independently. So they're just kind of floating there. Hey, we do have someone here. Hey,
Hello.
man, how you doing?
I'm doing pretty good. How about yourself?
Well, I'm doing good. I'm doing great. Living, all the important things are going well. Had internet trouble this morning, but we're finally up and running.
Oh, weird. I did too earlier today. But
Well.
good to see the judge coming back 30 minutes after another 15-minute break in this case.
Oh, I'm actually starting at the very beginning. Are you watching this
Oh.
live?
What? I was somewhere else, but you're more interesting.
Okay. Oh, sorry about that.
So I came here.
I don't know who else is covering it. I'm actually starting 2 days ago, so I'm starting back with
Okay.
opening statements.
Oh, good.
Because another lawyer on the internet who I don't know real well, Law Talk with Mike, was kind enough
Yes.
yesterday to invite me on to talk about this case. By the time I saw his invitation, it was too late. But that's what brought this case to my attention, and it made me yesterday watch these opening statements, and they were so damn bad, especially the states.
It gets worse. Spoiler alert.
All right, so that made me suspect that maybe this trial was going to be bad enough that it would be worth watching.
Oh, yeah. Definitely.
But I don't really know anything about the case except for the opening. So we're going through those now to kind of bring everybody up to speed. And then my plan was just to kind of quickly try to catch up on proceedings, skip over the breaks, go 1 1/4 time and so forth.
Yeah.
Folks, I'm not doing 1 1/4 time right now because when Law Talk with Mike did that yesterday, this opening sounded even worse. And I want to give, I don't want to, artificially make this prosecutor look worse than she is, because she's already pretty damn bad. So we're just going to do this at normal speed. When we get to witnesses and stuff, I'll probably speed it up a little bit to help us catch up.
Hey,
what time is it in
alert? Oh, it's like 2:00 in the morning.
Oh, good Lord. Well, thank you for coming on, dude.
I got a good hour. But yeah, just a spoiler alert, let you know how this is going. Just a minute ago, the prosecution's expert kept calling a Sig Sauer an AR-15.
Mm.
And then he went to AR-15 style platform.
Oh, yeah.
It's not good. It's not good.
Okay. All right. I'm going to start this back up. Comment anytime you like, dude. For those who don't know, by the way, everybody in my audience should. Jeff, you want to tell us about yourself?
Hi, I'm Legal Vices. I'm Jeff. I'm in Korea. Most of what I do is maritime law, about 30% corporate stuff. But hey, law talking guy. So I guess that qualifies me to be here. Kind of see things pretty much. I haven't had a single disagreement really that was of any significance. I don't have any drama. I'm just here, and I tend to be. I sort of just tend to be on the same wavelength as Andrew here. So, yeah, we're kind of good. Nothing special to grift other than my channel. I certainly don't have a book to sell. So, you know, that's me.
Well, that's you should, dude. You should have a maritime law book.
Oh, that would be the most fucking boring book ever. But
Well, you do all these YouTube videos about maritime events, right? Catastrophes
Yeah.
on the sea, that kind of thing. Oh,
Yeah.
you should do a book like that, man.
oh, that's an idea.
All right, so I'm going to start this up. Again, folks, just keep in mind that the burden of the state here is the legal defense is going to be self-defense, although we don't hear that for quite some time. It's all very ambiguous and vague what this whole trial is about based on this opening. It's bizarre to me. But ultimately, the legal defense is going to be self-defense, which the state will have to disprove beyond a reasonable doubt. So when we're hearing
Okay,
these...
that was my question. I understood that Ohio was the only state that the defense had to prove the argument, but
actually Ohio joined the majority. Ohio joined the majority of states a couple of years ago. So now in every state, the state has the burden to disprove self-defense beyond a reasonable doubt. But Ohio was the last holdout. Yeah,
because the prosecutor wasn't making it clear which side had the burden of proof. So okay,
well, and if I were the prosecutor, I would leave it vague. Because they need all the help they can get. If I were the defense, I believe the defense does mention that the burden's on the state to disprove self-defense, but she doesn't mention it with a sledgehammer, which is how I would have done it. But we'll get to that. So keep in mind, folks, that's always what we're looking for. We're looking for the evidence that would contribute to the state disproving self-defense beyond a reasonable doubt. That's all that matters here. Okay.
This case, ladies and gentlemen, is a case about reasonableness. And you, ladies and gentlemen, are the finders of the facts. The state has the burden of proof of showing that Dean Cummings, the defendant in this case, committed this homicide beyond a reasonable doubt. And the state will also show that the defendant, Mr. Cummings, also committed the crime of tampering with evidence. And that is because he washed his face, his hands, and changed his clothing after committing that homicide.
See, she's already misstating what the law and the burdens are here. I mean, of course, technically she has to prove he shot and killed this guy beyond a reasonable doubt, but that's already baked into the cake. It's a self-defense case. The guy's never denied that he shot and killed the victim. So that's not the point here of the trial. The point is not, can they prove that he shot and killed the victim? That's a given. The point of the trial is, did he do it with legal justification? Can we disprove that legal justification beyond a reasonable doubt? That's the point.
And also on this tampering with the evidence, he was sprayed in the face with mace. Are you just not going to wash your face while you wait for the police to show up and investigate?
It seems ridiculous to bring that charge is even in the trial. I mean, there's such an... there's an obvious explanation consistent with evidence. So how are you going to prove guilt beyond a reasonable doubt under those circumstances? It's just crazy. Okay.
And the state will also show that he committed the crime of concealing identity, because when law enforcement came and interacted with him, he didn't give his identity to them. The evidence is going to show, ladies and gentlemen, that on February...
This concealing identity charge too also strikes me as ridiculous. When the defense does their opening, they're going to tell the jury, hey, our client, he called 911 to report the shooting and identified himself on the 911 call. So when the cops show up, plenty of people would believe the appropriate thing to do when the cops show up is don't talk to the police without your lawyer present. So the fact that he's not talking to them then, that ought not be the basis for a criminal charge. If he's already called... He knows they're going to know who he is. He called them. Crazy.
Just walk our IT person here if you want.
That's okay. I'll just proceed. It's fine.
Okay.
Thank you.
Thank you.
So, ladies and gentlemen, the evidence is going to show that on February 29th of 2020, at Guillermo Arriola's ranch, which is way out past Cabazon Peak in the far remote area of Sandoval County, New Mexico, a ranch that is so remote that there is no cell phone service out there.
Somebody's got to buy that lady a hairbrush.
And a ranch that is
She's
so
unkempt.
remote that law enforcement had to use GPS coordinates on the search warrants. The evidence is going to show that the defendant killed Guillermo Arriola in his trailer. And the evidence will
As
show
as
that
trailers go, that's not the best one.
Mr. Arriola had been contemplating selling this ranch to Dean Cummings. He had his realtor, Christine Landers, draft up a real estate contract to sell this property to Mr. Cummings. Mr. Cummings had time to contemplate the purchase of this property and had not yet signed the real estate contract at the time of the homicide. On February 29th, 2020, Guillermo Arriola drove out to his ranch out in Sandoval County to meet with Mr. Cummings. Mr. Cummings shot and killed Mr. Arriola with a Sig Sauer AR-15 rifle. This rifle had a 30-round magazine and a scope on it. Mr. Arriola was 47 years old at the time of his death, and he was shot 2 times that day. He was shot once in the head and once in the chest. Law enforcement came and processed the scene, and they recovered 10 casings, spent casings, from that bedroom where he was shot. In Mr. Arriola's right hand was a can of mace, and that can of mace was facing Mr. Arriola, not outwards towards any attacker, but facing him and his body. You will be asked to determine whether the reasonableness of Mr. Cummings' actions when he committed this homicide. Were his actions reasonable when he shot and killed Mr. Arriola with an AR-15? Initially, when law enforcement went, Mr. Cummings refused to identify himself when the deputies made contact with him. And Mr. Cummings told the Sandoval County Sheriff's deputies that he killed Mr. Arriola in self-defense because he was sprayed with a neurological agent, presumably the mace. Mr. Cummings told deputies that he washed himself off to get rid of the neurological agent and that he changed his clothing.
What a monster.
Now let's talk about the evidence that's going to be
This is
presented
clearly
to
a
you
woman
over
who's
the
never
next
been
week, week
maced.
and a half. You're going to hear testimony from Christine Landers. Miss Landers is going to tell you that she drafted that real estate
I suspect she's
contract
had to wash her face once.
for Mr. Arriola to sell the land to Mr. Cummings.
Not from a neurological
She's
agent.
going to tell you that she met Mr. Cummings and
DNA
Mr.
evidence,
Arriola about a
perhaps.
month before the homicide to go over this real estate contract. She's going to tell you that Mr. Cummings had his 5th wheel parked on the ranch property. And you're also going to hear testimony from David McCullough. Mr. McCullough will tell you that on February 29th, 2020, which was a leap day, he was out riding his ATV out in the
It was a
middle of
leap
the
day.
desert.
That's
He had his
important.
on
Therefore,
feet,
he's
and he came
guilty.
upon Mr. Cummings. Mr. Cummings spoke with him and conversed with him for about an hour, and then Mr. Cummings asked him to come with him to witness the body. Mr. Cummings told Mr. McCullough that he killed a man in self-defense and he wanted him to witness the body. Mr. McCullough followed Mr. Cummings back to the ranch, and Mr. McCullough will tell you that he had medical training, so he believed he could render aid to anybody who was injured. So that's why he went back to the trailer, to the ranch, to see if he could render aid. Mr. McCullough will tell you that Mr. Arriola was past the point of aid being rendered.
I would think so.
The defendant, Dean Cummings, told Mr. McCullough that he had used the rifle in the back of his truck to kill Mr. Arriola. Mr. McCullough will tell you that he saw the rifle in the back of Mr. Cummings' truck, and then he proceeded to drive to an area where he could get cell phone service. Mr. Cummings stayed back at the ranch while Mr. McCullough drove out to get cell phone service. The area was so remote that it took him several times to get in touch with a 911 dispatch. And you'll hear those calls,
cameraman
and
here.
they continue to be dropped. He made about 4 calls to 911. You'll hear those calls. Mr. McCullough waited for law enforcement, and then he led them to the remote area where the ranch was located. After Mr. McCullough called law enforcement, then Mr. Cummings also called law enforcement. You're going to hear testimony from several Sandoval County Sheriff's deputies. You're going to hear testimony from Deputy Hayden Walker. He was one of the initial responding officers that responded on February 29th, 2020. You'll hear that he met Mr. McCullough, and Mr. McCullough led him into the ranch. And you'll hear that Mr. Cummings told him he killed Mr. Arriola in self-defense because he was sprayed with a neurological agent. Deputy Walker placed Mr. Cummings in the back of his patrol car while they
So what we're looking for here, folks, is the testimony of these officers is only helpful to the state if it contributes to disproving self-defense, right? So if this defendant made statements to the police that he just killed him out of anger, or there was some other motive other than self-defense, well, that would be useful information to the state, but she would be keying the jury to that evidence now, right? You will hear from the officers things that are helpful to us in the prosecution. What she's keying the jury to is you will hear from these officers that from the very beginning, the defendant claimed it was self-defense.
Yeah,
I mean, that's
exactly.
not helpful to the prosecution.
The
So
very
that's
first
again,
person
that's
he
what we're
comes
listening for here. We're listening for her to say, hey, and these cops are going to tell you things that would suggest this was not self-defense.
Yeah,
We'll
the
see if we
very
hear
first
that.
person he meets says it was self-defense. He calls the police. He escorts the police he tells the guy, here's the weapon that I used. This is all indicative of someone who believes it was a self-defense situation.
I shot him in self-defense, and this is the reason, right? He sprayed me with whatever, a neurological agent. I've never heard Mace or OC called a neurological agent before, but whatever, it's fine. So I'm still waiting to hear something from the state's opening that would be inconsistent with self-defense or suggest in any corroborated sense some other motive than self-defense for this killing.
They conducted the investigation, and Mr. Cummings tells the deputies that he placed the rifle on the porch and that he had the magazine. He took the magazine out, and they were both laying on the porch for them. Mr.
Which
Cummings
is, again,
tells
is
Deputy Walker that
clearly
he
in a
washed his
self-defense
face
thing.
off and his
He
hands
didn't
and
hide the
changed
weapon.
his clothing.
He
You'll also
he
hear
unloaded it and
testimony
put it on the
from
damn
Deputy
porch.
Jonathan Crispin, and he also responded to the scene with Deputy Walker. They secured the scene. They made contact with Mr. McCullough. He collected some witness statements while he was there on scene, and then they secured the perimeter. They went into the trailer to make sure that there was nobody else that was injured, and then they held the scene until the remainder of law enforcement can come. You're going to hear testimony from Sergeant Thomas Griffin, another officer with the Sandoval County Sheriff's Office. And he was the on-scene sergeant out there at the ranch. He arrived with Deputy Gutierrez, and he was present when Mr. Cummings was evaluated by emergency medical services. Mr. Cummings told Sergeant Griffin that the clothing he was wearing at the time of the homicide was in the back of his truck. So
Hiding nothing.
Griffin collects those clothing, and he's going to tell you that the clothing was indeed wet, as if Mr. Cummings had washed himself
So where's
off.
the concealing of evidence?
Sergeant Griffin also assisted with the towing of the vehicles from that ranch. They towed the vehicle of Guillermo Arriola. They towed the vehicle of Mr. Cummings, his truck, as well as the fifth wheel. Sergeant Griffin also collected the evidence. So in this homicide, the Sandoval County Sheriff's Office called the New Mexico State Police, and they come out and they assist with the crime scene. So he collected the evidence from the New Mexico State Police that was collected from the scene that day, and he's the one who tags it into evidence. You'll also hear testimony from Lieutenant Frank Tomlinson, our case agent here. He was assigned this investigation, and he's the one who was in charge of making sure everything got done. Lieutenant Tomlinson assists with the investigation while working out of the Sandoval County Sheriff's Office, which is right here in the courthouse, while Thomas Griffin was the one at the ranch.
Why does
there was no cell phone service? They had to play telephone tag, if you will, to get sure the warrant's done. He wrote several warrants, and he interviewed several witnesses, and you're going to hear about all of that part of the investigation.
She's so
He also
dispassionate,
transported
uninterested
the
in this
evidence.
case.
As I stated, the New Mexico
Where's the cry for justice here, right? Where's the tremendous injustice that the people of New Mexico demand that justice be served in this case? She's describing how two cops had to play phone tag to get their warrants done up. I mean, holy cow. It's like watching a really bad episode of The Office with no jokes in it.
Mexico State Police assisted with this investigation by processing the scene. And you're going to hear testimony from Carlos Herrera, the New Mexico State Police case agent. He was the criminalistics agent. So he was the one in charge of making sure all of the evidence is documented and collected.
Criminalistics.
New Mexico State Police arrived at the ranch after the warrants were granted so that they collect and document everything. He'll tell you about the processing of the scene. One person is assigned to take photographs. One person is assigned to scan the scene. And he was assigned with documenting the casings, the trajectory.
I guess what she's doing here is I get the sense that they know they have nothing really. So they're trying to create an aura of guilt by just listing like every cop who was involved in this case to suggest, well, this cop and then another cop and yet another cop. And if all these police are involved, surely a crime must have occurred.
Where the blood was and things like that. Agent Herrera is going to tell you that he collected 10 spent casings from the scene that day. He collected the mace and he collected the AR-15 rifle. Agent Bogue, also the New Mexico State Police in the criminalistics portion, she was assigned with running what's called a Leica scanner, and it's a scanner that scans the whole room, and she uses the information from that scan to create a diagram. And she'll testify about the diagram that she created that documents where the body is, where the casings were, and the outline of the house.
None of these are issues in contention. So.
Yeah.
And you're finally going to hear from Jennifer Otto. She is the New Mexico Department of Public Safety DNA analyst. She's going to testify about the analysis of the evidence that was sent to her for review and whose DNA was on what and what kind of DNA it was. And finally, you'll hear from Dr. Heather Gerald of the Office of Medical Investigator.
That's the
She's
second
chief
finally
medical
you'll hear from.
investigator there at UNM. And she conducted the autopsy of Guillermo Arriola. She's going to testify that Mr. Arriola had 2 gunshot wounds to his body. The first gunshot wound was to the head, and it entered at the right temple with a trajectory of right to left and downward. Dr. Gerald will testify that there was a second gunshot wound of the chest, and it entered at the supraclavicle region of the chest and exited the left side of the chest.
So this is actually a real problem for the state, because this fight occurred in a room in that trailer. You saw the picture of the trailer. This is not going to be a large room, a small space, 2 men, 10 shots, 10 casings from that rifle were found. 10 shots were fired, and the victim was hit twice. Folks, if you're just aiming at someone to shoot and kill them, you don't fire a rifle 10 times at 100 yards and miss. Especially with a scope on the rifle. From a couple of feet away, you somehow miss 8 out of 10 times. The only way I could imagine that happening is if the 2 men were fighting over the weapon, which of course is part of the defense narrative, that the defendant got sprayed with the mace and was defending himself with the rifle. And in the struggle over the rifle, that's how the additional shots got fired. Oops.
It's almost as if you know what you're talking about, unlike the state.
That's...
As I stated, ladies and gentlemen, this is a case of reasonableness. A second-degree murder is a homicide committed without having been provoked, and a voluntary manslaughter is a homicide committed after having been sufficiently provoked. And the judge is going to give you the definition of what sufficient provocation is. Again, this case isn't about who did it or how it was done. The facts for you, ladies and gentlemen, are to decide whether this homicide was committed in self-defense or whether it was committed with or without sufficient provocation. This is a case of reasonableness, and you are the finders of fact. You are going to determine whether or not Mr. Cummings' actions were reasonable.
That's another weird thing. So I would not be talking about manslaughter here in the opening. Manslaughter is just a mitigated form of murder here. We're talking about voluntary manslaughter. So you go for murder, and then in the closing you might mention, but hey, if you don't buy the murder, it could still be an unlawful killing if there was adequate provocation, which you might think the fight was. And so if you're not going to give us murder, and you make this argument depending on how the trial goes, right? If you think like murder's not a lock, you mentioned the manslaughter to see if it gets captured. You ask the judge to instruct on it as a lesser included. But here you're just muddying the waters with all this stuff. You want to argue here the worst case, your strongest argument that this was simply an unlawful killing. It was not self-defense. That's the only thing I'd want the jury thinking about here.
That day when he shot and killed Mr. Arriola with an AR-15 rifle when he only had mace. And I surmise to you that the evidence will show that there was no struggle in the bedroom, that little bedroom on February 29th, 2020, and the evidence will show that this was not a justified homicide. Mr. Arriola cannot speak about what happened in that little room on that day, but the evidence will show what happened on that day. And at the end of the case, the state, we're going to ask you to.
So what was the
find-
motive? What was the motive for the killing? I mean, motive's not a required element of the crime, but it's part of the narrative. So we have one narrative that says, I shot him because he pepper sprayed me. I was defending myself. What's the counter narrative? What's the reason here that it would make sense that you want to discard that self-defense argument? I'm not hearing it.
Mr. Cummings, guilty of second-degree murder or the lesser included offense of voluntary manslaughter for the killing of Guillermo Arriola. And we will ask you to find the defendant guilty of tampering with evidence for him washing his hands, his face, and changing his clothes after the homicide. And we will ask you to find him guilty of concealing his identity when he refused to identify himself to the law enforcement officers on that day.
Now, I will say, folks,
Thank you for your time.
if the cops show up and you literally say nothing at all, you do open yourself up for this, because until you've either asserted your rights or they've Mirandized you or should have Mirandized you, they can talk about the fact that you were silent. If they show up on the scene and they say, hey, what happened? And you're just not saying anything, they can say, yeah, he just wouldn't say anything to us. They can't talk about that after you've either asserted your rights or you've been Mirandized or should have been Mirandized. After that point, your silence cannot be mentioned, cannot be used against you. But prior to that point, it can be. So if he had only said, when the cops immediately showed up, they said, what happened? He said, I'm asserting my right to silence. I'm asserting my right to counsel. None of this could be mentioned in court. But that when you stick to absolute silence, it can be. That was it. That was the opening.
That is an absolute weak opening. Again, you say there's no motive, there's no narrative. It's just
at this point, the jury's only heard one side of the story, right? When you've only heard one side of the story, you should be utterly convinced that this guy is guilty. Utterly convinced. And then now the defense gets to go up and they get to kind of chop away at how convinced you are. But I don't know about anybody in the audience, but I am utterly unconvinced by this opening that this guy's guilty of anything or even belongs in a criminal trial. So here comes the defense. The defense is not. The defense is not as bad. I'd say it's fine. It's not great though. It's not great.
And see, this is also my second time going through this, and I'm more confused than I was the first time I went through.
Interestingly enough, every lawyer in the room is a woman, but it's fine.
Counsel.
Hey,
Ladies and gentlemen of the jury.
I hear Steve Gosney is in the chat. Let me pull up.
Hey, Steve.
I'll send him the. How the hell do I do this again? Okay. Hold on, Steve. I'll email you the link if you'd like to join us.
And I do like the defense lawyer. I really do like her. She's good. She's aggressive. She sticks to it.
So, Steve Gosney, if you're in the chat, I'm sending the link to your presidential email. You'll know the one I mean. Oh, there he is. He's just sent me, so I'll link him back. Even better. And I replied to your email, Steve. I just saw that. So that'll be great if Steve can join us as well.
Yeah.
So, in fact, let me take a moment just in case he can join right away. Let me take a look and see if there's any super chats. I'll cover some of that. Let's see. Before we start with the, how YouTube does this is really awful. Come on, super chats. Okay. Michael says, and thank you, five British pounds. That's like 800 American dollars these days, I think. Oh, no, the pound is down too, probably, right? Branka, YouTube unsubbed me from you. I'm so mad. Yeah, so YouTube does this kind of thing, folks. And I don't YouTube every day. I'm not like a hardcore law tuber kind of person. I just do it when the motion moves me. And if you're not on every day, then YouTube, people are not seeing videos that you're not posting up, and YouTube starts unsubscribing people. That's just how they do things. I'm not sure it's personal, but we're on Rumble. We're now live streaming on Twitter, or if you're a law self-defense member, we're always there. Michael Carney, if this is the prosecution opening and I was a member of the jury, I'm already swaying for the defendant. Yeah, right. You should be utterly convinced at this point the defendant's guilty, and nothing like that. Farmhand Tom, $10. Thank you very much, Farmhand. Appreciate the retweet of my Home Alone video on Twitter and allowing me to grift off your success. Branca videos make the best videos. I have a few more on YouTube. Yeah, so thank you, Farmhand Tom. I wish there was a way for me to direct that to your link. He did a very, very funny video featuring me, yours truly. I thought it was great. But I don't know how to describe it other than to tell you to look for Farmhand Tom on Twitter and find it there. And here is Attorney Gosney. Hey, Steve, how you doing, man?
Hey, Steve.
Hey, how are you doing? I just sent your book, Legal Vices, by the way.
Oh, did you? Oh, thanks. I'm just waiting for it to come.
Yeah,
great.
it's Korea, man. It's a long way away.
It's about 10 days to get here.
Yeah, I was just. I'm actually at home. My back is just killing me. And then I get this email from Branca, who's like, I didn't know if it was an invite or if it was like an announcement of the trial. So I was like, I don't know. What is it? And then here I am. But
well, you're always welcome anytime, Steve. Yeah, that first email you got would have just been our general email out to our community to let them know we were doing this on an impromptu basis. But are you familiar with this case?
I'm not, but when I just tuned in because you sent me that link and I started tuning in, and you had said something about pre-arrest silence, pre-Miranda arrest silence, and it's interesting because I'm teaching on of course, your law school, you know this, but that actually is in Florida there is a different rule. I'll post it in the chat that basically pre-arrest silence in Florida is not allowed based on Florida constitutional provisions. So let me send you that link here. It was something I taught way back in the, I think in the 4th module of your class.
Yeah. So, and that makes sense. It is definitely allowed under federal law because the Supreme Court has a decision. I forget the name of the case, but it's only 5 or 7 years old or something. But of course, the states can, their constitutions can provide protections above and beyond what the federal constitution provides within state court for sure.
Right. Here's the case is State v. Hoggins, Hoggins, from Florida Supreme Court, 1998, which is 718 Southern 2nd, 761. And that is the prosecutor may not comment upon or attempt to impeach a defendant with his or her post-arrest, pre-Miranda, or post-Miranda silence. So this is an expansion of that rule. Because I know that, because whenever I hear that, because I know that's a minority rule.
But is post-arrest one of the conditions there?
Well, the way it's
what about pre-arrest?
Pre-arrest, right?
So the cop, the responding officer screeches up in his patrol car, jumps out, says, "What happened here?"
Right,
and the defendant doesn't say anything.
That's a good question. I'd have to look at that in depth. When I'm practicing, I do trial backup and appeals and things. And I know that this is something that I'm very hyper aware of, and the courts are very afraid of in Florida. They basically, if somebody is silent or imposes them, does not say something, and then later invokes a Miranda, the courts are very reluctant to let prosecutors comment on that. So I think that the rule, based on experience and my reflections on judges, is that they cannot comment even on any kind of silence as an admission of guilt. Now that may, I don't want to just make it a declarative statement without having researched it specifically, but my understanding of just on practice, Florida is a little different on this, but I don't know, just sort of a little tip. But I don't know if that.
Well, I certainly think that should be the rule. I mean, if we think it's important
Yeah.
enough to protect the right to silence, then it seems to me it shouldn't hinge on some mere technicality. You have a fundamental right to silence and not incriminate yourself, or you don't. And to base it the initiation or the catalyst or the triggering of that right on some legal technicality that normal people would not be expected to know doesn't strike me as good public policy.
Right. And the fact is that some people don't realize that your rights to counsel and your right to remain silent, you must affirmatively invoke. And so there's cases where people sit there and say nothing for hours.
Right.
And that is not an invocation of their right to remain silent. In
fact, it's an invitation to the police.
Right.
Because as long as you haven't asserted your rights, it's up to them whether they want to Mirandize you or not.
Exactly.
And I think you can really see that if you watch some of the interrogations in the Alec Baldwin shooting, where especially the armorer, she's saying, well, do you think I should have a lawyer? I think I should have a lawyer. I think I might want a lawyer. And like, well, we'll just ask you some questions. And later, if you think you need a lawyer, you can tell us. When she clearly should have had one from square one, but she didn't affirmatively say, I'm not talking to you. I want my lawyer.
Yeah, right. Affirmatively and unambiguously. Things like, I don't know. Do you think I need a lawyer? Maybe I need a lawyer. Should I talk? None of that counts.
Well, the pain. I've got so many painful cases in the past where this sort of thing has occurred, because what the ideal world, the way it should work, is if somebody asks a question of the police and it's ambiguous whether it's an invocation, the police officer is supposed to stop and answer the question directly. But that's not what happens. What happens, somebody says, well, I think why would I need a lawyer, right? The cops just ignore them and just plunge ahead. And then I've had multiple cases where that's subject to suppression and they let it in. It's not suppressed. And so basically this whole thing is meaningless. The only thing you can do to protect your right to remain silent is to invoke it and to remain silent. Anything else doesn't work.
Oh yeah, that's another thing. So if you assert your right to silence, but then you start talking, you've opened the door up again, folks. So if you're going to, and cops are clever about this. I've seen cases, I talk about it in my classes, where you'll invoke your right to silence. You're in that interview room and the cops will be like, all right, well, we can't ask them any more questions, but we can talk amongst ourselves about the case. And two cops will start talking to each other at the far end of the table. What do you think happened here? That guy's obviously a racist killer. And they're just trying to trigger you to no, that's not what happened at all. And then they can start talking to you about the case again.
Well, and we have this. I'm sorry. We have this intersection of legal theory and idealism, and we have that rubs up against the practicalities of what happens, because there's case law on that too, where something that is designed to invoke a response. So what they do is there's a case out of, I forget, it's a U.S. Supreme Court case where somebody's in the back of the car and the cops are talking. Yeah, so they're talking amongst themselves in the front seat. Well, it'd be terrible if that gun was found by some kid. Yeah, they could. And then the guy's like, wait a second, and he jumps up and interjects after he's invoked his right. Whether that's considered a
waiver.
Well, it's considered the case law is that is a technique to invoke a recriminating response. Therefore, Miranda should be invoked, right? But the practicalities of it are that stuff goes in all the time, and it's Anyway, I'm just ranting today. I'm in pain.
Yeah.
My
By the way, for folks, Steve, why don't you take a moment to introduce yourself, talk about your book, and maybe talk about the class you're teaching?
Right. Well, most fun things first. Andrew recruited me to teach his law of self-defense criminal law class. Now that's part of a larger class, and he can talk about the larger issues, but I'm having a blast. The students are great. It's like I'm really pouring my heart into it, and we're almost done. I think we've only got 3 or 4 more modules. And that is, you can sign up there and get a criminal law class. It's like real law school stuff, plus, because we don't have political correctness in there. We're talking about the realities of the law, not just the theory. And so that's what we're doing. And of course, my book. And that's another thing. Andrew, man, you got so much credit. Here's the, look at this baby. It's got a foreword.
Nice.
By who? Who's this foreword by?
I know that guy.
Andrew Branca wrote my foreword. And it is basically all of my law review articles plus a few other things. And Andrew encouraged me because I'm always going on these shows and he's like, you should have something to sell. And I'm like, well, I don't have anything to sell. And she's like, what about all those articles you write? What about all this stuff? And I'm like, that's a good idea.
I got that lecture a few minutes before you came on.
You got to grift, man. You got to grift.
But
always be grifting.
Yes. And so between you and Nick, between Andrew Branca and Nick Rekieta, this has been a tremendous success. And I'm really humbled by everybody buying it.
And where can people find that book?
Oh, it's at, see the little description right here? Crimelaw.net. Crimelaw.net. You go there and you can buy a book or donate. Just want to donate, you can do that.
So for this criminal law class, for folks who don't know, this is a series of law school level courses we put together at Law Self-Defense. And Steve, of course, is teaching our criminal law class, maybe our criminal procedure class. We got to talk about that. I'd love to have Steve teach that.
That's a long
but we're also we're also having courses on constitutional law, evidence. Jeff just bowed out. I was about to suggest to him that maybe he'd want to teach a class on maritime law, which is his area.
I'm still here. I was just
okay.
Trying to make myself look a little less green, and it's not working.
No, it's okay. You're in Korea. Everything's supposed to look a little green. Well, I guess Godzilla's Japan, right? But it's close from America. They're all right next to each other. Hey, I was going to say, Jeff, if you ever want to teach a maritime law course for the law self-defense law school courses, let me know. I'd be happy to talk with you about that. But if anyone would like to learn these, so these are law school level courses. There's no formal accreditation. This is for your information. There is a certificate you'll get if you pass the exam at the end of the course. So you can hang that up on your wall if you want. But this is for your own information. If you've ever wondered what it would be like to go to law school, take law school level courses without the political correctness that plagues law schools today, you can take a look at that at lawofselfdefense.com/courses and learn more about all that. And
something cool about it too is that it's a lot less expensive. You don't need to quit your job. You don't need to take the LSAT. You don't need to devote 3.5 years of your life. You don't have to pass. It's basically the content that you're going to get at these criminal law classes without all that burden. I mean, a lot of our students are very educated and are interested in the law and want an in-depth understanding of the law. But where do you get that out there without all the political correctness stuff, right?
And I would imagine it would help you decide if a career in law is something you want to actively pursue or go, okay, never mind. This isn't something I want to do.
One of my
I will say this, of course, most of us who go to law school, we get criminal law, we take the course, we take the final exam, we get our grade. But that's our first exposure to criminal law is in that course. You want to kick the ass out of criminal law in law school? Take Steve's course first.
Actually,
and you will crush that thing.
I do have a student or a kid in my class who's really a nice guy, and he's wanting to go to law school and is taking the LSAT. So I told him, I said, when he goes in there, he's going to be dangerous.
All right. And of course, Steve is a public defender down in Florida, mostly appellate work, also supports a trial division, previously did the trial work himself, and former prosecutor as well. So he's been on both sides of the table. So very, very experienced lawyer. We're very lucky to have him here. So Steve, have you seen these openings at all?
I watched a little bit. Boy, the state's opening seems awful boring.
Awful. You just can put period right there after awful. Yeah, well, it was terrible.
It's kind of just paint by numbers, no passion, no drama, and kind of just mailing it in. I mean, I don't really know anything about this case, but when I heard the opening, I'm like, she doesn't seem very committed to her prosecution.
Yeah, it almost feels like she doesn't want to be there, right? There was like a job she's been assigned. She has to do it, whether she likes it or not, or her boss will be pissed. Like her boss feels out for political reasons. We got to try this case, and nobody really wants to do it, but she's got to go through the motions. But anyway, I may play that opening again later on. It depends. But here we have the defense opening just about to start right now. So she literally just said, ladies and gentlemen of the jury, and let's hop back into this.
Good afternoon. This case is not about who did it. Ms. Walker is correct because Guillermo Arriola was shot and killed by Dean Cummings. There's no dispute in that.
So the question before the court, before the jury, isn't who killed him, but why. And the evidence is going to explain to you why that happened. The facts that led up to the death of Mr. Arriola. Mr. Cummings told the police when he called 911 that day, he called them and he told them, "My name is Dean Cummings. I just shot and killed a man in self-defense." So he told the police that right away. And he told David McCullough that right away. Because after this shooting happened, Mr. Cummings reacted.
So, Steve, in case you missed it, what they've charged him with is murder, voluntary manslaughter based on adequate provocation, but also tampering with evidence because he washed his clothes. They had mace on them, so he washed himself. And then concealing his identity, which the defense is addressing now because he identified himself to police in the immediate aftermath of the event. It's like they're squirreling for things to charge this guy with. I guess when the cops showed up, he didn't want to say anything, so they're using that as the basis. But, you know, I was telling Jeff earlier, when there's an explanation for the conduct that's consistent with innocence, it's a hard sell to get to guilt beyond a reasonable doubt.
But it might even be subject to dismissal at JOA, depending on your circumstantial evidence rule in your state. Because
yeah, I'm really surprised that this charge is in court, to tell you the truth, that it got this far. But
why, if you're charging murder, why would you go for some stupid charge like that? I mean, that's like a tack on.
Well, and then even during the opening statements, as Andrew was saying, why is she mentioning a lesser included as an option in her opening statement?
I would never do that as a prosecutor at opening. That is a sign of weakness for sure. But I don't know. I mean, I'm just, this is new to me, so I'm reacting to it as it goes. This is kind of fun because I know nothing about the case. I'm like a juror, you know?
Right.
Okay. He was in the middle of nowhere, and you're going to hear evidence, and Ms. Walker showed you some overhead photos of where this occurred, the ranch where this occurred. It was out in the middle of nowhere. It's a remote area. There is no cell phone service out there, not for miles. It's a place that is so remote. There are no neighbors. There's no other buildings. You have to drive for miles before you reach anyone or anything. And that's where Mr. Cummings found himself on February 29th, 2020. Because as you heard from Ms. Walker, and you will hear in the evidence, Mr. Cummings was looking to purchase some land. He grew up in New Mexico, Los Alamos to be specific. He grew up here. He spent his childhood in New Mexico before leaving for Colorado and then Alaska. And then in 2019, he returned to New Mexico. Mr. Cummings is an outdoorsman. He's a man who loves to be out in the wilderness, to be out in remote areas, to live off the land. And so he was looking for a piece of land back home here in New Mexico where he could build a home, start a new life. And Mr. Arriola owned property that was what he was looking for. This property out there, out near San Luis, San Ysidro area, near Cabazon Peak, remote, beautiful land. So Mr. Cummings and Mr. Arriola were planning this real estate transaction. And Mr. Cummings was excited about his future. And you're going to hear evidence about this real estate contract that they were negotiating. And Mr. Cummings had every intention of buying that land. And in the meantime, he was permitted to stay out there. He put his RV out there, and he was allowed to stay in this little trailer. Mr. Arriola encouraged him to stay out there, encouraged him to get to know the land, the property, the trailer. There were some horses out there. Mr. Cummings was helping take care of the horses, feeding them. And that's what led up to this incident on February 29th. Mr. Cummings was staying there, as he had been told and encouraged to do, when Mr. Arriola showed up. He showed up unexpectedly. Mr. Cummings and Mr. Arriola started talking about this real estate contract, and they started arguing. It was a verbal argument in the kitchen of this small trailer. And while they were arguing, all of a sudden, Mr. Arriola attacked Mr. Cummings. Without any warning, Mr. Cummings was all of a sudden fighting for his life. Mr. Arriola and Mr. Cummings were in this physical altercation. It led down this very short hallway to a small bedroom. And it was during this physical altercation that Mr. Cummings realized that Mr. Arriola had something in his right hand. You're going to hear testimony Mr. Arriola was right-handed. You're going to hear testimony that Mr. Arriola routinely carried a canister of mace with him. Mr. Cummings didn't know exactly what it was, but all he knew was that he was being struck with this thing in Mr. Arriola's hand over and over again. During this altercation, Mr. Cummings was able to grab his rifle that he had had sitting there. He had recently purchased a scope and was putting the scope onto the rifle, which is why it was sitting there. He grabbed the rifle, and he and Mr. Arriola started fighting over this rifle. And it was during this struggle, Mr. Cummings has one hand on this rifle. He has his other hand blocking, his left hand blocking Mr. Arriola, who's repeatedly striking him. During this struggle between these two men, all of a sudden, Mr. Cummings realized that his eyes were starting to burn, his lungs were starting to burn. Something had been sprayed. He didn't know what this stuff was. But at the same time, he starts to feel this burning sensation. He feels Mr. Arriola pulling on the rifle. They're fighting over control over this gun. Whoever wins is going to live. Whoever loses was going to die.
That's a good line.
And during the struggle over this gun, the cap on the scope of the rifle comes off. And that's important. And you're going to see the evidence. You're going to see photos of that cap. That cap had been taped onto the scope with electrical tape. Mr. Cummings had taped the cap on with electrical tape, so it was on there good. And you'll see photos, and you're going to see the evidence that shows that the cap from that scope ended up underneath Mr. Arriola's body because it came off during a physical fight for control of that gun.
Much better opening.
During this struggle for the gun, shots went off. You're going to see photos of bullet holes in the trailer. That is important because those bullet holes, or we call them impact sites, a lot of times that's what we refer to them as, those impact sites tell the story of what really happened in that trailer. And you're going to hear from an expert who's going to explain that to you. But some of those bullets sprayed down the hallway and out of the trailer. Three bullets went out the trailer on the other side of the trailer from where the small bedroom was. And that shows how this fight was progressing and continuing as these men are fighting each other for control of this gun. They end up in this small bedroom, and Mr. Cummings ends up basically trapped in that room. Mr. Arriola's.
So, folks, can you guys still hear me?
Yep.
Okay, sorry. Someone complained about the audio before. Folks, I just want to point out what we're hearing here is a story, right? What we're hearing here is a narrative of what happened. We never got anything like that from the state. This makes what the defense is presenting here much more emotionally compelling than anything we heard from the state, where the entire burden's on the state to disprove self-defense beyond a reasonable doubt.
And she's also really, this is right the way you do it here with the defense. She's also pointing to evidence that she anticipates the jury will hear, that she wants the jury to pay a special attention to. And namely, that is the struggle for the gun and the fact that it's a life and death. And now this bit of evidence about the cap, which may be overlooked, but she's emphasizing that in opening, saying, watch for these things. These things are important.
Right. And when the state mention specific bits of evidence, and they did. They were like, well, the police, you'll hear the police testify when they arrived, they found the rifle here, or they found this there, but none of it was evidence that was inconsistent with self-defense. It didn't actually advance a narrative of the prosecution. It was just kind of irrelevant bits of information that no one's going to bother remembering, but they'll remember this if she can, of course, if she can back up what she's claiming here in the actual testimony.
In front of him, the only way for him to escape is through Mr. Arriola. And you're going to see other impact sites on the floor in that bedroom, and those impact sites are really important. And you're going to have an expert who's going to explain to you why those impact sites are so important. And the reason that those impact sites are so critical is because what they're going to show you is that at some point during that struggle, the gun that ultimately killed Mr. Arriola, that firearm was upside down, almost on the ground when it went off. Again, the evidence will show that that gun was upside down, literally almost on the ground when 2 shots were fired. That shows you that there was a physical fight, a struggle occurring over that firearm. You're going to see that firearm. It's going to be in this courtroom. You're going to have a chance to look at it. And it's important that you take a close look at that firearm. Technology.
There's a light. There you go. It'll get going.
What's the jurisdiction here?
New Mexico. Just I forget the name of the county, but it's the county just west of Los Alamos.
Is this a stand your ground state?
Yes.
Do you know if there was a stand your ground hearing prior to this?
Oh, I don't know if they have. I don't know if they have self-defense immunity. There's no legal duty to retreat for self-defense in New Mexico. I don't know if they have an immunity provision.
It sounds to me like that might be an issue here if they did.
This is a photo of that gun that was taken by an investigator with the Office of the Medical Investigator. What you're looking at there, this is the AR-15 that was involved in this struggle. What you see there is some kind of residue or spatter that dried on that firearm that is consistent with Mr. Cummings' story that something was sprayed at him that day during that struggle while they're fighting over that gun. You're going to be able to look at that firearm when it's in this courtroom. So those are the 2 important things about that firearm that the evidence is going to show. 1, this residue or spatter that dried on the gun.
Just as an aside, I'm looking at the judge here. The judge looks like he's looking at the defense attorney here. When the state was talking, the judge looked like he was looking at papers on his desk.
It's interesting, all the masking too.
Still, right? Amazing. Yeah. But it is, New Mexico is a pretty liberal state.
That the muzzle created those marks on the floor, showing that that gun was literally on the floor or almost on the floor when it went off at least twice. You're going to hear evidence from Dr. Gerald with the Office of the Medical Investigator, as Ms. Walker indicated. Officer Gerald conducted the autopsy of Mr. Arriola. And there's a couple of important details that she's going to tell you about what that autopsy revealed. First, the trajectory of those bullets. Mr. Arriola was shot and killed by 2 bullets. Both of those bullets entered in a right to left trajectory. One through his temple and downward, and ended up in his chest. The other one entered on the right side of his chest and went through and exited on the left side. So those 2 bullets, both right to left in a downward trajectory. Dr. Gerald will be testifying to that, and you'll probably see some photographs that also help to demonstrate some of that. The other thing that she's going to tell you is that Mr. Arriola was intoxicated at the time of this altercation. He was intoxicated on alcohol. He had cocaine in his system, and he had marijuana in his system. And Dr. Gerald will explain to you the significance of that combination of alcohol and cocaine when it's in someone's system at the same time. You're going to see photographs that detail the scene. And again, I explained, you're going to see photographs of those impact sites that tell you the story of what happened in that trailer. The impact sites that go down the hall out of the trailer, the other impact sites next to Mr. Arriola's body that show that the gun was on the floor when it went off. And you're going to also hear testimony from an expert by the name of Aaron Brudenell. Mr. Brudenell is a forensic scientist who has spent decades working with the Arizona Department of Public Safety. He is a forensic.
By the way, folks, you hear all these experts she's talking about, all of that costs money for the defense. The defense has to go have money to pay for all these people to show up. That's one of the reasons these cases get so expensive so quickly.
Scientist, his full-time job.
Sorry, Steve, go ahead.
No, I was going to say, even a cheap expert for a state can be $10,000 to start. So a cheap firearms expert, somebody who's just like for the public defender's office, not a private attorney, it's $10,000. You just got to bank that at least, and it goes up from there. I mean, we've had $25,000 experts, and that's a state contract. That's one that are not, where we retain him, which we get better deals because we're state and we got limited by statutes and governments and budgets. So when you're talking private defense attorneys hiring the best experts, it can get very expensive very quick.
Yeah. And this whole, the victim was, had alcohol and cocaine in the system. I presume what their expert's going to testify is that this prompts violent behavior, which would explain the claimed attack by the victim on the, and it's not hard to imagine how that could happen, right? People are doing a real estate transaction. Maybe somebody gets emotionally invested in what they think they're going to be offered for their property. And the guy comes back a week later and says, well, I've walked around. It's not that great. I'll give you half as much. And now the property owner feels like he's getting robbed on the price, right? Being extorted on the price, gets mad, fight ensues. It's just not that hard to envision.
Now, can I ask another question? Maybe I'm new to this, right?
Sure.
Is this Cummings's homes or Arriola's homes?
So this was Arriola's property. On the property was a trailer. The trailer where this fight occurred. And Cummings was a prospective buyer of the property. He was being allowed to stay in the trailer so he could familiarize himself with the greater property. It was a very sizable piece of property out in New Mexico. So, did he own the trailer? Probably not. Was he using it as his dwelling? Yes.
So he is a tenant in that he has rights to possession of the properties. Okay.
Right.
And the seller would be this Arriola guy.
Yeah.
Okay.
Yes. Correct. So, to my mind, that's a classic. That makes it a castle doctrine type of situation as well. Right. Even if New Mexico otherwise had a duty to retreat, you're letting him live there. That becomes his dwelling while he's permitted to live there.
Right.
Is working for the prosecution in Arizona. He analyzes crime scenes, especially when there are firearms involved, and he reconstructs shootings. He took the evidence that was gathered by the New Mexico State Police and the Sandoval County Sheriff's Department. He took that evidence and he examined it, and he reconstructed what happened in that trailer that day. Mr. Brudenell is going to testify that he closely examined those impact sites that I've just briefly described for you. And he's going to tell you that the physical evidence that he saw is consistent with some kind of physical struggle occurring over that firearm. So at the end of this trial,
that's the defense saying that the prosecution witness is going to prove their case.
Mr. Cummings did shoot and kill Mr. Arriola. And the evidence is going to show that he acted in self-defense. The evidence is also going to show that he did not conceal his identity at any point in time. In fact, the evidence will show that he placed a 911 call to the police, identifying himself and explaining what had just happened in that trailer.
Oops.
This state has also charged Mr. Cummings with tampering with evidence, and I'm just going to briefly address what the evidence is in that. The state is going to ask you to convict him of tampering with evidence because he washed his face, washed his hands, and removed his clothing after this incident occurred. However, what did Mr. Cummings do with that evidence? What did he do with his clothing? Well, the prosecution's own witnesses are going to testify that Mr. Cummings put his clothes on the back of his pickup truck. And the prosecution's own witnesses are going to tell you that when the police arrived on scene, he told them where his clothing was.
Wow.
He asked them to collect his clothing and
Why
test it
is this a trial?
for whatever he had just been sprayed with. So
We'll
the evidence
see.
is going to show that Mr. Cummings acted in self-defense, that he did not tamper with evidence, and that he did not conceal his identity. That is what this evidence will show.
And that's the state's witnesses are going to testify to that.
This-
So there's no, I mean, the jury is the ultimate finder of fact. No question about that. But there are situations where the facts are not effectively in dispute, or there's no reasonable interpretation of the facts that's counter to the interests of the defendant. And that should not be a legal issue being argued in a trial.
Yeah,
The judge should clear those things out.
if this is the facts of this case, is the defense, if this is what the facts come out on, this is a very strong defense case.
I've seen the next day and a half's worth of trial, so I'm trying not to give any spoilers here. That's kind of why I'm being quiet, because I don't want to spoil what's coming up in the future.
And
So
those
from
three-
what you've seen, Jeff, has the state rested yet?
No.
No. Okay. So it's still, because I'm wondering if this could actually be, that unicorn case where it's like a directive verdict when the state rests, which never really happens. It's like a theoretical outcome they teach you in law school, but
I'm thinking there's a very good chance.
Really?
okay.
Oh, yeah.
Thank you.
All right. So that's it for the state. So my plan, Jeff and Steve, I don't know if you were here when I mentioned this, was to kind of fast forward, try to play catch up here, because this actually happened 2 days ago. Now, this opening statement, and just kind of fast forward to the various witnesses. We may miss some things that way, but hopefully not too much. And again, everybody, what we're looking for is the whole case. The whole case is the state's burden to disprove self-defense beyond a reasonable doubt. So we're looking for testimony from the state's witnesses that is, inconsistent with self-defense, that would undermine that claim of self-defense, and not just by a little bit, but by a lot. But I mean, I'd like to hear anything, because I didn't hear anything in the state's open.
Well, and but before we get too caught up in the defense case, I'm going to push back a little bit, just because somebody's got to be the advocate for the state, right? And that
What,
is
lawyers arguing?
yeah. Well, the first thing is that you never know what a jury's going to do. You can get jurors on there who are, ooh, guns are icky. Somebody got shot, and somebody is dead, and this guy shot him. He admits it, and therefore he's guilty. And not get into all the intricacies. So there's always, if you've got a trial and you're just going to a jury, there's a danger that you get convicted, even if it's a 10% or 20% or whatever the percentage you want to assign to it, which you can't really assign. Jurors can come back. So if they can get it past that judge and to the jury might convict. So I'm just because the guns are icky and somebody's dead.
Never a 0% chance of conviction, folks. I always tell people, cases I work on, if we put you in front of a jury, we put that client in front of a jury, there's a 10% chance you get convicted. I don't care how innocent you are, because that's just the noise in the system. And jurors are dangerous and unpredictable creatures. And, the prosecution knows if he can get it in front of that jury, there's a chance. He's got a chance. It's like the Dumb and Dumber movie, right? Even if it's 1 in a million, you're saying there's a chance. Well, that's...
We all have that in our communications with clients too. Well, what's my percentage of winning? Well, I think you have a good chance, but we can't rule out the possibility that ...
Right. Could go sideways. Always a greater than zero risk.
And the other
which is
thing
why you don't want to be there if you can possibly avoid it, consistent with safety and your other interests.
And there is a prosecutorial philosophy that I don't agree with, but I'll put it out there. And that is, we have a case that we have an argument to be made, and we're going to make it, and we'll just give it to the jury, and whatever the jury decides, that's justice because they made a decision. But I think there's a gatekeeper function on the prosecutor's office that should not be submitting cases when they have a reasonable doubt as to the
cowardice.
But a lot of times they'll just say, we're just going to throw it up there and let the jury decide, throw our hands up, and whatever will be, will be.
Yeah,
And,
that's to my mind, that's a morally unsound position if you're the prosecutor. If you're the prosecutor, you're supposed to be pursuing not a conviction, but you're supposed to be pursuing justice with a capital J, and not just relying on noise in the system and the chaotic nature of a jury to deliver you a guilty verdict.
And some of these preliminary witnesses, a lot of times the lead witnesses are going to be authenticating witnesses. So they're going to be putting on evidence like authenticate the gun, the phone call, and the real, this is all build up. Usually, unless you lead with a strong witness, most of the preliminary witnesses are basically just bringing in evidence and not anything impactful.
Yeah. So what I'm seeing in the chat is people telling me that it only goes downhill from here for the state. So
oh gosh, that was the best.
Yeah.
Well, yeah, spoiler alert. It doesn't get better.
ISIS, tell me, give me a spoiler. Give me one little spoiler.
Oh God, which one should I give? That they can't identify the defendant in the courtroom, one of the witnesses?
Really?
How was that for a
Good
spoiler?
afternoon, sir.
Good afternoon, ma'am.
Could you please start by telling us and spelling your first and last name?
My first name is spelled Hayden. My last name is spelled Walker.
And where are you currently employed?
I'm working for a personal friend.
Okay. So are you working in law enforcement currently?
No, ma'am.
Were you previously employed by the Sandoval County Sheriff's Office?
Yes, ma'am.
How long total did you work for the Sandoval County Sheriff's Office?
Approximately 2 years.
And prior to that employment, had you been employed with any other law enforcement agency?
Yes, ma'am.
And can you tell us about that?
So in 2014, I started with the Lee County Sheriff's Department, and 2016, I worked with the Hobbs Police Department.
And
A guy who changes jobs every 2
I
years.
guess I should just
That's
call
not
you
good.
Mr. Walker, correct?
Yes, ma'am.
Sounds funny. Can't call you deputy now.
So, I mean, this all happened in 2020. Presumably, the shooting happened in 2020 when he was still a cop then. Presumably, that's why they're calling him as a witness. But that's his third cop job in 5 or 6 years, which is, I guess, not completely. And now he's out of the cop business, right? He's working for a personal friend. That's his self-described employment. 2 years later, after this shooting, he's no longer a law enforcement officer. I don't know.
So, Mr. Walker, were you on duty February 29th of 2020?
Yes, ma'am.
And can you tell us what shift you were working?
I believe I was working swing shift.
And what hours are swing shift?
To my memory, it's from 2 p.m. to midnight.
Okay.
By the way,
While
I completely concur with the people in the chat arguing that allowing witnesses to testify wearing these masks is a constitutional infringement of the rights of the defendant, because you cannot effectively evaluate a person's credibility if you cannot see their facial expressions.
I was actually working on motions in that effect for our courtrooms, but then the masks mandate got lifted. But we were going to challenge that constitutionally, and in our courtrooms, I was sort of tasked to do the research. But it's quite a complex issue. But yes, there's a right of confrontation, and how can you assess this person's credibility when they're behind a big piece of paper?
you were on duty on February 29th of 2020, did you receive a call to go to a remote area near Cabazon Peak?
Yes, ma'am.
And what can you describe the nature of the call that you received or the call out?
From my recollection, it involved a possible shooting.
I'm going to speed this up a little bit, folks.
The call came out as a shooting.
Now, when you were you
They all
when
talk
you were
pretty
working,
slow.
Did you wear a uniform?
It's
and a
New
badge of office?
Mexico.
Yes, ma'am.
And what kind of vehicle did you drive?
A marked Dodge Ram pickup truck.
And did you drive alone or did you have a partner with you?
I drove by myself.
Can you tell us approximately what time you got the call to go out to that area?
May I refresh my memory?
Would looking at your report help refresh your memory?
Yes, ma'am.
Do you have a copy of your report with you?
No, ma'am.
May I approach the witness? Yeah. Yes.
You may, Ms. Palmer.
Approach right now.
Yeah, I see that the video is looking choppy to me too on YouTube. Sorry, folks. I don't think there's anything I can do about that.
It was approximately 1740 hours. 5:40 p.m.
So after you received the call,
Yeah, hopefully it's a transient problem.
proceed straight to the location?
Yes, ma'am.
And where was this location?
So the best directions that we had was near Cabazon Peak Road. And I believe there was some GPS coordinates provided. And there's a road called Cerro Los Pinos. And that area is kind of, I mean, it's not very well marked, but in that general vicinity.
And when you went out to the location, did you meet up with someone?
Yes.
Do you recall who that was?
I believe his name was David McCullough.
Okay, and when you met up with David McCullough, did he assist you in locating the residence where the shooting had occurred?
Yes.
And how did that happen? Did you go together? Did you follow him there? Did he ride with you?
To my knowledge, there was myself, Deputy Honey Estiwa, and Sergeant Crespin. And I believe Mr. McCullough rode in Deputy Crespin's patrol unit towards the rear. And I was at the lead of the convoy, I guess you could say, and utilizing the radio, he provided directions to Sergeant Crespin, who relayed them to me.
Okay, so approximately how long or how far was it from the point where you met up with Mr. McCullough and when you got to the actual location of the shooting?
Approximately 4 miles, I believe.
Okay. And when as you were driving up to the location, what did you observe?
I believe the road split off to, it continued south, and then it branched off to the west, so it would have been like a right-hand turn. I was informed that we were near the location, near the residence, but our view was kind of obstructed due to the terrain. So we kind of like set up there to kind of make sure we had all our resources in place before approaching the residence.
Okay. So how long did you wait there before you made sure you had all the resources you needed?
Maybe a couple minutes.
Okay. So if I understand you right, then did some other deputies arrive at your location to assist?
To my knowledge, people were having difficulty finding us. There's no cell phone reception in that area.
Okay.
So I know my phone wasn't working and we were kind of in a depression. So our radio communication, like we'd have to send somebody to the top of the hill. So I think we kind of came to the decision like, hey, just based off the fact that there's a potential shooting victim, we need to approach the scene as hastily as possible while still maintaining safety. So I think waiting for more people was kind of out of the option because we were given an ETA of hours for state police to show up.
Okay. Now at that point, did you know the condition of any victim, whether that a person was alive or not alive?
So at the time, like I said, it was a possible shooting. We had no direct witness to said event, to my knowledge, from what Mr. McCullough had seen. And so, I mean, in law enforcement, we get calls like hoax calls all the time. So at the time, we were using best practices and trying to make sound judgment decisions.
Okay. So at some point you drove up closer to the ranch?
No, I believe we stayed where the Y intersection was at.
Okay. And what did you observe when you got there?
So around this time, it was dark, and I remember seeing some lights that were headed towards our direction, which in this area, it's very, hardly any people live out there. It's very sparsely populated. So I saw the lights coming towards our location. I believe it was coming from the residence.
Okay. Could you actually, was it dark yet when you got out there?
Yes, ma'am.
Okay. So other than the lights of the vehicle approaching, did you see any other lights besides those of the officers?
No, ma'am.
Okay. So when you saw the lights of the vehicle approaching, what did you do?
We have it's called a PA, a public announcement system. I began giving verbal commands over the PA to try to establish contact with the person from a distance.
Okay, and what did you say? More or less, I mean, not verbatim, but
I
what
mean,
kind of commands were you giving?
just basic commands of stop your vehicle, turn it off, get out, kind of stuff like that.
Okay, and did the vehicle stop immediately?
Yes,
Okay, and how many people exited that vehicle?
just one.
Okay, and is the individual that you saw, do you see him in the courtroom here somewhere?
Yes, ma'am.
Could you point him out and describe an article of clothing that he's wearing?
He has on a blue mask, and from my view, it looks like a black or dark navy jacket sitting in between the two women.
Okay, could the record reflect that the witnesses identified the defendant?
So reflect.
So, Mr. Walker, after the defendant exited the vehicle, what did you do next?
I continued to give him commands to approach us because, like I said, we were kind of at a position of advantage. So I had him come to us, and I gave him verbal commands. Essentially, and law enforcement, for safety purposes, will have somebody like lay them on the ground and have them put their arms out to safely restrain them.
And did he comply?
Yes.
Did you do any sort of search of Mr. Cummings, the defendant?
Just a basic pat down for weapons.
And did you find any weapons on him?
No, ma'am.
Okay, so after that was completed, what did you do then?
I secured him in my patrol unit.
Okay, and when he was secured in the back of your patrol unit, what did you do after that?
Mr. Cummings was asking a lot of questions like, hey, why are you doing this to me? And I was trying to explain to him, like, this is protocol given the severity of the type of call. And he basically told us that he had acted in self-defense and he was
Let's start.
armed by some sort of neurological agent.
That's what he told you?
Yes.
Okay.
Okay, first
And when he
contact.
told you he had been harmed, what did you do?
I asked him if he needed medical assistance.
And did he respond?
No.
Excuse me. To your knowledge, were medical personnel dispatched?
Oh man,
to
that's
the
going to get
location
tiresome.
to examine the defendant?
Yes, ma'am.
And who was that?
I believe it was the Navajo Nation's Medical Service.
And they did that while you were present?
It might have been in the company of another deputy,
Okay,
but I was kind of in the area.
okay. So what was your next step after that?
So my next step was, okay, is there potentially somebody who's injured that we need to render medical aid to? So our next priority became potentially locating a injured person. So we, in law enforcement, it's called a security sweep. Basically, we went to go secure the scene and check for any victims.
And when you say the scene, help the jury understand was there some sort of residence there on that property?
Yeah, so it's kind of like a big ranch style property, I guess. Like there's a fence and to my knowledge, I want to say there's like some like sheds, like some overhanging structures where somebody might keep horses. There was a RV camper and there was a small little house in the middle.
Okay. So who besides yourself went in to do the protective sweep inside that residence?
Myself and Deputy Honey Estiwa.
Okay. And describe what you observed when you entered the residence.
So whenever I entered the residence, I remember we were standing outside the door, so we had opposite views. And I saw a bathroom and a kitchen area, and I went into the bathroom and kitchen area, and Deputy Honey Estiwa went to the other side where he informed me that he had saw a male on the ground.
Did you ever go in there to observe the male that was on the ground?
No.
So after you finished your protective sweep, what did you do after that?
So we exited the residence, we secured it, and we continued clearing the rest of the property. And then after we determined that there was no outstanding suspects or any potential threats, we went back to our patrol units and waited for additional deputies to respond.
So did you have any part in, I don't know, securing the scene is right, but setting up the perimeter and controlling entry and exit?
No, so it's, like I said, it's a very rural area. I believe there's just the one roadway to the property. So where we were set up at, we were able to maintain the security pretty well.
Okay. Now, did you on that day have any sort of lapel recorder on that you were activated, or excuse me, that you were wearing that was activated?
Like a body camera?
Yes.
No body camera.
Did you have any sort of audio recorder?
Yes, a pocket recorder.
Okay. And did you turn that on at any point during your?
Yes.
Okay. When did you turn it on?
Probably right before I was going on scene.
Okay. And What happened to that audio recording after your part in this investigation was complete?
I uploaded it to the Sandoval County's server as part of our evidence procedure.
The location is south of
And have you
Chama.
had an
Everything in New
opportunity
Mexico is
since
south
that
of
day
Chama.
to
It's just west of Los
review a
Alamos.
portion of that audio recording?
Yes, ma'am.
Okay. I don't know. May I approach the witness?
You may.
Mr. Walker, on the hand, you listed marked as Stacy Exhibit 13. Do you recognize that?
Yes.
And there appears to be a name on there. Is that, do you recognize that name?
Yes, that is my signature.
Did you put that on there?
Yes,
And when did you put that on?
today.
Your Honor, at this time I would ask to play, it's about a 5-minute segment.
You may.
I don't do technology. We might need your IT person if it doesn't work. Your Honor, I'm sorry, I think this has been stipulated to, correct? Yeah, we're not objecting.
13 will be admitted.
Thank you.
Farron. Hey, Farron.
Fingers crossed.
We get audio.
Hey, Farron. If you want to join us, I send you a guest link.
Mr. Walker, if you could listen to it, because I might have a couple of questions about it afterwards.
Okay.
Farron wants to start some shit.
I heard about a dust up between you guys, but I never saw.
It was nothing. It was nothing.
It was a snuggle struggle.
It's
we
just
had
a
a
way
great-
to generate controversy and views, is what it is. I know that.
Come on, please. This way. All right, lift up the back of your shirt. All right, spin around for us. Continue to lift your shirt up.
Sorry, folks. That's on them.
Okay, all right.
I
All right, now
forgot
this way
about
from
that.
us. Drop down to your knees. All right, lay face down on the ground, okay? We understand that we have to follow our procedures, okay? All right, now lift your arms up like an airplane. All right, remain in that position.
Like Jesus.
Is there anybody else in the truck with you?
I need to start a feud with someone.
Maybe we should
Boring.
start something. We should, but I don't have
Yeah.
any. But nobody watches me. You're like the guy. You know, you need to start it with somebody who has like a lot of watchers.
I'm just too much like Rush Limbaugh, just a harmless little lovable fuzzball.
So this is the audio of him taking down the defendant.
Yeah. Because he didn't turn his body cam on.
Okay.
Yeah. Do you have anything else on this person? Any pocket knives, anything like that?
No, nothing, maybe some pocket change.
And you said nobody else is out here with you?
There's a gentleman that came down, my dad's, just up the road.
Okay. Where's your dad at?
Just up the road about a mile. He called me from Amazon, so he's right over here.
What
No one's out there on the premises.
Okay. What kind of vehicle is he in? Your dad?
He's in a Toyota Rav,
Okay, what color?
blue.
Okay. Okay, this one? Wait,
Who you guys with?
Farron, I DM'd you a guest
where's
invite
the
on
file?
Twitter if you'd care to
I
join
think on the
us.
fourth.
Don't feel an obligation.
Report to the
You're
resident?
more than welcome.
You guys could get right there.
Okay, and where's the subject at?
He's inside the house.
Inside the house?
Yep.
Okay.
And there is some, whatever he jammed in my face, it admitted some sort of, I don't know what it was, chlorophyll or something.
Okay, do you need
So
an
the
ambulance?
house,
Do you need an ambulance?
I was putting the ambulance out of the house and I went and washed my face off.
All right, we're gonna set you up. All right, type your knees under.
And there he goes explaining why he had to wipe his face off.
We're gonna get this up. We're gonna take care of it. So which road is your dad coming down? This one?
We're also streaming this on Twitter, folks. It's at Law Self Defense on Twitter. That's their audio, folks.
So from what I'm hearing, he's immediately claiming self-defense. He's explaining that he got hit with some kind of chemical and it's irritating his eyes, and he's completely compliant.
All right, so
Right.
if you
Yeah.
are legitimately defending yourself, okay, we have to preserve the scene, we have to preserve the evidence, we have to do everything by the book and show that, right?
And what the prosecution said in their opening statement, he took the magazine out of his weapon and placed it next to it on the porch in plain view.
Which is the proper procedure.
Yeah.
Yeah,
Very thoughtful, actually.
yeah. So I was gonna say.
Can I give you a layout, guys? You know what you're looking at?
Sure.
So, my truck's in the way, so
Right.
I'll have to stop and drive out here to put it on. and then go in, and it's the bar trailer.
Okay,
You'll
bar
see-
trailer. So what color is the trailer?
You'll see my rifle on the porch.
Okay, what
You'll
kind
see
of?
that from a position.
Okay,
I can flip, I put the rifle there.
so what color is your trailer?
The trailer, I was communicating guys about it.
Folks, this is a lot more detailed than I'd be sharing with responding
Okay, like your
officers.
trailer.
There's an
So
RV.
is there anybody else on any of the other
No,
properties? Okay,
So there's an RV in the first one.
okay.
Yeah, there's no body camera video. I believe it's because the officer does not have a body camera. It does sound like he's wearing corduroy.
What's the address here? You know?
I don't know. It doesn't.
Yeah, he does have the body cam.
Oh,
He
really?
just
So you don't have
knew
a
it
camera?
wasn't working, so he
Does
didn't
he?
turn it on. Yeah, it wasn't working, so he didn't turn it on.
Okay.
It's you got a hand if you own.
Okay.
You got a pussy cup.
Okay. Thank you.
And,
All inferences should be in favor of the.
Okay. All right.
did you see the device in his hand?
I didn't clear that room. The other deputy did. But, so.
We're just here to secure, make sure everything's all right. So.
Mr. Walker, it sounded like he was asking you a question about whether you saw something. Did you hear that?
Yes.
What was he asking you
He asked if I saw a device in his hand, I believe.
in the decedent's hand?
Yes, ma'am.
Okay, and you said you hadn't gone back there, right?
No.
Let me ask you this. When you observed Mr. Cummings, the defendant, did you observe any kind of injuries on him?
No.
Any scratches or bruises or anything like that?
No.
What about his eyes?
This trial is taking place this week, folks. This video is from 2 days ago. They were wearing masks.
No, ma'am.
The shooting is from 2020.
Did his eyes appear to be red or watery, anything like that?
No.
And when you went out there, you did not know who the defendant was, correct?
Good heavens, we're over 1,000 on the chat.
Did you attempt to find out what his identity was?
So my main role in this response is as a patrol deputy to go out there and secure the scene. Like I said, I didn't go see where the decedent was at because, I don't want to contaminate the scene and potentially ruin the investigation. So my main concern was
Good heavens, we are.
any possible suspects in securing the scene.
Hit that like button, folks. Hit that like button.
Your patrol car?
Yes, ma'am.
Would it be standard practice at that point to try to find out the suspect's identity?
Yes.
Did you try to do that?
Oh, don't steal people from other people's streams, folks. I know that's well intentioned. That's not how I want to operate. So people, can go wherever they like. Lots of good streamers out there.
I'm gonna leave this in case you need it. But okay. Just because I don't have to look at it. I'm gonna leave it for your own. But I will need more room. Oh, I'll get it. So, I don't think I need that. I'll go ahead and grab it.
That looks
That was-
really disorganized.
That was it, huh? Is this the second, defense counsel here on the left? Must be, right?
It must be.
Yeah.
Good afternoon, Mr. Walker. How are you?
Doing good, ma'am. How are you?
I'm good, thank you.
Oh, she sounds very masculine, which is good in this context.
She sounds authoritative. I like
Yeah.
it.
Okay, for a minute, okay?
I'm sorry.
I'm going to back up and ask you some preliminary questions.
Okay.
What year did you begin your law enforcement career?
2014.
And in 2014, did I hear you say you worked for the Lee County Sheriff's Department?
Yes, ma'am.
How long did you work there?
2.5 years.
And where'd you go after that?
Hobbs Police Department.
So did you start there in 2016?
And Hobbs, yes, ma'am.
How long did you work for Hobbs?
It was around 2 years.
And then you left Hobbs?
Yes.
Where'd you go when you left Hobbs?
He's already looking down.
Yes.
He's already averting his eyes.
Just what I keyed on.
Maybe a little less than.
So what year would you have started in Sandoval County?
To my knowledge, it was November 2018, I believe.
And then did you leave 2020?
Yes.
So that would be the year of this investigation?
Yes.
And where'd you go then?
Bernalillo County Sheriff's Department.
And how long were you there?
2 years.
And now you're no longer in law enforcement, is that right?
Yes.
Okay. Now,
Implication, you suck.
on February 29th of 2020, that's when you get dispatched, is that right?
Yes.
I'll try to
And
bump up the
you
court volume a bit.
understand at the time that you're getting dispatched, that you are being dispatched to a possible homicide.
Yes.
And you ran an audio recording device. Is that correct?
Yes, ma'am.
Now, it's my understanding that you actually had some type of a camera, but for some reason you didn't use it. Is that correct?
Yes,
So why didn't you use the camera?
because it did not work.
The camera didn't work.
Yes, ma'am.
How long had the camera not worked?
For several months.
And had you gone to any of your supervisors and told them that your camera didn't work?
Multiple times.
And did they ever replace your camera?
I was told there was not money to replace the
So
camera.
this is textbook impeachment, folks.
So you run your audio recording device because that is all you have at your disposal. Is that right?
Yes, ma'am.
And the small portion of the recording that we heard today, I think, is about 5 minutes. But have you had an opportunity to listen to the entire audio recording that you recorded?
No.
Okay, hang on just a second.
I can fix that for you.
The mask thing is really annoying to me.
Yeah, yeah.
Isn't it?
I'm from Free Florida, and it bothers me. I like this defense attorney. I think she's going right for
Yeah,
it.
yeah.
So,
Oh, they're all just
Mr.
cutthroat.
Walker, do you have any idea how long the entire audio recording is that you recorded on that night?
To my recollection, it's probably an hour and a half long.
An hour and a half. Now,
Thank
I
you,
have listened
Farron.
to the entire hour and a half, and I've never heard you ask him his name. Am I wrong? Would you like to have an opportunity to review it?
I'm not saying that you're wrong.
So, Ms. Romo asked you if you asked him his name and if he refused to give it to you, and you indicated that that occurred. So if that occurred, we heard your recording. We can clearly hear your voice, right?
Yes.
Now, it's harder to hear Mr. Cummings' voice on your recording, right?
When I'm not walking and moving, yes.
Okay. So I'm going to give you an opportunity right now. You can agree with me that you never asked him his name, or we can take a break for an hour and a half, and you can review your entire audio recording and come out.
Yeah,
Give us
go
your
hard.
opinion.
Gotta do it.
What would you like to do?
So I guess I didn't ask him his name.
Oh!
Testifying today from your memory, or are you testifying based on a conversation that you had with someone at the district attorney's office? What?
Oh, I
where
like
are you
this lawyer. I
testifying
got to
from?
find out who she is.
Yeah.
But you didn't take the time to actually sit and review
I'll turn down my
the
audio
audio
a little
recording,
bit.
right?
So I have listened to it. As far as in entirety recently, no, ma'am.
Since the date of incident on February 29th, 2020, have you listened to the entire recording?
Yes.
When was that?
After the incident, when I was having my report.
So what day would that have been?
The day of or the next day?
So have you listened to the audio recording that you made anytime within the last 2.5 years?
No.
Oh. None of this testimony should be surprising the state, by the
Now,
way. And this is their
By
first
the time
witness.
you show up there to the area, the first person you make contact with is Mr. McCullough, right?
Yes.
And how much time do you spend with Mr. McCullough? Do you recall?
Not a very long time.
I'm glad this woman went
What does
into
that mean?
law
Is
and
it
not
minutes?
human
Is it 10
resources.
minutes, an hour?
Minutes approximately.
She'd be
Okay.
like a
And
Uber
after
Karen.
speaking to Mr. McCullough, you went kind of with Mr. McCullough to this area where the ranch was, is that right?
Yes.
So how long do you think it took you before you made contact with Mr. Cummings?
But I mean, let that sink in. The police did not ask his name for the first hour and a half.
It's a rough road, so I would probably guess maybe 30 minutes to an hour.
30 minutes to an hour from what time?
May I refresh my memory?
Sure, would something
With
refresh
what?
your memory?
With what?
So is part of the evidence they're trying to say he's obstructing because he didn't give his name, and now
Right.
he's saying he never asked him.
Yep.
It's name, and then later the other officer says that he gave multiple dates of birth.
That's weak.
I think.
just a little commentary.
Yeah, well, that's a good point in the chat. It's I really like this woman as a lawyer. I would not want to be married to her.
Andrew's smoking today.
Yes.
So walk us through this timeline a little bit.
So approximately 25 minutes
From when?
from making contact with Mr. McCullough to making contact with Mr. Cummings.
Okay. So 25 minutes from the time that you made contact with McCullough to the time that you made contact with Cummings.
Yes.
And when did you receive the dispatch call to head out to Cabazon Peak?
I believe it was at 5:40 p.m.
How long did it take you to get out there and make your contact with Mr. McCullough?
Approximately 26, or I apologize. I don't want to give a specific time, but I know that I was coming from Cuba and I was driving with my emergency lights and sirens activated. So drive time from Cuba to that location. If you'd let me refresh my memory, I could give you more specific time frame.
What would refresh your memory?
My police report.
You know she has sensible shoes.
Oh, for sure.
So approximately 46 minutes.
She's going to reach under that table to that big briefcase and pull out a strap on in a minute.
So it takes you 46 minutes to get to the location to make contact with McCullough.
Yes.
And then it takes you.
And
Would
he'll
this
take
report
every
record-
inch of it with pleasure.
Yes.
Okay. And you don't.
This is the
understand-
commentary I came here for.
Now, before you arrive out there, you already have some information about what's going on, right? Let me ask you
Very-
this. Isn't it true that you're receiving updated information on your CAD system?
Yes.
Can you explain to the ladies and gentlemen of the jury what a CAD is?
Actually, I'd like to, from my memory, I don't believe that
I'd
we
like to
had
go
an
home.
update CAD system at Sandoval County Sheriff's Office at the time of this incident.
They don't have CAD?
What do you mean?
So some agencies have computer assisted dispatch, and I do not believe Sandoval County had a computer assisted dispatch at the time.
So let me ask you this.
Did you get
Who's communicating to you when you're out in your car, telling you where to go and what to do?
Dispatch.
What is this, Albania?
And so how are you receiving that information?
almost? It's
Radio.
BF New
Or are you
Mexico.
receiving it on a computer also?
To my knowledge, I was not.
But you're receiving it over the radio.
Yes.
And what you're receiving over the radio is that there is a written record of it, whether you received it at that moment on your computer or not, a written record of it is made, correct?
That would be through the dispatch system, to my knowledge.
Right.
Well,
But
did you get it from a computer screen in front of you, or did you get it from your radio? How
It's true
fucking hard is this?
that at 5:50 p.m.
See,
you
she's got
receive
CAD.
information from dispatch that says Dean Cummings, phone number 907-831-6512, claiming he was attacked, tried to defend himself, and shot the individual dead. You received that information, did you not?
If dispatch related over the radio, yes.
Yes. So before you ever arrived, you know his name. They had already given you his name, and they had already told you what was going on. You had that information, correct?
So when I received the call, I began responding to the area with my emergency lights and sirens activated. I am traveling as fast as my patrol unit will go, which is approximately 105 miles per hour. I do not have time to remember every detail. There's cars that I'm avoiding. I have to obey traffic laws.
None
Like
of
going
these
105.
are relevant to the
105.
charge.
Notes on all information. I'm trying to get to the scene as fast as I can.
Of course, I have no expectation that
Oh,
you would take notes. My point is, there's a reason
Defense
that I don't
attorney,
see the
man.
actual recording what his name was. You already had it.
Boom.
Mr. McCullough already had it, right?
So we did not have a computer assisted dispatch, and also the phone was not working. So I don't.
The
see
issue is
how-
whether the name was provided,
when I
not
get
whether
the
he happened to
scene,
hear
I
it.
see what you're saying, but
Mhm.
if there's no internet signal, I'm not going to be able to receive this information in real time. And I'm also not going to be able to call dispatch and ask them questions.
Dispatch, oh, all right, let's back up. At 5:50,
When this lawyer
you are
says,
still
let's
able
back up,
to
that's a bad
hear
sign.
the radio communications as you're driving in your car, right?
When you're driving 105 miles per hour in a Dodge Ram, with air resistance over the light bars and sirens, it is very difficult to hear every radio transmission. If I heard it, I do not recall.
All right. Are you disputing that the dispatcher said Dean Cummings, with his phone number, claiming he was attacked, tried to defend himself, and shot the individual dead? Are you denying that that came out over your radio?
I'm not denying that. I'm saying perhaps I did not hear it.
I have the
But you agree
volume
with me,
master
just so
plugged
we're
in.
clear,
It's
that nowhere on that audio recording
That's all
did
I
you
can
ask him
do.
his name.
Correct.
Was there some point in time when you separated yourself from your recording device?
Yes.
When was that?
So whenever we secured Mr. Cummings in the backseat of my patrol unit, I don't have a recording device in my patrol unit that works. I made the decision to leave my pocket recorder inside my patrol unit while I went to the property. Now, whether I was vigilant and putting that on my person at all times, I cannot recall. Like I said, there was a lot of moving pieces, but I figured for the integrity of the case, it was better that I left my pocket recorder where Mr. Cummings was at while I performed the security sweep.
The victim wasn't
let me
moving.
understand
That's
this.
one less thing.
You leave your pocket recorder where Mr. Cummings is,
On my passenger seat of my patrol unit, yes, ma'am.
and Mr. Cummings was in your unit.
And the back seat, yes, ma'am.
Who was staying with Mr. Cummings when you were not in your unit?
Deputy Crispine,
So,
Sergeant Crispine. My
so your,
apologies.
your audio recorder was recording even though you weren't there.
Yes,
This
So
is the
you separated
state's first
yourself
witness?
From the recording device,
Yeah.
but you didn't separate the recording device from Mr. Cummings.
that is correct.
Okay, so there wasn't any point in time where he was saying things that aren't recorded.
So if you look at the time frame of the call, my pocket recorder actually dies. So that is why it's at an hour and a half duration and not for the entirety of the incident.
Right, but that doesn't happen for an hour and a half.
So whenever we cleared the property, like I said, it's a very large property. I don't know how long it took us to clear it, but it took a long time. I remember I was physically exhausted after searching the premises.
After an hour and a half?
Yeah.
But your
look like a
recording
young
device
man, my friend.
ran the entire time that you were clearing.
My
the
fat
property.
ass could walk around a flat area for an hour and a half with no problem.
It wasn't on you.
So I don't remember exactly when I took it off my person, but I remember that I left it with Mr. Cummings and separated myself from at some point in time.
And on the recording device, on the audio recording, we can hear you go and clear the residence and we can hear you come back, right? Or do you not know because you haven't reviewed it?
I was waiting on the second PTI from your office to review it.
I don't understand second PTI.
So I had a PTI hearing with your office, I believe,
Mhm.
and I was told that there would be a second PTI where you requested that I listen to it second per second, and I never received notification for that.
There was a discussion during your interview about the fact that no one had your recorder, had your recording device. That's true.
Right,
But we're 2.5 years into the case now.
right. And I also separated from the agency, and I don't have access to that.
Okay. So now, Mr. Cummings was completely cooperative with you, correct?
Yes,
He followed all of your commands, correct?
yes,
You asked him numerous questions and he answered all of your questions, even though he didn't have to, correct?
sometimes he didn't answer directly to the question, but he did speak on some matters.
Such what?
Like, what are you referring to?
I asked him if he needed an ambulance. He didn't answer that question with an affirmative yes or no.
Well, that's not really what the audio recording bears out. Isn't it true that some of his answers are inaudible because your recording device isn't close enough to him, right?
Correct.
So we could hear on the recording that Ms. Romo played for you, we could hear you ask if he needed an ambulance. You asked him twice. The second time, the first part of what he says we can't hear, and then we can hear him say, I had to wash my face, correct?
That is not a yes or a no, but yes, you are correct.
Okay. It's not like he's ignoring you. And the inaudible portions of that recording, do you remember what he says?
It was over 2 years ago, no ma'am.
Right.
Oh, if only he had reviewed it.
Transcript that's inaudible. You don't recall what he said, do you?
No.
Ugh,
So just to be clear,
this is just utter destruction.
Now he should poke her some more. That's a good plan.
Well, okay, another spoiler. The third witness is where I came into this trial. And it took me about 20 minutes to figure out that it was cross-examination and not the prosecution bringing in a police witness as a hostile witness.
Audio recording. Well, I haven't tried to use it to impeach yet, but I'm happy to give her a copy.
Oh my gosh. She is on top of her game, man. See, this is a good defense attorney right here. I'm in awe.
Dummy. It's like, Your Honor, can you ask the...
One of the very first things that Mr. Cummings told you when you had contact with him is he said, "I'm not armed," right?
To my knowledge, yes.
To my knowledge.
You asked him, "Where's the firearm at?" Correct?
Yes.
And he gave you a very direct answer. He said, "I put it on the porch," right?
Yep.
You said, "Where is the subject at?" And he gave you a very direct answer. He said, "He's inside the house," right?
Yes.
He's been beaten.
Yeah, just look at the eyes.
Yes.
Stop.
You asked him, "What color is the trailer?" And he tries to answer you. Part of it's inaudible, but you're able to clear it up. You say, "What color is your trailer?" He says, "It's light blue." Right?
If that's what's on the pocket recorder, yes.
If you need to refresh your memory, I'm happy to show you this. Sure, right now I'm on page 14. You asked him, "Is there anybody else on any of the other properties?" He says no, correct?
That is correct.
By the way, this is the verbal strap on here.
I know. Your Honor, can we get this witness some
You
Midol?
asked him, "Is the residence unlocked, sir?" He said yes. You asked, do you have any dogs or anything? He said
Vaseline
no
at least.
dogs, right?
Yes.
Get the butter.
Now, if you recall, you had a conversation with Mr. Cummings that is on your recording about the clothes that he took off. Do you recall that?
Yes.
He told you that he took his clothes off because he had been sprayed with whatever this man had in his hand, correct?
Yes.
And he told you exactly where the clothes were, right?
Yes.
Where were they?
To my recollection, they were on the back of his pickup truck.
And in addition to telling you where the clothes were, didn't he also ask you to be sure to preserve them, to put them in a trash bag, he said?
Right.
Okay. So in no way did he try to hide the clothes from you, prevent you from obtaining them. In fact, he did the opposite, right?
That is correct.
Oh, Jesus. There goes the evidence
What the address was,
charge.
Told you that there wasn't one out there.
I believe
Right.
that was Deputy Honey Estiwa who asked him what the address was.
Okay. And we're just hearing it on your recording.
Yes.
And you make an important point. You're not the only person speaking to Mr. Cummings, right? There's other deputies who are speaking to him at the same time. You're just the only one with a recording device on, correct?
To my knowledge, yes, ma'am.
All right.
This trial's ongoing right now. This was 2 days ago, this testimony. It's New Mexico. Yes, they're wearing masks 2 days ago.
You even asked him if he had a key to his fifth wheel so that you could get in it without too much trouble, and he directed you to where the key was, right?
Yes, ma'am.
This is why I
How-
left law
how-
enforcement.
He looks pretty young for get a vasectomy like this.
Answer, man. Yes.
This is a legal prolapse here.
One of the things, just to be clear, that we heard on the audio recording is initially when you make contact with Mr. Cummings, he says to you, "I'm devastated." Isn't that what he said?
To me, that part sounded inaudible, but that could have been what he said.
Would it refresh your memory if you looked at the transcript, or do you want to agree with me?
I mean, your level of
Great
awareness is
question.
different from mine, so I'm not sure your transcript is accurate with what I would be hearing from my pocket recorder.
All right, well,
Ooh.
let's go ahead and
Just he's trying to dig.
let me see if I can.
This
would it
lawyer
refresh your
also
memory if you listen to it again?
Hammer Factory.
I'm not intending to play an hour and a half. Your Honor, she's right.
I'm not intending the video for all that.
Yeah.
So,
Neither is the jury, I don't think.
I,
He can listen to it overnight.
well, we can do it a couple of different, it's part of the short clip that we played for the jury. So we can play that 5-minute clip again because it's in there. Or we can have the gentleman listen to the hour and a half overnight and he can come back tomorrow, whatever everyone prefers. It seems easier that he just listened to the 5-minute clip.
Ms. Romo.
I'm not sure where she's going with it. I mean, she's going to refer to different parts of this entire interview that she's been doing, then I think we need to play the whole thing. She's been referring to this entire alleged transcript of his belt tape.
The judge does not want to do that.
And most of it is just him writing, but if she's going to ask specific things that are outside that 5-minute clip, then we need to hear the whole thing.
I'm not limited to the 5-minute clip that Ms. Romo chose.
Okay,
Right.
We're going to research for the day, provide him with the 1.5 hour recording, and we'll come back in the morning.
Sure, I don't have a disc of it. Yeah, I have the recording on my computer. Sure, he can come to my office and pick it up. It's in Albuquerque.
Albuquerque is not close, folks.
It's just been a long day for the jury, so let me read the research instruction and we'll break things up tomorrow.
Break for tomorrow.
Folks, pay attention to this instruction. I'll read it one time, and as the trial goes on, I'll just remind you of it.
All right,
Okay.
folks, this is just going to be the closing instruction about, not to read anything in the news and all that kind of stuff. And folks, I apologize for audio variances and such. This is StreamYard. Complain to StreamYard. We have very limited audio tools to work with. I'm sorry about that. They don't normalize the sound across all the channels. I don't know why they don't do that. It doesn't strike me as something that would be technically difficult to do, but they don't. So some things are loud, some things are quiet. You take what you get and you don't throw a fit. So guys, can I leave you for a moment to discuss, Steve and Jeff, discuss amongst yourselves? I'm going to go hit the head for just a moment.
All right.
Sounds
All right.
good. We'll tag it up after you get back.
We will. You too, huh?
Yeah. Too exciting. This is great. It's so refreshing to see like good defense attorneys at work when we've been watching that Brooks trial.
Yeah. Well, we're sort of, this is like if Brooks were the prosecutor.
Yeah, that's right. Well, this is obviously, I can't believe that they're bringing some destruction of evidence charge in this case for that. This is not, that's probably going to get JOA'd. I would expect that it's dismissed at the end of closed case if this holds up like this. What do you think?
I think the whole case has a directed verdict possibility. And I've seen, 4 witnesses now?
Really? Are we going to watch some more on top of this? I'm getting into this now. This is amazing.
Oh, I hope so. I want to get through at least, we're coming up on 4 a.m. here, and I've already seen this, and I don't want to leave.
Oh my God! Well, something that just to explain it for a legal purposes for our legal consumers out there, the state played like a 5-minute clip of an hour and a half audio. All right. Now the defense, I think what the defense wants to do is bring something that wasn't in the 5-minute clip, but elsewhere within the 1.5 hour audio. Right. Well, there's something called the rule of completeness. Mm-hmm. So they could bring the entire hour and a half in under the rule of completeness. So if the state objects and says, well, that's not, we didn't put that in evidence, the defense can then say, we want the whole thing in rule of completeness. And they could make the jury sit there and listen to the whole hour and a half. They kind of don't want to do that because they're making such good points here and they want to keep it brief and to the point. But if they do have to do that, they want to make sure that the state and the witness get blamed for it and not them. Is that fair?
Yeah. So this is just go home, listen to the audio, refresh your memory, and come back and answer the question tomorrow.
Right.
Or whenever it's ready.
And this another thing is to see the defense attorney has mastered this case. She knows the facts backwards and forwards. This cop is coming in. He hasn't looked at this stuff for 2.5 years. And so now he's trying to go toe to toe with her when she knows exactly what she's asking. She knows the answer to every question. And when he tries to wiggle out of the answer, she's going to nail him with it every time. He's a fool. Now you saw at some point he kind of gets beaten and he just starts agreeing with her because she knows the case way better than he does. This is a very typical interaction. I mean, have you seen that in your practice, legal?
It's a thing. I mean, you get, and weirdly, it's where if you are over prepared for your case and the other side is under prepared, it's actually very hard to argue against them because they make no clear statements because they don't have a clear statement to make. They just sort of throw stuff out there and you have to counter their ramblings. And it makes it that much more difficult.
Right. Well, so far now, unless this guy makes some kind of inculpatory statement, and this is a self-defense case, when they're struggling, and Andrew can jump in on this, but when they're struggling for a firearm between the two of them, both parties are armed.
Yeah, right.
And that's something that a lot of people don't understand. It's like, okay, he's struggling with an unarmed man. Once that person got hands on your gun and you are fighting and there's a firearm involved, both parties are armed.
Yeah,
right?
it's actually worse than if the other party was picking up their own rifle, which would clearly justify your use of deadly defensive force, because they're simultaneously arming themselves with a rifle and disarming you.
Wait,
Right.
time. I know. Someone in chat is saying I thought legal vices was disbarred. Fuck you for that comment.
Oh,
Fuck right off with that shit right now.
Who is that, Jeff?
Bahrain says I thought legal vices was disbarred. Yes,
I think he's
yeah.
talking
Fuck
about
off with that.
alcohol disbarred, you know.
Yeah.
You are kicked out of the bar.
Yeah, don't be bringing shit like that into the chat. I just wanted to say that right quick.
Yeah, Shane, if you can time out Barangay or whoever that person is, I'd appreciate it. We don't need any of that nonsense.
One other thing, I don't know. I got other ideas, but go ahead. Talk amongst yourselves.
Let me just cover some of these super chats to make sure we don't fall behind. Folks, I can't tell you how much I appreciate these super chats. $5, $10, $20 from Farron Balance. That's how much she loves me. I love you too, Farron. But honestly, it would be in your interest, instead of $5, $10, $20 a YouTube stream, become a Law Self-Defense member for less than $10 for the entire month. And you can comment all you want in the membership chat on your membership dashboard. But I'm not saying don't give me super chat money, but yeah, you know, it's an option that you might want to consider. All right, so let me step through some of these. Farmhand Tom. Tom's the guy who made that funny video of me and the Home Alone meme. He says, this is to you, Steve. $10 super chat. I get the $10, but Steve gets the comment. Steve, got your signed book. Thank you. I'm halfway through it. Good stuff. Appreciate it. Well, it's very kind. Farmhand Tom. Michael Carney, $5 British pounds. Another $5 British pounds for Michael. Thank you. This is to Jeff. Hey, Jeff, new Toho Godzilla movie, November next year. All right. Branca, I know more U.S. law because of YouTube lawyers than UK law now. That'll happen if you listen long enough. I would caution it depends on which of the YouTube lawyers you're listening to, but some of us know what we're talking about. Rach, $5 super chat. Thank you. Unrelated. I've been waiting for Steve to come back to ask if he knows anything about the Othal Wallace case in Daytona. Othal, Othal, Wallace case in Daytona, Florida, presumably, if it will be live streamed. Do you know if it'll be streamed?
Well, I know a whole lot about that. I'm actually advising. I'm kind of behind the scenes on that case.
Okay.
He hired a private attorney, but we are anticipating that it will come back to our office, so I can't comment on that case.
Understood. Slade asks, $10 super chat. Thank you very much. What's your opinion on carrying mace while armed? Well, I can prove it to you. I'm armed right now, and I'm carrying it's OC, it's pepper spray. Mace is actually technically a chemical agent, although now it's a generalized trademark for that company, Mace Incorporated, I guess. But this is pepper spray from Palm pepper spray. That's my preferred pepper spray. I think a lot of those guys, if I'm carrying a gun, I'm carrying pepper spray, folks, always. So that's my opinion. Ian, $10 super chat, just because we're awesome. Thank you very much. Farron Balanced, $20 super chat. Farron, looking good.
Another one. Boy,
no, that was just the only one. I just I mentioned it twice. Why are you cheapos not paying this man? I guess me would pop in, but I'm getting my hair done. Make sure you get your free book at lawselfdefense.com/free book. You should definitely do that. That's our book, The Law of Self-Defense. Have a great show, gentlemen. Love you guys. In fact, let me grab a copy of the book. Hold on.
Do you have a book, Legal?
I don't, but Andrew was just telling me I need to write one. So
I know I mean, the reason
Usually,
I wrote mine was because of Andrew. Andrew encouraged me tremendously, and he made it sound so easy.
I don't think I said it was easy.
Well, but you made it. You were just like, oh, just do this. I'm like, oh, okay.
Well, just because it's hard doesn't mean it's not a good reason to do it.
I know you, but thank you for encouraging me. I'm just a humble public defender over here.
Hey, full credit to you, man. You actually did it. I have to be honest. For every 100 people I tell to do something like that, what to me is an obvious opportunity to monetize the value they bring to the community, 99% of them don't do it. So kudos to you. You actually did it. And it's not that easy to write a book, folks. It's real work. Speaking of books, I happen to have one right here. You can get your own copy of The Law of Self-Defense Principles, my book, forward by Mas Ayub. For those of you who know Mas is, all of you should know, but and we give this book away, real physical book. We give it away for free, folks. We just ask that you cover the cost of shipping the book to you. You can get this at lawofselfdefense.com/free book. All right, back to the super chats. Thank you very much, Farron. That was very kind of you. TR, great.
I've got one. I'll have two, and I'll have two in about 10 days. Got Andrews.
Can you turn your audio down? I can't fix the audio issues, folks. Farron balanced another $5 super chat. Asked, has the state of New Mexico shown up yet? Sanir Chris, $5 super chat. What the actual F? No CAD mean the computer-aided dispatch system, the computer system in the car. Wow. Yep. Contingency plan. This place, this county, folks, is literally nowhere. It's like the backside of the moon, New Mexico. Contingency plan, $10 super chat. Check out the Volume Master Chrome extension. Yes, I have it. The courtroom is cranked up to 600%. That's the maximum. Michael Carney, another Michael Carney, £5 The officer said it was remote and never seen anyone in the area. So does that not contradict him saying driving he had to avoid people? Well, there's no people. There's nothing. There's nothing there, folks. Nothing. I've been through there on my motorcycle many times. There's nothing there. Shri SR, $5 super chat. Was this guy fired because of this case or did he resign? Well, he went through a number of agencies before he ever got to this case. So it suggests to me there's perhaps other issues going on.
Well, but on defense of that, I mean, it's hard being a cop. And I mean, they go through a lot of abuse. And so it's not for everybody. So he could have tried it out. It wasn't for him. So you just, anyway.
Well, except he kept going from agency to
three agencies in 5 or 6 years is not a good endorsement.
I mean, I would agree. A county deputy in one of these impoverished counties, I mean, they're not making any money. Nothing. It's terrible. But he didn't quit law enforcement. He went to another agency.
Well, he could have said again, I'm being the devil's advocate here, but he could have been like, well, maybe it's the department. And then he goes to another department. He's like, nope, it's law enforcement. So
then he's just not very bright. I mean, all the cops know what all the departments are paying. They all talk to each other.
Yeah.
Incarnation Art, $10 super chat. Thank you very much. Says the cross-examination proved that men can get pregnant. Well, it proved they can try. He's clearly trying. All right, I think that I'm all caught up on those. Let me take a look at my the member dashboard here. Let's see. Thomas says, Andrew, you and Steve are Rakaita's best panel guests. Well, Jeff is also awesome.
Yeah, what am I?
Charlie says you invited lawyers. You invited lawyers you like, so no Natalie then. No, I would not have Natalie. I only invite good lawyers. Let's see. Someone told me about the trial. Someone saying Mace is not neurological. I've never heard Mace described as a neurological agent, but if the defendant used that phrase, it's, you can talk about it. He may just not know what he's talking about. Be curious to hear how the purchase of the ranch factors in. Well, it could factor into this case as a motive for the dispute that led to all this. Maybe they were arguing over the price or conditions or whatever. Let's see. How long has he been living on the property? Is it possible he was technically a tenant? Well, I don't do tenant law, but I would certainly, if he's living there at all, if he was in a tent, I would count the tent as his dwelling on the property if he's there by permission.
Well, prior to criminal law, I did 6 years in civil litigation, and I did a lot of landlord-tenant law.
Mm-hmm.
So looking at from a Florida law perspective, If he was allowed to live in that place to try it out, he is at least a tenant at sufferance and has right of possession. So therefore, he was a legal occupant, and the stand your ground and castle doctrine would apply to him as a tenant of that property, and that would be applying Florida law. So I'm not sure of what New Mexico law is, but yes, the fact if he's got permission, he's living there. In order to get him out, you have to evict him.
And so some of these questions will be cleared up with the next witness, who is the real estate agent.
Ah, interesting. Yes.
So
look at Jeff's got the insights.
Okay. Someone says, why was Cummings, the defendant here, attaching a scope on a loaded gun? Some of that may just be the terminology of the lawyer describing it. I mean, he may have already installed the scope when it was unloaded and then put a fresh magazine in the gun. I mean, and she's saying, well, that's why the gun was in his room, because he had been putting a scope on it. On the other hand, not everyone knows all that much about guns. It's not hard to imagine someone could be stupid enough to actually be doing mechanical maintenance or installation on their gun with a loaded magazine in it. After all, we all know a famous Hollywood actor who pointed a gun at a woman and killed her just because he didn't want to check if it was unloaded. Let's see. Considering that there's no reception in the area and Cummings had all the time in the world alone with the crime scene, I'm a little suspect of him, frankly. There's no problem with you feeling that way, but that's not evidence, right? That's just speculation. Especially in the absence of any corroborating evidence that he made any attempt to tamper with evidence or tamper with the scene or anything like that. Let's see. Joe M says, and Joe M may be former law enforcement. When you're nervous and scared, people tend to talk. When people are nervous and scared, they tend to talk. It's hard to keep your mouth shut. Yeah. People, especially if they're involved in violent events, when the cops show up, especially for normal law-abiding people, their tendency is to want to explain what happened. Normal law-abiding people are brought up to perceive the police as someone who's there to help them. Andrew, good thing you don't allow minors to be law self-defense members. Do you? God, I would hope not. It's never come up. If some minor gets a hold of a credit card, I guess I don't know how I would know. But if I found out, I would not take their money. Let's see. If I ever have to defend myself, I hope it's in New Mexico where I can hire this woman. Yeah, she's good. This second defense attorney so far is really good.
And the opening was good too, though. I mean, the team here, the defense team is doing what they need to do so far.
Yeah. So one thing I wish they would do on the opening more, and maybe you can give us some feedback on this, Steve, is but really drive home the burden on the state that this is a self-defense case. The state has to disprove, because my concern always is if you don't do this, the jury defaults to, well, do I believe it or not position. And that's a preponderance of the evidence position. And that's not where the burden is. The threshold is the state has to disprove self-defense, not by a little bit, not by a substantial amount, not by half, not even by a lot. They have to disprove it beyond a reasonable doubt. And I wish they would be more vigorous in driving this home with the jury. And then you can always add, by the way, the state's not even going to get close to that. We're not asking you to acquit our client just at that threshold, although that's the law. The judge will instruct you. We're convinced that the state won't even come close to that threshold. Just keep in mind, that is the threshold for guilt.
That's a very good point. Yeah, that would definitely have been, I would have included that a little bit more than what was done. And I would also say there was also no ask. I think that before you sit down, you say, and we ask you, the jury, once you've reviewed all the evidence, you will find that the state has not met their burden beyond a reasonable doubt. And we ask that you find our defendant not guilty. And, and then sit down. So you really want to put that ask at the end of it. It sounds stupid, but I mean, that's something that should be part of the opening also.
Yeah, no, I agree. Your duty here, why you're here, is to deliver justice in this case in the form of your verdict, and we ask that you find the just verdict in this case is not guilty. Yep, and you want to, and the reason I see, most competent defense attorneys will talk about this threshold of proof thing in self-defense cases, but they do it at the closing. And by the closing, it's too late. Everyone's made up their mind by then. You're not changing anyone's mind with the closing. You're putting the ribbon on the package with the closing. You're making it easier for them to do what they want to do anyway. But you're not convincing them with the closing. They've listened to days of testimony. All that testimony has been filtered through their preconceived idea of what the threshold is. So if you don't kind of lock that in hard at the beginning, and they did this in the George Zimmerman trial brilliantly. They actually brought out a chart,
right?
Like low evidence, high evidence. Mark O'Mara did that. I think he actually did it in jury selection, is my recollection.
That's
but man,
that chart is popular around here. That was actually in the Casey Anthony case too. That was used. And we have a chart like that in our office also. So that's a big, and the burden of proof issue, one of the reasons you really want to put it up front, aside from what you're saying, is that it's unusual. Our normal decision-making patterns are not beyond a reasonable doubt, because our normal decision-making patterns are, well, this is probably the truth and this is probably not. But we are at a different state in a jury trial. It's way skewed pro-defense, and if you don't make that clear up front, people just kind of default to their normal decision-making patterns.
Right. I mean, you can believe that 75% this defendant's guilty, and that's not enough to convict him criminally. I think it just needs to be driven home. And yes, folks, we're going ahead. We're not stopping. I'm going for probably go all day on this. We're going to start now with the next day's testimony, which continues with that officer. He's back on the witness stand for the next day.
And the Casey Anthony, what the chart we're talking about is one that talks about likely, most likely, probably did it, the burden of proof argument, and the beyond a reasonable doubt is at the top, and there's like 20 other options that are all reasonable doubt. I'm going to take a quick break here.
Sure thing, Steve. Okay, so now we have the following day. This is yesterday's testimony now, so we're catching up. The same officer we just heard is back on the witness stand for more fun at the hands of this defense attorney and cross-examination. So here we go.
That's a really involved nameplate the judges got there.
Good morning, Mr. Walker.
Good morning, ma'am.
I'm going to play you a portion of the audio recording that was played in court yesterday. So it's the 5-minute portion of your audio recording. Okay, I'm not going to play the whole 5 minutes.
She doesn't have a hairbrush either.
I'm going to start
None of them do.
Counsel
Jeepers.
at 1 minute 5 seconds. Let's see if I've got my volume right. Bear with me here for technical issues.
Yeah, I'm going to plan to keep covering this trial, folks. So we're trying to catch up today. We're going to go through. I'll it up a little bit.
Sir, we have to follow our policies and procedures, okay?
Devastated.
Right.
That's 1 1/4 speed now.
Yes, ma'am.
All right.
How many cats do you think?
Now, after we broke for the day yesterday, did you have an opportunity to review the
Over
entire
under
audio
5.
recording?
Yes, ma'am.
So
My
yesterday
turn.
you testified that you left your recording device in your patrol unit when you went to clear the residence. Now that you've had an opportunity to listen to the whole recording, is that correct?
Look at him breathing.
Yes, there was a portion where I took it out of my pocket.
Look at his shoulders
I was
moving.
having a discussion with Deputy Haniasiwa, and I later made the decision to return it back to my person.
Well, let me make sure that you're understanding my question. What you testified to yesterday was that you did not take your recording device with you when you cleared the residence. You left it in the unit, right?
No, that is a mistake that I made.
Okay.
Oh,
That is what you said yesterday, but that was not correct.
That is correct.
Okay. So you didn't leave your recording device in the unit with Mr. Cummings. You took it in with you when you cleared the residence, right?
That is correct.
Okay, because we can hear you talking about what you're seeing as you're clearing the residence, correct?
That is correct. Yes,
All
ma'am.
right.
it's almost like he had a nightmare where he woke up in a straight bar.
Having listened to the entire audio recording, at any point in time, do you ask Mr. Cummings his name?
No, ma'am.
So at no point in time did he refuse to give you his name?
To my knowledge, that is correct.
Okay. And you wrote a police report related to this incident, correct?
Yes, ma'am.
And nowhere in your police report do you make any mention of him refusing to give you his name. Is that correct?
That is correct.
And not that the law required you to do this at this point in time, but just as a point of clarification, you never Mirandized Mr. Cummings. Is that right?
That is right.
Okay. Thank you, sir. I'll pass the witness.
Ms. Romo.
Oh my God, they're going to try to rehabilitate this guy?
We'll see.
Mr. Hayden, just to clarify.
Look at that hair. Oh
what
my
I believe I
God.
asked you yesterday was, were you aware of whether attempts had been made to obtain the defendant's identity? Do you recall me asking you that question?
I do recall.
Objection. I would ask to approach.
Okay.
You can't just have him change his answer now.
That's a great. These defense attorneys are on top of their game. She's approaching. She doesn't blurt out some speaking objection. She's going to get a ruling from the court outside the presence of the jury. That's the proper ethical way to do it, right there.
Right. We'll see. I don't see him walking over this judge, so that's good. He seems to be I presume that means because they recognize he's in control of his courtroom. I hope so.
And that is a very large bailiff back there.
Holy cow, he is.
He's going to eat this guy.
Godzilla. I thought he was in Korea.
Hulk smash.
Your Honor, we ask that the defense be required to use more lubricant.
A plethora of sensible pantsuits.
That would be scary, man. That is a big dude. Hodor. Hodor. That'll be his whole testimony.
So your testimony is that you never asked the defendant his identity. Is that correct?
Yes, ma'am.
Okay. And if you had asked him his identity, you would have put that in your police report, right?
Yes, ma'am.
Now, what is the purpose of a police report? And why do you do a police report?
So that way I can recall the events if I'm ever needed to testify to them.
Okay. And I know you're not in law enforcement anymore, but after the event of February 29th of 2020, did you go on other calls?
Yes, ma'am.
How many calls approximately do you think you went on?
Thousands.
Thousands. Okay. And you haven't been with the agency you testified yesterday since when?
July.
Of this year, of this
Yes,
past year? Okay. So you were also asked a question about whether you in fact asked Mr. Cummings about whether or not he wanted medical attention, and he did not reply. Do you recall being asked that question by Ms. Morrissey?
Yes, ma'am.
Okay. And is that something that if you had, would that have been noted in your report?
Yes, ma'am.
And is that in your report?
To my knowledge, yes, ma'am.
Would you like to see the report to refresh your memory?
Yes, ma'am.
May I approach?
She's just making him her bitch.
Look at him shaking.
Folks, for those asking on Rumble, if you just go to the Rumble search window on rumble.com and type in law of self-defense as 4 words, when I do it, my channel pops right up.
That is in my report.
And it's in his report.
This is the state trying to rehabilitate him.
Why was it asked if he needed medical attention?
I believe he told me that he was attacked. And I always think that it's a good practice to ask anybody if they need an ambulance.
And did you personally observe any signs that he had been attacked in any way?
No, ma'am.
Describe so we can have a better idea. There was a lot of discussion between you and Ms. Morrissey yesterday back and forth about dispatch and your, I guess your response, not responses, but your ability to hear dispatch and what was being told. Can you give us an idea of how the radio reception was out there?
The topography, I guess you could say the geography out there, you're going through valleys and canyons. So just depending on where you're at, you might have radio reception, you might not. It just, I mean, you could have it for 10 feet and then not have it for 10 feet. So it's very patchy out there.
So before you went to the scene, did you know the identity of Mr. Cummings?
No, ma'am.
Okay, and when you got to the scene and made contact with Mr. Cummings, were there other deputies around you?
Yes, ma'am.
Can you tell us approximately how many and who they were?
2 deputies during the initial response. That would be Deputy Honey Estiva and Sergeant Crispin.
Okay. And after we broke yesterday,
I'll turn
there
on
was a lot of
captions,
discussion
folks.
about the entire belt tip. Hey, let me ask you, the 5-minute
Oh,
segment
it says
that we
unavailable.
played
Sorry.
yesterday, does that incorporate the entire interaction you had with Mr. Cummings?
No.
Okay. What other interaction was there on the entire belt tape?
So there was some discussion while I was talking to Deputy Honey Estewa. You can hear Mr. Cummings making comments. It's very difficult to make out what he was saying, but he was talking to us that there's taken out of the 5-minute section.
And you did listen to the entire,
Yes, ma'am.
and did you review the entire tape for accuracy?
Yes.
Your Honor, I would like to admit State's Exhibit 14. I'm not going to play it, but that way if the jury has any questions, so there's no inference that we're trying to hide anything.
Well, from an evidentiary standpoint, you can't because it's full of inadmissible hearsay.
Yeah.
So I understand what you're trying to do, but it is full of hearsay from this gentleman, from the other deputies that were on scene. If they're going to testify, they need to come into the courtroom and testify. They can't testify through that audio recording.
Right on.
Yep.
Your Honor, she opened the door by making an inference to the jury that the state was trying to hide something by not playing the entire.
Nope. Nope.
Good
I'm sorry, I
judge.
couldn't hear you. Okay, thank you. I just couldn't hear you.
Mr. Walker, you did enter the entire unredacted.
Your Honor, we'd like to admit all audio ever
Yes, ma'am.
recorded.
Thank you.
May this witness be permanently excused. Ms. Romo.
Yes, sir.
Ms.
It's hard for me to imagine that I would want to call him back, but I'm going to reserve him. He certainly doesn't need to stay in Sandoval County.
Okay, Officer, you're excused. You may be subject to recall.
It's hard for me to imagine the prosecution want to call him again anyway.
Right.
We want to get rid of this guy.
This is pretty much a one-night stand, Your Honor.
State may call your next witness.
State calls Jonathan Christine.
Yeah, we look at that deputy up there, that bailiff.
Oh, I thought the real estate agent was second. Did I miss this guy?
She gave the defense a little side eye. Yeah, that bailiff. They must have closed every all-you-can-eat buffet in that town.
The Simpsons buffet episode. Does this look like a man who's had all he could eat?
What they're going to do is they're going to obviously they're going to try to parade a lot of victim shooting bloody pictures and create as much sympathy for the victim as they can. And, you know, with showing the dead body and somebody's got to pay. And here's the guy that shot him.
Yep.
Yeah.
Okay. Are they got a, is this next witness in Colorado? What's going on, folks?
One of the other things too is I don't know if you remember, Andrew, when you interviewed Rosemary Peoples about her self-defense. She's our lead capital defense attorney in our office, and she's great. And she did a self-defense case where she looked for people with concealed weapons or concealed weapon adjacent people on jury selection. I think that's what they need on this jury, because if you have a bunch of people that are unfamiliar with firearms, then they're going to want to they're going to wave the AR-15 and look at point the gun and
point to the jury.
You're going to pull a binger and just
right. So if you have people that are uncomfortable with firearms on the jury, that's a problem. So you want people who have some knowledge and comfort level with firearms.
Okay, my memory is refreshed. The guy they were going to call, they started late, and the guy is still late to a late trial. So they have to call a witness out of order.
Oh, I see. Okay.
I don't know if order is going to help the state in this case.
It can make it worse.
We're in the date just, folks.
I'm so jealous of you. Yeah, she's the real estate agent, and she's crying already.
Oh,
And Jeff happens to be first in line
Morning,
for
Ms.
my
Landers.
yacht master if I decide
Can you
to
hear me all right?
move that
Yes, I
along.
can.
Okay, because we have these masks on, it's a little hard to hear. So if you could try to speak up
Oh my God,
as
sad
clearly
face
as you
showed up
can
to
into the
testify.
microphone so everyone can hear your testimony, all right?
Okay.
Can you start
Wow.
by spelling your first and last name?
Christine, Chrisistine. Landers, Landers.
Ms. Landers, are you a little bit nervous today?
Just a smidgen.
Just a smidge. Okay, we'll try to relax. I think there's some water there for you if you need it, and we'll try to make it as
That's
gentle
a
as
ketamine
possible.
injection
Okay?
right there.
Ms. Landers, did you know someone named Guillermo Arriola?
Yes,
Oh, they went all.
How did you know him?
Yeah.
I'd actually.
You're
known
not calling
for
him
20 years.
Arriola
He was
anymore.
here From New Hampshire, and I had a couple of horses, and he was highly recommended. So I'd been here just a couple of years when I contacted Cedars Yard Works, which was Guillermo.
That was his business?
Yes.
And what kind of business was that? What did you hire him for?
Yard work, weeds. He had a bobcat. He would remove my manure for me. He built things for me, and of course, my husband.
The horse is not her personal manure.
But yeah, he built a lot, and he was very good at what he did, and very honest, and he showed up always on time.
Okay, for what? What's the objection?
For what? Grounds.
this is the way it should be done right here. This is very good.
Yeah.
A lot of attorneys and a lot of courtrooms could learn from this. Speaking objections are a big problem in our county. That the defense attorney or the state wants to say something, and so they speak. They say, "Well, objection, Your Honor, this is inadmissible because we all know that this is,"
Right.
and they make this thing, and then the judge doesn't matter what the judge rules because it's already in front of the jury.
Right. Yeah, a clean trial. It should always be done this way. On the other hand, if you have a weak judge and you give me the opportunity to do speaking objections, I'll do it.
Okay, Ms. Landers, you said that you hired him to do some work. You said bobcat. Now, you're not talking about the animal. You're talking about the machine, correct?
Correct.
Okay.
Correct.
And did you already say you knew him how long?
20 years.
20 years. Okay. And what is your occupation?
I'm a real estate agent.
Okay. And did you ever have any occasion to have real estate dealings with Mr. Guillermo?
Yes, I did.
Mr. Arriola?
Yes.
Okay. And specifically, did you have occasion to draw up a contract for some land purchase between Mr. Arriola and the defendant, Mr. Cummings?
I drew it up, yes.
Okay. And before we go further, let me see if I can are we on exhibit 14, I believe? 14?
She needs an emotional support animal.
Emotional support horse in the courtroom.
Little miniature pony.
It would look small next to that bailiff.
That's Guillermo. Yes.
She was so banging him.
I'll admit it.
We were in a situationship.
Okay. Is it 15?
Why don't we
Okay,
make it 15?
All right, so. And what was your, okay, first of all, how long, or did you have occasion to meet the defendant, Mr. Cummings?
Once.
Okay, and without saying anything that was said, what was the occasion of that meeting? What was the purpose of the meeting?
To go over the contract?
Okay. And was the contract signed?
No, it was not.
Okay. And do you know why?
He wanted to take it to an attorney to look at it.
But it was
A
never
horror.
It was never signed. We did not have an executed contract.
signed. Did you have an opportunity to observe the interaction between Mr. Cummings and Guillermo?
Yes.
Okay. And how would you describe their interaction? How did they get along?
I thought they got along fine.
Did you ever see them arguing?
No, I did not.
Did you know Mr. Guillermo to carry mace?
Not that I'm aware of, but I was told.
I'm sorry, I say Mr. Guillermo, I mean Mr.
I know, it's okay.
You never saw him.
I never saw it. He never showed it to me.
Okay. Did you ever see Mr.
That she was
Arriola
told.
with any sort of weapons like firearms?
Never.
So you're saying he was a woman?
And were you made aware of the purpose or why Mr. Cummings was, excuse me, why Mr. Arriola was going to his property on the 29th of February?
Yes.
And was that because you were his real estate agent?
Yes, I had talked to him
Okay.
the Friday before.
And was it your understanding that he was going out there to try to finalize the purchase?
No.
I'm going to object to hearsay.
It is hearsay.
Can I rephrase?
Rephrase.
Was it your understanding as a real estate agent?
Would you
have
agree or
the status
disagree?
of a real estate contract, correct?
Correct.
Okay. And when Mr. Arriola went out to the property, what was the status of the contract negotiations to your knowledge?
There was none
And why is that?
because there was no signed contract.
The negotiations and a signed contract are two different things.
What
Maybe.
was, how big was the property that Mr. Arriola was attempting to sell to the defendant? Do you know? If you saw the contract, would that refresh your memory?
Yes.
Okay, well, these are not.
She's going to smell it to see if she can still smell Guillermo on the contract.
You know, there's an issue here about legal, the legal status of the defendant on the property, and she can't testify, I don't think, to that. That's a legal conclusion
Right.
that I don't think she can testify to. So they need to be careful of that. I'm sure they are. This defense team's pretty on top of it, but
I know it's on some different kind of funny paper,
Okay.
but,
Yes, I recognize it.
and is that the contract that you drew up?
Yes.
Okay. What was the purchase price supposed to be?
149.
Okay, and were there any terms of payment?
Yes.
Okay,
It was $5,000 down with a balance of 144, and he was to pay $1,200 a month to be there.
and as part of that contract, was there any arrangement as part of the contract for the defendant to be allowed to live in the residence that was on the property?
No, to the best of my knowledge.
Okay.
He had a fifth wheel, and Mr. Arriola had poured a pad for him to be there.
Well, okay. So he wasn't there without consent.
And I don't see the acreage.
Hold on.
I'm sorry.
She's going to just say
You
something.
don't see any acreage?
I don't see the acreage on here. Yeah, it was, yes.
And in your opinion, how did the defendant, or how did Mr. Arriola treat the defendant?
Very well. He liked him.
Were you aware of any kind of gifts that he gave him?
A horse.
He gave him a horse?
a pony.
Do you know if Mr. Arriola had?
Not
any-
really helping you give
Just his back. He
grounds
had
for
a back
murdering
brace on when he
someone.
worked.
They're
Okay.
great friends and they gave each other horses.
You said you've known him for almost 20 years?
Yeah.
Right. The paper doesn't matter. It doesn't matter if there was nothing in this particular sales contract about staying on the property.
Sunday morning,
And
the day after.
how did you find out? Who told you?
His sister.
So were you friends with the family?
Yes, I was.
Is Mr. Cummings in the courtroom today?
I think so.
Can you?
You think
point out
so?
Or describe a piece of clothing that he's wearing?
He's wearing a blue mask and he's sitting behind the computer.
That's like everybody.
Can you tell what color his tie is?
No, I can't see it. The computer's in the way.
It looks like the record reflects that the witnesses identified the defendant. And for the record,
That's so stupid, though. I mean, why are you doing this? There he is. Get him.
That's why you're doing it.
Yeah, it's just such an old prosecutor trick.
Good morning, Ms. Landers.
Point
Good morning.
of guilt.
Now this gets interesting here.
So this is the defense lawyer who did the opening now.
Now, you just testified that you drafted up a real estate contract at the request of Mr. Arriola. Is that correct?
That is correct.
And you drafted up that contract working as Mr. Arriola's agent in this
Correct.
transaction. Please let me finish my questions, okay?
I'm sorry.
Thank you. So you were working as the seller's agent and not a buyer's agent?
Yes.
Okay. Was there a buyer's agent involved in this transaction to represent Mr. Cummings?
No.
When Mr. Cummings came in to review the contract, he reviewed it line by line, didn't he?
He took some time with it, yes.
Well, the time he took to review that contract, it annoyed you, didn't it?
No, it did not.
Aha,
Do you remember
sensitive.
an interview that you had with me and my investigator?
Yes,
back
I
in
do.
February? And do you remember during that interview, if we talked about that meeting with Mr. Cummings?
Yes.
And do you remember talking about how long it took for him to review that contract?
Boy, so all this takes more money, by the way, folks. Doing these interviews long before the trial, hopefully soon after the whatever the event is, when people's recollection is fresh, for the defense, that can be absolutely key to impeaching that witness. So suddenly they start saying shit on the witness stand that no one ever heard before, but is very damaging to the defense. Same thing happened in the George Zimmerman trial. They had a lot of witnesses who, after 18 months of hyper politicization of that case, were on the witness stand saying all kinds of shit, but they had deposed those witnesses months before and could say, well, you never said a word about that in your deposition. And it completely destroyed those witnesses.
And something that came across here, and the jury is probably going to be right on there, and it's hard to get it through a video here, but her tone, the way her demeanor changed like that.
Yeah, 180 degrees. Look at her now. She doesn't look scared now.
It was like she's crying. It's all this, and all of a sudden she gets asked a pointed question, and she's like, "No," right?
Yeah,
and the defense attorney's now got the goods, and she's going to get crushed here, if I expect, because the defense attorney knows their case. That answer is inconsistent with what she's done before. So,
right.
But
one of the reasons I mentioned the earlier interview is because those things cost money. Doing those interviews, having an investigator, doing depositions are fucking expensive, but they can make or break that case right there. But they cost a lot of money. Most of the killing cases I consult on, they go through $200,000 before they get to trial if they have the money to spend. They can easily go through that much.
It took him about 45 minutes, so yes.
And the amount of time it took for him to review that contract, it annoyed you, didn't it?
Ashton answered, Your Honor.
No, it did not annoy me.
Do you remember providing a written statement to a detective in this case?
Yes.
And do you remember in that written statement? Hold on a second, let me try to find it. Do you remember in that written statement that you provided to the detective saying, Cummings came in and proceeded to read the purchase agreement line by line? I was annoyed.
Well, now, but I don't think I was annoyed. I think I was wondering where we were going with this.
Do you remember, though, writing in your statement to the detective that you were annoyed?
I was annoyed.
Yes.
See, why do people lie like that? I don't get it.
Contract to his own attorney before signing it, didn't he?
Yes, he did.
And you.
I mean, I guess the witnesses don't know, right? Because they're brought in one at a time. But we know, watching this, we know if these defense lawyers are saying something like, and isn't it true you were annoyed? They have evidence that you were annoyed. They're not just saying that idly, and you're either going to agree or they're going to impeach you with actual evidence when you disagree. It's a trap. It's a trap.
Trap. Go away.
You refused to let him do that.
We didn't have a signed contract, and I did not know. Mr.
Yeah, she
Cummings.
refused to let him take the copy of the contract to his own lawyer. That's
because
shady.
I work for the commission also. I don't give my contracts just and let them go.
All right,
Okay,
folks,
so your answer to that was no, you would
No.
not let him take the contract
Correct.
and review it with his own attorney.
What
would you?
the heck?
Correct.
Okay.
What kind of real estate agent's that?
Yeah, well, her idea is she gets the commission. It's a proprietary document. She doesn't want him taking it off and making a copy and using it for himself or some bullshit like that.
BS, BS, BS. You know, I have my real estate license, and you know, my parents actually teach a real estate school in town. That is complete and utter garbage.
And by the way, if anyone signed a contract under those terms without being denied the opportunity to have it reviewed by counsel, that contract would be crushed if it was contested later on.
And she's like insane. I'm the seller's agent. He's not represented. He wants to review the contract, and she's not going to let it go.
She's not an impartial party here.
That's ridiculous. And she's
She offers
annoyed
an
that he's
explanation. Yeah.
All right, so folks, I forgot to crank up the volume on the trial feed, so I'm going to do that now. So you may need to adjust your overall computer volume. Sorry about that. I don't want to blow anybody's ears out, but I understand. I understand. So I'm going to crank up the volume on the court feed. You guys too, my guests, be careful if you're wearing earbuds or something. Okay, here we go.
And would you agree that he was good to Guillermo when you saw the two of them together?
I don't have an opinion about that. I know that Guillermo liked him.
And do you recall during our interview back in February of this year, when you told me that Mr. Cummings was good to Guillermo?
Okay, yes. Thank you.
classic impeachment.
Yeah.
Sigh.
It's so funny because I see this, of course, a long career happen over and over again. We have these witnesses and they develop in their mind some vision of how they think this is going to go when they're on the witness stand or when they're being deposed. I talk to so many people like, well, if I'm deposed, it's no big deal. They have this narrative in their head and they have it's like being fed into a fucking wood chipper. I mean, when good legal counsel gets a hold of you in a deposition or on cross like this, you just get whatever you thought was going to happen. Forget it, man. You better have brought tourniquets with you.
You know, the answer here is be fair, impartial, and testify factually and truthfully.
Then it's easy.
Yeah, but she's trying to she's the state. This was her decedent friend, and so she's trying to arc her testimony to I don't want to say something that'll hurt our case, right? And then she's going to get blasted because every question this defense attorney asks, she knows the answer.
And I mean, it sounds a bit crass, I believe, but the way she's crying before she even gets in, she cries when he sees the picture. I don't think this was just a real estate client relationship.
Yeah.
Okay. And before Ms. Romo objected, I had asked you, isn't it true that Mr. Cummings treated Guillermo well?
At the time I saw them together, yes.
Okay. And would you agree that Mr. Cummings was standoffish with you?
Yes.
And did you feel that he didn't trust you?
No.
No? Okay. Do you recall telling me during our interview that you thought that Mr. Cummings didn't trust you?
I don't recall that interview, but okay.
Now, you talked a little bit about the fact that you have known Mr. Arriola for 20 years.
Correct.
And it sounds like he did a fair amount of work for you.
Yes, he did.
Did the two of you ever socialize together?
No.
Okay. Did you ever go out to dinner together?
No.
Did you ever
Don't believe it.
have cocktails with him?
No.
Did you ever see Mr. Arriola when he was intoxicated?
No.
Did you ever know him to drink alcohol?
No.
Did you ever know him to use illicit drugs?
No.
Did you ever see him when you thought he was on drugs?
No.
Is his name tattooed across your chest?
Ms. Landers, prior to your
What you call him, Bobcat?
your involvement as a real estate agent in trying to negotiate this real estate contract with the defendant, did you know the defendant at all?
No, I did not.
And you were asked a question about your written statement, and I know it's been a long time since you wrote it. Have you had a recent opportunity to review it?
No, I have not.
When the defense counsel asked you about the fact that you said you were annoyed, in that statement you also said that Guillermo told you something about that as well, right? Would you like to see the statement to refresh your memory?
Yes, please.
May I approach?
This might be calling for hearsay.
One highlighter.
Oh, lost audio.
Yeah, yes, it does. He said he would have done the same thing to read it line by line.
And you're talking about the interaction. Did you indicate any, she was asking you about your feelings or the feelings that Mr. Cummings and Mr. Guillermo had towards each other? Now, did you have any long conversations with the defendant, Mr. Cummings?
No.
And she asked you, I believe, if you felt that the defendant didn't trust you. Remember her asking you that?
I remember her asking me that. I was very emotional when I was talking to her.
No kidding.
Did you ever express any feelings to Mr. Arriola about the defendant?
Yes,
And what did you say?
that
Hold on, counsel, for today.
Where's this going?
One of the things the defense did too, that they went to sidebar. There was an objection. They went to sidebar. The objection from the state was overruled. So she came right back and said, just before we got rudely interrupted, I'm going to re-ask you exactly the same question. That makes it clear that the objection was BS. And I love that technique.
That was a nice touch too. Yeah, smart.
This mask thing is really annoying, though. Boy.
What's most annoying about it?
Right now, the judge is saying, hey, you women just got to calm down, all right? Probably not. He's probably not saying that.
Wonder if they're all synchronized.
Oh. That's kind of have that vibe.
Just based on your own observations, what did you feel about the defendant in regards to this whole transaction?
Look at her demeanor flipped again.
I felt that he was taking advantage of Mr. Arriola because he didn't pay anything to be there, and Mr. Arriola was doing everything he could to get the contract. Well, how am I supposed to answer it? Sorry.
Frustrated.
You
Flustered.
made an observation that you recorded in your statement. And what was that?
You can't mind read.
No, what? Well,
No, I'll allow certain amount of reading.
would you like to look at the statement again?
Yes, please.
She's a drama queen. Like, why is she so emotional? And now she's like,
they were more than friends, man. I don't care what anybody says.
He showed up.
They were a thing.
Just what was your observation that you?
My observation was that he was not. Oh God, how do I say it?
Did you indicate that there was something strange and something was not quite right?
Correct. I did.
Pass the witness.
Okay, is there any reason why we need to possibly recall this witness from the state? Ms. Romo, can we permanently let her go?
Yeah, we should reserve her for rebuttal now.
Okay. Any objection to permanently letting this witness go?
Your Honor, we would ask to reserve her.
Okay. I'm gonna let you go, but they may call you back in the next few days, okay? They would call you if they call you back.
Thank you.
Okay? Be careful with this.
the defendant's a lot older than I thought he would be. I thought this was a young guy.
You guys got real quiet all of a sudden. On your end. Yeah. I'll bump it up a little bit.
Okay.
You didn't change anything, right?
No.
Okay.
Is the defendant, that's the defendant there. He's older than I thought. I thought he was a younger guy.
No, he used to be, I guess, some kind of world famous, helicopter mountain skiing dude.
Okay. Okay, thank you. Okay, be careful. Bye.
But yeah, that was some time ago. He's an older gentleman now.
Okay, stay. Let me call your next witness.
Call Jonathan Christine.
The JOA will be interesting. What did that witness actually establish? What's if you're to state, what did she prove? What point? What element?
There is no
Sympathy
coherent narrative or direction with the prosecution. Both of these witnesses have been disastrous.
The first one, I mean, the first one you had to call him.
Good morning,
But
sir.
what's the real estate agent ad?
Please spell and, well, say and spell your first and last name.
Sure. My first name is Jonathan, Jonathan. My last name is Crespin, Crespin.
So I've been pronouncing it wrong. It's Crespin.
It depends where you're at. Northern New Mexico, Southern New Mexico. Some people roll the R.
Well, I will pronounce it the way you pronounce it, sir. So, Mr. Crespin, where are you employed?
I'm currently employed with Sandoval County Sheriff's Office.
And what are your duties with Sandoval County Sheriff's Office?
My duties are to manage the patrol division.
How long have you been with the Sandoval County Sheriff's Office?
I've been with Sandoval County since 2018 October.
Okay, I think you might have hinted at the next question, but do you have previous law enforcement experience?
Yes, I was a former sergeant in San Miguel County, which is Las Vegas area, New Mexico area.
Okay. Were you with the Sheriff's Office there too?
With the Sheriff's Office, correct.
And any law enforcement before that?
No,
So how many years total with law enforcement?
it'll be over 7.5 years.
Yeah, that lean-in is going
And,
to be annoying.
What sort of training have you had?
That's a long question. Training as far as just similar to homicides or to,
Well, and you went to the basic academy, correct?
yes.
Okay.
Schooling, so I do have a degree in criminal justice. I do have my basic academy. Obviously, I went to the academy, my police certificate. I do have a lot of advanced certificates after that as well.
Okay.
Too many to count.
Do you have any special training in processing of scenes, scene processing, anything like that?
I do.
Okay. And what about in terms of homicide investigation?
I do.
You do. Can you tell us about that a little bit?
So I do have training in managing homicide scenes. I also have experience. I've worked homicides before. I've worked on a cold case, missing persons that turned out to be suspicious. I have a lot of experience when it comes to things like that.
Okay. Let me direct your attention back to February 29th of 2020. Were you on duty that day?
Yes, I was.
And what was were you a patrol sergeant at that time as well?
That's correct.
And on that day, did you receive a call out to go to a location somewhere near Cabazon Peak?
Yes, I did.
Can you tell us, well, tell the jury, first of all, about what time did that call come in to you?
So I was en route to that call. It was around 5:40 is when I was en route that way when the call came out.
And what was the nature of the call?
So the nature of the call came out as a possible shooting near this area.
And where were you directed to go?
To coordinates. There are some coordinates provided, so I was directed to go to those coordinates.
You said coordinates?
Coordinates, correct.
So there were no streets or highways or anything to direct you?
No, it's very rural, the area. It was nothing but desert, one house in the middle of nowhere that I observed.
And where were you? I'm sorry if you already said, but where were you when you actually received the call? Were you at the office?
No, I believe I was on patrol in somewhere in Bernalillo near 550 and 528, the major highways.
And did you receive any instructions of anyone to meet up with when you went out? You know?
With nobody else but the calling party.
Okay.
We were to meet with the calling party.
Okay. And were you given directions of where the calling party would be?
That's where I believe the coordinates were where the calling party was at.
Okay. So when you went out there, were you in a marked unit?
Yes, I was in a marked unit.
And you were wearing the uniform with your badge of office?
Yes, full uniform, displaying my badge of office, correct.
Okay. So at some point, did you meet up with the calling party?
Yes, I did. Can
you tell the jury approximately how long it took you from the time that you left Bernalillo to meet up with the calling party?
I believe it was at 6:26 is what I documented in my report when I arrived on scene with the calling party.
Okay, and how did you go out there? Did you go out there at normal speed or did you go out there?
It was lights and sirens.
Okay. So when you got there, who did you meet up with?
The first person I met with was the calling party and two of my deputies.
Okay. And from that point, what did you do?
From there, we were trying to figure out what was going on, basic who, what, when, where, why, what happened. Once we determined that a male subject was possibly shot, our main goal was to get to the property, see if we can conduct any life-saving measures. So we proceeded to the property with the calling party.
Okay. So did the calling party lead you guys out there?
Yes.
Okay. And from where you met up with the calling party, how far was it from where you met up with him to when you actually reached the residence?
It was miles. I documented 4 miles was my estimate. The reason being is he had to go to a place where he got cell phone service, and it was about 4 miles away from the property.
So when you got to the place where you met up with the calling party, was there cell phone service at that point?
Yes. At that designated location where he was originally at, yes.
Okay. And how was the cell phone service?
I had like one bar. I was lucky if I had my phone up in the air, but it did make phone calls from that location.
So it was spotty.
It was what?
Spotty, would you say?
No,
Reliable or?
it was reliable.
Okay,
Yeah.
cool. Okay, so now when you were driving out there, can you describe what kind of roads were they? Were they paved?
No, dirt road. Nothing but dirt road.
And were they maintained at all?
I mean, they were drivable, so somebody had to be out there, but yeah, they weren't that bad.
Okay.
I don't know if they're maintained.
Okay. So do you know approximately how long it would have taken you from the time that you met up with the calling party to get to the actual residence where the incident took place?
It was about a 5 to 10 minute time frame.
So when you got to the residence, well, first of all, when you were driving out there, was it dark or was it still light?
It was light.
It was still light?
Yes.
And when did it get dark? Do you recall? I mean, during the whole process, when did it get dark?
It got dark close to 10 o'clock at night, between 9 and 10 p.m.
Okay. So when you drove out there to the scene, what's the first thing that you encountered?
So when we got on scene, the first thing we encountered was
dark at 10 p.m. in February.
We were setting up a perimeter. So the first thing we encountered was Dean.
When you say Dean, do you mean Dean Cummings, the
Yes,
defendant?
yes, Dean Cummings.
And do you see him here in the courtroom?
I don't remember. No, I don't see him.
You don't remember what he looks like?
No.
Okay. How do you know that it was Dean that you encountered?
By his name, him identifying himself as his first name. was Dean.
So he gave his name. Oh my God.
Yes.
Do you recall in that report where you indicated that he refused to give you his identity?
Yes. Yes, I do.
So when did he give you the name?
Initial contact when I first met with him, when the deputies were doing a protective sweep of the property to make sure it was safe. I was trying to identify Dean.
And did he identify himself initially?
By his first name, Dean, yes.
Did he refuse to give you any other information?
I couldn't identify his name and his full name and date of birth, which I needed for our records. So that he failed to do.
Okay, so when you say you encountered him, how did you encounter him? What was he doing?
He was leaving the property in a vehicle. I believe it was a pickup truck. Right away, we gave him commands to place him in investigative detention, make sure the scene is safe. He was compliant, got out of the truck, showed us his hands. Only thing I could hear him yelling was self-defense, self-defense. We did place him in handcuffs, double lock them, check for proper fit. And placed him in, one of the deputies placed him in the back of a patrol unit, a marked patrol unit that was on scene.
So did you ask him any questions?
I did not ask him any other questions besides trying to identify him.
And why is that?
Because he was placed in investigative detention for a pretty serious allegation of murder. So our protocol and policy and procedures is to identify this individual.
To wait for the detectives?
To identify him? No, I did not.
Okay, so let me ask you, you said he was, without being asked, he was yelling self-defense, self-defense. Did he make any other spontaneous statements to you?
Not that I recall.
Did you have a chance to?
Trial's occurring right now, folks, but this testimony is from yesterday.
I did, yes.
Okay. And did you observe any visible signs of injury on him?
None.
Now, do you normally have a belt tape or a lapel cam?
Yes, I do.
Did you have one on that day?
I did, yes.
Okay, and did you enter any video or audio into evidence from that scene?
So the camera had malfunctioned. I did not. It was not
Oh my
operational.
God.
And when was the first time you realized that it had not been functioning?
When I went to go look for the video on our Vault system to download it appropriately.
When you were at the scene, and specifically when you were having interactions with the defendant, were you ever alone with the defendant where there were no other deputies around?
Yes.
Okay. And during that time, what kind of interaction did you have with him?
None other than trying to identify him.
And he gave you only his first name?
That's correct.
1 second, Your Honor.
This is just terrible.
Hey, folks, as long as we got a pause, get your free copy, real book, The Law of Self-Defense Principles. Get it for free. I only ask that you pay the shipping. lawofselfdefense.com/free book.
That took place. Did you also have conversations with another individual regarding this incident?
Other than the calling party?
Yeah.
Yeah, I spoke, the calling party did speak to me about the incident.
Okay. Anyone else?
No.
Did you get any information from anybody else?
None.
Pass the witness.
All right.
That helped the prosecution so much, didn't it?
What is going on?
Officer.
When did he identify himself? First contact.
No, literally, that was the guy that I watched that, and
Right, and you
I watched
testified
her,
that the
and I
initial
thought it
call
was like
dispatching
a
you
hostile
came in
witness
around 5:40
for the
PM, is that
prosecution. It
correct?
made no sense.
Correct.
And you were on duty at that time?
I was.
And I think you even specified that you were in a marked patrol unit wearing your uniform badge of office.
Correct.
Where were you when you first received that dispatch around 5:40 PM?
So I was stationary at the Santa Ana Police Department right off of Highway 528 and Highway 550.
All right. Santa Ana Police Station?
Correct.
Would that be in the lower district?
That's in the lower district, correct.
Okay. And so when you received this call at 5:40 PM, what did you do?
I proceeded to the location of the coordinates.
And when we're talking about you receiving this call or this dispatch, how are you receiving it?
It's via radio.
By radio?
Yeah.
This is a radio that's in your vehicle?
That's correct.
Okay. And so these radio transmissions that are coming into your vehicle, those are coming from dispatch?
Correct.
And then you can radio back to them. Is that correct?
That's correct.
And every officer has what's called a call sign. Is that correct?
That's correct.
What was your call sign at that time?
My call sign is Sam 236.
Sam, so S236.
Yes.
All right. And is there a place or a record that is created of these various radio transmissions that go back and forth?
I believe with dispatch, yes.
Okay. Would that be a CAD?
Correct.
And what does CAD stand for? Do you know?
Off the top of my head, I don't. It's a.
Have you ever heard computer aided dispatch?
That's correct.
Okay. So CAD stands for computer aided dispatch.
That's correct.
And so that would be a written report of all these radio transmissions.
Correct.
And you've seen CAD reports before, haven't you?
I have.
In fact, I mean, these are a standard record that you use in your
yes.
in your career.
Yes.
Okay. So you get the call around 5:40 PM and you start to proceed to the location.
That's correct.
How long does it take for you to actually arrive?
Whatever the time frame when I arrived at 6:26, that was how long it took me to arrive.
Okay, so 5:40 to 6:26.
Correct.
During that time, you're in your vehicle.
Yes.
You're hearing your radio.
Yes.
Okay. And would you agree then at 5:49, a radio dispatch went out indicating that the BIA, Bureau of Indian Affairs, is that what BIA stands for?
Yes.
BIA had actually received a 911 call from a man named Dean Cummings.
I didn't. That was not relayed over the radio.
Are you aware that it's in the CADs?
If it's in the CAD, it doesn't mean it was relayed to me over the radio. I did not hear it.
You did not hear it. So a computer-aided dispatch, which we just agreed is a written record of radio transmissions.
Yes.
And that includes this 911 call at 5:49 from Dean Cummings. And you never heard that?
I didn't hear that, no.
No. Okay.
I will say that everything in CAD dispatch doesn't always provide that information to us.
Oh, yeah. Okay.
So you arrive at the meeting point and you meet up with the calling party.
That's correct.
Was that David McCullough?
Yeah, that's correct. That was David. Yep.
Okay. And he relayed to you information he received from Dean Cummings.
Yes.
Okay.
No, it's a jury trial, folks. It's not a bench trial.
Then you proceeded with deputies Walker and Honey Stua over to the perimeter of this ranch?
That's correct.
Okay. Around what time did you arrive at the perimeter?
It had to be shortly after, moments later, right after we met with the calling party. I want to say about another 10-minute to 15-minute time frame after we met with our calling party.
Okay. So that would have been around 6:40.
6:40.
6:40. Okay. Now you had testified on direct exam that it would get dark around 9 or 10 p.m.
Correct.
This is February 29th.
That's weird.
Are you familiar with how the sun sets and rises in February?
Yeah. Yes, I am. So I would say more closer to 9.
Okay. So you stand by the sun setting around
No,
9 p.m.
no,
at the end.
a little bit earlier than that.
Okay.
It was dark, between 9 and 10. That's
Okay.
the way that I took it.
All right. So you think the
No.
sun sets around 9 o'clock?
I can't testify to when the sun sets at night.
Do you recall what time the sun set last night?
Actually, yes, I can.
What time did the sun set last night?
I would say that it probably set it around 8 o'clock last night.
8 o'clock. Okay. When you arrived at the perimeter of this property, was it dark or light?
It was light.
It was still light?
That is correct.
All right. And you said you saw Mr. Cummings leaving the property.
That is correct.
Leaving the property and heading towards you, is that correct?
That is correct.
Okay. So there's no allegation here he was trying to flee or
No.
evade?
No.
Okay. So he was driving right towards you?
Correct.
All right. And when he drove right towards you, he then stopped, is that correct?
That's correct.
And he got out of his vehicle
That's correct.
and he held his hands up in the air
That's correct.
and he lifted up his shirt as ordered by deputies and then he lay down on the ground.
That's correct.
All of those were instructions given by your deputy to him.
That's correct.
And he fully complied with all of those instructions.
Yes, he did.
And he was cooperative.
Yeah, yes, he was.
And he was taken into custody at that point in time?
He was placed in investigative detention at that time, yes.
So investigative detention, that means he's handcuffed, correct?
Yes.
Hands behind his back?
Yes.
And he was put in the back of a locked patrol car.
Yes.
Whose locked patrol car was he in?
I don't recall.
Was it yours?
I don't recall.
And was it at that
Yes.
point in time when he was taken into investigative detention that you asked his name?
Yes.
And what did he tell you?
He identified himself as B.
Okay. Did he tell you anything else?
No, no, he didn't.
And this was at what time?
This was initially right after we detained him. This was between 6:40 and 7 p.m.
Okay. Would 1851 sound right?
That sounds about right.
Okay. So 1851 is 6:51 p.m.?
Yes.
Okay.
yes.
I always have to do the translation. It's not natural to me.
I understand, yeah.
This is the defense team.
So it was at 1851 that he told you his first name, but not his last name.
It was a little bit after that.
A little bit, how long after?
About five minutes after.
Okay. So a little bit after 1851 would be 1855.
Sure.
Okay. Well, in the CAD, around 1855, there's no mention of him refusing to provide his identity. Why is that?
Because I didn't call it out that he was refusing to identify himself.
Well, officer, the problem with that statement is that at 1949, you do call out that he's refusing to identify himself.
That's correct.
It's almost an hour later.
Correct. That's how long I was trying to identify this individual.
Okay. So for an hour, you're sitting there asking him his name?
It was probably longer than that. It was probably about 3 hours of a time frame I was trying to identify this individual. I did ask him multiple times. He started going off, talking about other things that wasn't related. So I gave him some time to cool down, try to build a little bit report by asking him what his name was. About 10 minutes later, 20 minutes later, maybe 30 minutes later, I tried again and I just couldn't identify this individual. So
Okay.
I did finally call it out that he did refuse to identify himself.
Okay. And so if your video camera had been working, it would have captured these attempts. Is that correct?
I sure would.
Okay. And you said that you did try to run your video camera that day.
That's correct.
And in fact, you told me specifically that you remember distinctly turning it on and off several times.
That's correct.
And you expected to have numerous videos capturing your involvement in this investigation.
It was on the entire duration of the scene. And then when I met with the state police, that's correct.
Right. And so you told me you had recorded every encounter you had with Mr. Cummings, with Mr. Cummings' father.
So it was on record, and that is correct. But like I said, the camera was not operational. So it did not record any of the incident. Go figure, on a case like this, that's pretty bad.
It is pretty bad. I
Yeah.
agree. I agree with your statement. So the video camera that you have, you use this on all of your call outs. Is that correct?
That's correct.
It wasn't just special to Mr. Cummings' case.
That's correct.
And so once a week, you go in and you download all those videos from the week before. Is that correct?
That's correct.
And so you did that in this case?
That's correct.
And when you downloaded everything for that week that captures Mr. Cummings' investigation, you downloaded videos for other calls. Is that correct?
I don't recall.
Well, you told me during our pretrial interview that you did download other videos for other cases.
Okay, then it's probably so.
And so when you did your weekly download, all other calls were videotaped except for this one.
Yes, that's correct. I will say this is the one case, go figure, that my lapel
Go
camera was
figure.
not operational. That is correct.
And you weren't
The
wearing any
one
sort of, like,
case in
audio
every
recorder,
case
belt
he's
tape.
ever handled where it doesn't work.
But Deputy Walker
conveniently.
was.
I don't know. I don't know what his recording device was.
Okay. And your interactions with Mr. Cummings, those would have occurred at least in part when Deputy Walker was there. Is that correct?
I'm sorry, say that again.
That probably wasn't a very good question. I apologize. So when you first arrived at the perimeter, Deputy Walker was with you, correct?
Yes.
And if his recorder was
Slow down
running at the
audio
time,
for a second,
that would have
'cause
captured
He's coming
those
across
moments that you were also present.
rather strident, but it may
Yes.
be the
Okay.
speed. My artificial bump of the speed.
I usually watch things at 1.5, so I'm all for it.
So now
Did
it's
you
just,
conduct any sort of a search in this case?
yeah, that sounds more normal. All right, I'm
no,
gonna bump it back
not
up
that
to
I
1.25.
recall.
Okay.
She was
Did
sounding a
you
little.
go to
there.
the trailer?
Once the scene was secured by the deputies, I did, yes.
Okay. And did you see an AR-15 sitting next to the porch?
I did.
And Mr. Cummings had told you that he had put it there, didn't he?
I don't recall. I don't believe he told me that.
Okay. Did you create any diagrams in this case?
No.
Did you move anything?
No.
Did you collect any evidence?
No.
Did you use your cell phone?
No.
Did you take photos with your cell phone?
No.
Do you
Were
recall
in fact
telling me
useless?
during our interview that you used your cell phone to take pictures?
Not my cell phone, not my personal cell phone. My department issued cell phone was utilized for pictures for the search warrant.
Okay, so you did take photos using a cell phone?
With my department issued cell phone. Yeah,
Sure,
Yes.
okay.
I took it as you were asking my personal cell phone if I took pictures. No, with my department issued cell phone, I took pictures of the property for the search warrant.
Okay. And what happened with those photos that you took?
They were uploaded to our patrol server, a secured server.
What are Miranda warnings?
Oh,
Those are your rights, the Miranda rights.
Are you familiar with them?
Yes.
Did you
Well-
ever tell Mr. Cummings his Miranda rights?
No.
and that job of court bailiff.
Regarding
Kill
the
myself.
photos you took with your department issued cell phone, not your personal cell phone, your department issued cell phone, how many photos did you take?
Off the top of my head, it was very few. I want to say about 10 photos is what I took.
10 photos. You said those were uploaded to a server?
Yes.
Okay. Have you ever seen those photos again?
What do you mean again? After I uploaded them?
Like
I
again?
definitely checked again to make sure they were there. I checked last night to make sure they were there.
Okay. Because I've never seen them.
Yeah.
So I've just
Yeah.
didn't know where they were. Okay.
Whoa.
Right?
Let's move on.
Okay.
They're not the same photos that you guys
No.
asked.
Okay. All right. Thank you. I passed it.
There's a lot of issues here.
Let's just clarify, the photos that you took were used to obtain the search warrant, correct?
That's correct. It was just of the property structure, which way the door was facing.
Which were part of the affidavit for the search warrant, correct?
That's correct.
Thank you.
Yeah, everybody's
Now,
got it
you
right.
said that you
Brady
tried
violation.
for some length of time to get the defendant's identity, and he gave you his first name, but did he give you any other identifiers, like his date of birth?
He did say a date of birth that was incorrect.
Okay. Did he give you more than one date of birth?
He did kept changing his date of birth.
Okay. And Ms. Moss asked you about meeting up with the defendant's father. What was that all about?
His father wanted to speak with us. I met with his father. His father said that he was there. His son.
Why did you
Hearsay.
meet up with his father without saying what the father said?
To try and identify Dean.
Okay, thank you. Ms. Moss asked you about the fact that the defendant voluntarily stopped his truck. Do you recall one of your fellow deputies using his PA to tell him to stop his truck and get out of his truck?
Yes.
Thank you, pass the witness.
I'll allow it because he's on your witness list too, but then the state has a chance to recross that. Or you do it.
The recross has to be on the topic that was just
Officer,
covered.
you just testified
No,
on
no,
redirect that
not all
Mr.
states.
Cummings gave you a date of birth, but kept changing that date of birth.
Correct.
Do you include that information anywhere in your one-page police report?
That he
One
refused to
page.
identify himself. It should be in there.
Okay. You don't include in your police report that he gave you his first name.
To be specific, if you're asking if I'm there specifically about his first name and then the date of birth, no.
That is what I'm asking you.
No, I just put in there he refused to identify himself.
Okay, which isn't entirely true because he gave you his first name.
It is. It is true. He did hinder my investigation. To appropriately identify somebody, I need more than just a name. I do need his full name and date of birth. I need a social. I need a driver's license. I can identify him any one of those ways, which he failed to provide and disclose to me.
Okay, and you failed to put in your report any information regarding him refusing to give his date of birth.
I just put in there that he refused to identify himself.
Okay, and my question to you, again, was did you fail to put that he refused to give his date of birth in your report?
There's none of that information is in that report.
All right, thank you.
Any redirect?
One question.
Okay.
Did you indicate to the defendant what the consequences would be if he didn't fully identify himself?
I did. I told him you're about to be charged with concealing identity if I can't appropriately identify you.
Okay, I'm gonna keep this witness. He'll be subject to recall. I don't want you discussing your testimony with anyone, right?
Yes, sir.
They may call you, they may not. All right?
Yes, sir.
There's so many issues.
Yeah, it's not getting any better after opening, is it, Andrew?
Amazing.
Remember, folks,
This is why.
And because of the situation, I'm gonna need everyone to clear the courtroom, and that way we'll leave the jury here within the courtroom by themselves. So we'll take a 15-minute break, okay?
All right.
Yeah, that's weird.
I don't know where to start. I got a list here. I've been writing little stickies here of issues.
All right, well, hit us, Steve. Hit us.
Well, my first question is this subject to dismissal under a fellow officer rule? If he gave his full name to the dispatcher, and she has that information in the 911 CAD report, then to me that knowledge is imputed to these other officers, and they could do that in a dismissal motion. I don't even know why this is. I mean, I don't know what the procedures are in New Mexico, but in Florida we would do a C4 motion. Now, I would also say that prosecutors do bad faith traverses of dismissal motions and get it in front of the jury. But at this point, fellow officer rule tells me if that's in the CAD report, that's a dismissal on that charge.
Right. And the fellow officer rule basically being a rule that says if one officer has the information, it's imputed to all the other officers involved in the event.
I mean, that's the first thing. The next is that there's something called, this is a long topic, spoliation of evidence, which to me, there should be a jury instruction given that the evidence is in custody of the state. And because the evidence does not exist, there should be a presumption that it favors the defense.
Yes.
And that's a spoliation issue. That is a civil issue, but it also applies in criminal. And we deal with that all the time. The case that's close, all of a sudden the videos have been lost magically.
Right.
Another issue is the photos and non-disclosure. Now here, that's called a Richardson violation. And I know Richardson's a Florida case, but I'm sure there's similar stuff in other county or other states. And that is if this, when the defense says, we've never seen this, the court is required to do an inquiry and to see whether that non-disclosure is prejudicial. And then you go through a list of remedies. So to me, when she said, we haven't seen this, that should trigger a Richardson hearing in Florida.
Right.
The 911 call is going to be coming in. That's going to be coming in. Let's see. Oh, and so does he identify himself on the 911 call? Because I haven't heard the 911 call, but the state should bring that in. If not, the defense will bring it in and he identifies himself. That's the end of that, right?
It's curious because the state tried to play it in their opening, but they had a technical issue. They weren't able to play it. So they're prepared to play it. Maybe, preemptively, because they know if they don't, the defense will do it.
They should. I mean, why wouldn't they should put that in. But to me, that might, if he identifies himself on the 911 call, those charges are out.
And the defense said he did. The defense made that claim in their opening.
At this point, I believe the defense. Also, the issue about no observable injuries. It'll be interesting to see if they come back, because just because he doesn't, we looked at him, he didn't have any injuries, right? But when they come back and all of a sudden he's got photos of marks and scratches and things like that, all of a sudden he's got injuries. So I'd be interested if the defense comes back with that. So those are a few of the one other thing is somebody had asked, judge allowing the charge. It's tough because the state can bring things to the jury. The judge does not have control of these charges. They have to be forced it either through motion or through trial. They can't throw out a charge because the prosecutor's acting badly. So those are a few observations.
So a couple super chats. I should keep up with these because they tend to be witness specific sometimes, and we forget who the witnesses is. Let's see. Shri SR $5 super chat says, was this guy fired because of this case or did he resign? That would be the first cop she's referring to. We have no idea why he's no longer a cop. Incarnation Art $10 super chat. The cross-examination proved that men can get pregnant. I read that one already, I guess. Sunir Chris, I'm a paramedic. Oh, $10 super chat. Thank you very much. I'm a paramedic. I have worked in some very rural areas, always had CAD, always had something, and if something was out of service and not reported. This is how old I am. I worked on an ambulance crew in college, and we were lucky to have working radios.
Well, but see, the first officer said we don't have CAD, and here they're bringing in the CAD in this witness.
Right.
So they clearly have CAD. So that officer doesn't know what he's talking about.
Chris D, Steve Gosney, loving your class. That would be Steve Gosney's criminal law class as part of the law self-defense law school courses. Learn more about that at lawselfdefense.com/law courses. We got a whole bunch of law school level courses taught without the politics of law school at a fraction of the price and time commitment of law school. You might want to check that out. If you've ever wondered what it was like to be in a law school class, that's what we teach, except without the politics and cheap. Nathan C, $2. This is 100 times better with three of you. Situationship. Yeah, we're all three in a situation.
Aww.
I guess that's
I'm gonna have to make it 2. It's 5:15 a.m. here. I should probably get 4 hours sleep before I go to work.
All right, buddy. Thanks for joining us, Jeff. Take care.
Enjoy the fun.
Hey,
see you
good
soon.
to see you, Jeff. Look for your book.
I'll send you another invite for tomorrow if you can make it. Don't
cool.
feel an obligation, but just so you know, you're welcome.
All righty, super. Thanks.
Take care, Jeff. All right, let's see. Some law self-defense member comments. Mike Sullivan, Mr. Gosney's book just arrived. Another happy buyer. Not had time to read it yet, although I'm looking forward to it. Jeremy asks, did any cameras work? So far, no. Northman Firearms Training and Service says, did his camera not upload because of radio reception to the repeater tower? Good question. We don't know what the failure was in capture of the video. Let's see. That's about it. All our feeds are working, folks. So you can watch us on YouTube, on Rumble, if you don't like YouTube, which I would certainly understand, or on Twitter. I'm live streaming on Twitter at my at Law Self-Defense Twitter handle. And of course, for our Law Self-Defense members on their member dashboard. The only questions I can promise that we'll answer are either the super chats on YouTube or all the Law Self-Defense member questions, if that's important to you. All right. Let's jump ahead to the next witness. I think I have this spooled up properly. I do. Okay, here we go.
Yes, sir.
Good morning, sir.
Good morning.
Could you please state and spell your name for the court reporting?
Oh, I still have to have it over there. Okay, no worries. My name is Thomas Griffin, ThomasGriffin.
And thank you, sir. Where do you work?
I currently work at Sandoval County Sheriff's Office.
And what is your position, sir?
I am the Detective Sergeant over Criminal Investigation Division.
And are you a full-time sworn salaried commissioned police officer?
Yes, ma'am, I am.
Tell us about your career in law enforcement.
I got approximately 16 years in law enforcement, 12 of them on the streets as a patrol deputy/sergeant. Currently now have almost 4 years as a detective/sergeant.
And have you always worked for the Sandoval County Sheriff's Office?
No, ma'am. I started my career at Taos PD. Came here, went to Los Lunas PD, Sandia PD, and here.
And your time at Taos PD and all the other law enforcement entities, is that included in the 6 years, or is that 16 years, or is that in addition to the 16
Yes, ma'am.
years?
That's all together.
Okay. And what was your assignment in 2020?
I was the detective sergeant.
How long were you in that position, sir, at that point? And
Approximately a year.
And what were your duties as the detective sergeant?
I oversee the criminal investigation division. I have 2 other detectives. On that day, I was on call.
How many detectives does the Sandoval County Sheriff's Office have?
Currently 1, but besides me, but we're slotted for 2 other positions.
What kind of training have you undergone?
I have large quantities of training, probably 700 and something hours of advanced training.
Have you done any trainings related to homicide investigations?
Yes, ma'am. Criminal
About
investigations on both homicide and suicides and documenting the scenes.
How about training on
Now, I'm going to ask
maintaining
some,
video
County Sheriff's Office
cameras?
before, I'm just going to ask some background questions about your department. In February 2020, did the deputies have belt tapes or body camera videos?
Some had belt tapes, some had body cam. They kind of ran both depending on who, because a lot of deputies bought their own at the time because the department didn't have enough cameras.
Okay. And if you know, in February 2020, did the deputies have a computer-aided dispatch system in their vehicles?
No, ma'am, they didn't have CAD, I don't believe. We were still running the old system.
What's the old system? What does that mean?
It was a different system where we had to document everything from the car, but it wasn't linked to dispatch in any way.
Okay, so was it just over the radio then?
Everything was dispatched through the radio.
And then there's maybe some operator somewhere keeping notes of what is being transmitted
Yes,
over
ma'am,
the
that
radio?
would be the dispatch.
Okay. Let's talk about February 29th, 2020. Were you on duty at about 1740?
I was on call, so they called me out for that. So at that time, I was notified.
Okay. And what time was that?
Approximately 6:30, I believe.
And what were your duties on that date?
I was on call as the on-call deputy, or detective, rather.
Okay. So tell me what happened.
I was notified of a possible shooting by Lieutenant Tomlinson and given grid coordinates for the location due to its remote location. So from there, took me approximately 1 hour to get to the general area just because it's so dark out there. After dark, there's no way to find your way unless you know exactly where you're going.
Do you remember what time it got dark that day?
I don't know. It was dark when I got there. So
Okay. What time did you arrive, sir?
an hour later, so it'd be 7:30ish.
Okay. And you said you were dispatched based on GPS coordinates?
Yes, ma'am. They give me the general location, GPS location, but then the deputies would meet me and bring me in.
Okay.
Just because it's easy to get lost after dark.
Can you tell or describe to the jury what it was like driving out there on that day?
It's dark. I mean, extremely dark. There's no lights. This is Cabazon Peak. If any of y'all have been there, it's pretty remote in itself. The residence is approximately 1.5 miles, I believe, from there, further into the mesa. On all the sides, there's hills, part of the mountain, the peaks, so much. So there is no light sources whatsoever out there. So at night, it's dark.
And what were the roads like?
Dirt, bumpy ruts from arroyos, so on.
Okay. Before we talk about your observations when you arrive on scene, sir, can you tell us about some of the difficulties you had in communicating when you were out there?
Due to its remote location, radios didn't work very well. Handhelds didn't work at all. That means your handheld radios, so they didn't. So only car radios would be able to get out. Cell phones on scene were non-existent pretty much.
So how were you able to relay messages to dispatch?
Somebody would have to leave scene, drive up the road to approximately the Cabazon Peak area, which is 1.5 miles to call.
Okay, so if you needed to talk to dispatch, you would have to send someone 1.5 miles down the road.
Correct.
To call. And would you call by cell phone?
We'd call by cell phone. Yes.
Did your radios in the cars work on site?
Some of them did, some of them didn't. I think it just depended on where they were located.
Nothing worked.
So what time did you arrive on scene?
I got there an hour after I was dispatched, so you figure 7:30. I stopped along the way to talk to Mr. McCullough, who was the reporting party. He gave a general statement. I told him, look, somebody will interview you later. He just told us what generally happened. They got written reports, and we're going to document it.
Okay. And what deputy did you meet at that point?
I want to say that was Deputy Latham at the time.
So what happened next?
Proceeded to the scene, myself and Deputy Gutierrez, who's now Ford. We continued onto the site. She was with me for taking pictures. At the time, I didn't have a good camera. She was on duty, so I asked her to come with me. So she had a good camera on scene.
And did you guys ride two-man or were you in separate vehicles?
Separate vehicles.
Okay.
She was the traffic unit at the time.
Okay. So when you get to the scene or the residence or the ranch, what happened?
Upon arrival, I'm notified that there's one deceased male inside the house. The other one was already in the back of a vehicle being detained. He was complaining of being sprayed by some chemical and that EMS was already on the way.
Okay. How long, if you know, was it before EMS arrived?
I couldn't give you an exact answer.
Okay. And Was it the same thing for EMS? Did somebody have to meet them a couple of miles down the road and drive them to the ranch?
No, ma'am. Actually, EMS is pretty good out in the Navajo Nation. That's who it is. They know that area because that is their one area. So they go down all the roads. So they were able to make it to it.
Okay. And were you present when Mr. Cummings was evaluated by EMS?
He was in the back of the truck, so we don't get present when he's doing that due to medical purposes. So we stay back.
But you saw him get into the...
He is in the truck. The doors are open for safety purposes, but he's being evaluated, and I don't hear any of their conversations.
Okay, thank you, sir. And you were able to observe Mr. Cummings on the evening of February 29th, is that correct?
Yes, ma'am.
Did you see any injuries on Mr. Cummings?
No physical evidence was there. He wasn't red in any way. When he stepped out of the vehicle, after he's done being seen by EMS, we asked to photograph him real quick, and during which time he expressed that he was sprayed by an unknown chemical, and it was neurologically messing with his functions or something along those lines, and explained that he was sprayed by something, he'd changed clothes, and he'd washed his face before we arrived. While he was doing that, he told me that told me where he put the clothes, which was in the back of his pickup truck, and told us that he wanted us to test it for the chemical agent.
Okay. Before we move on to that, when you guys were taking photos of Mr. Cummings on that evening,
He's hiding it.
did you observe any blood or anything like that on his clothing?
No, ma'am.
Did he complain of any burns on his hands?
Not that I recall.
This is ridiculous.
What about his feet? Did he complain about any burns on his feet?
This guy did everything right as far as I'm concerned. I mean, now maybe it was self-defense, maybe it wasn't, but I don't see any of these things as being incorrect responses to the scene, to the situation, if he was acting in self-defense. But see, this typical prosecutor, everything's suspicious. Everything's like made to look so bad. Every statement is like, well, you know,
there's no right,
answer.
Never the right ammo. You use full metal jacket, you should have used hollow point. Use hollow point, you should have used full metal jacket. It's never, whatever your choice was, it was the wrong choice.
Right.
Yes,
this is the same state that has yet to charge Alec Baldwin for killing Elaine Hutchins.
I'm approaching you with what's been marked as, for against Exhibit 16.
Which is a completely open and shut manslaughter case.
And I don't understand
manslaughter case.
I don't understand the significance of it being dark or not. I don't see why that matters.
Unless the state has to excuse away some failure.
Do you recognize those?
Yes, ma'am.
To find evidence.
What are those?
These are the pictures that Ms. Gutierrez took of him once he exited the EMS truck.
Okay. And you were present when these photos were taken?
Yes, ma'am.
Do they appear to be in the same or similar condition as when they were taken?
Yes, ma'am.
Your Honor, the state moves admission of exhibits 16 through 23.
They'll be admitted.
And permission to publish?
Yes.
Notice how that every statement that he made is being presented to the jury as an admission, and it's condemning, right? So it's being used against him, even though he's saying everything right.
Yep.
But everything that you say to a cop is being used against you. And it's being made to look as bad as it possibly, even though I think everything he's saying, I don't see any problem with it. But if you're new to the first time you've ever heard this, it sounds bad, right?
16.
He's admitting.
Is this Mr. Cummings on the night of the incident?
Yes, ma'am, that is.
And this is, we can see the EMS van right behind me, is that correct?
Yes, ma'am, that is.
Did you observe any scratches, abrasions, or anything of that nature on Mr. Cummings?
Nothing that was physical. I think he has 2 little marks on his hands, unknown if they're relative, but there was no marks that would show that he was sprayed by any type of mace.
Marks?
Exhibit 17, I'm putting under the document camera. Is this a close-up of Mr. Cummings' face?
Yes, ma'am.
Did he have any swelling of the eyes or redness or anything like that?
No, ma'am, he does not.
I'm putting under the document camera space exhibit 18. And what is this a picture of?
That's a picture of his torso and legs.
I'm putting under the document camera space exhibit 19. And what is this a photo of?
That is his legs and feet.
And this is the items of clothing he was wearing when you encountered him.
That is correct.
they may be trying to establish that he didn't get sprayed by the thing, and the time that his face isn't puffy, he's not
That
reacting.
is the backside of his torso.
Or hours later now.
Right. That's the question. It's like how much time has elapsed between the incident.
What is that a photograph of?
That is a picture of his hands, and that would be the little marks on his hands I was referring to.
Can you please point to them or circle them on your screen there, sir, that you were referencing?
Just little cut marks, probably working on something. They don't appear fresh in
Objection.
any way.
Move to strike. Speculation.
I'm putting under the. I can never. Bottom. There we go. State's Exhibit 22. And what is this a photo of?
His hands again.
And State's Exhibit 23. What is this a photo of?
His palms.
Did he complain of any injuries on his palm?
Not that I recall.
So you testified that Deputy Gutierrez took these photos. What happened next while you were on scene?
Once he told us where the clothes were, we secured those. The clothes were in the back of his pickup truck. They were in the bed. And once we go to tow this vehicle, all of them would have flown out.
So, folks, during the opening, I forget now who made the argument. I think it was the defense during opening. They were describing this interaction, this physical confrontation, as involving not just a pepper spray, but also being struck. So the state here is trying to say, well, if he was struck, there's no injuries. So that doesn't, lack of evidence is not evidence, of course, but it's the argument you'd expect to make. And, I would not expect pepper spray to cause reddening of the normal skin on your face. They keep describing this as mace, and technically mace, the original mace was not pepper spray. It was a chemical composition that could cause irritation of the skin, but mace is now just a trademark of a company that also sells pepper spray. So I don't really know what he was sprayed with.
And there's something else that this witness is doing that I really dislike about cop testimony. When we're doing this, pisses off defense attorneys every time, and he's done it twice now. And that is, he's asked direct questions, and then he tags the answer with something extra to make it look like he's swaying it. Like, oh well. The first thing he said was the cuts to the hand. Those are the cuts to the hand. He says, yeah, typical like little work-related injuries. He wasn't asked that. He's volunteering that. Now he's trying to insert his opinion, right? And then another thing he just said was the clothes were in the back of the truck. Well, if we towed it, they would have just flown out. Well, what the hell is that? I mean, that's cop trying to turn his testimony against the defendant. You testify, it's direct, and answer the question. This little volunteering stuff is garbage. And to me, that's a biased cop. I don't like this kind of testimony. I'm sorry. This is the kind of thing that really pisses off defense attorneys.
Yep. I totally agree.
Yeah.
Okay.
And he'd already given us permission to test them for purposes of the chemicals. So we put those into evidence bags. They were slightly wet. They were put into paper bags so they could dry.
Okay. So why did you have to move the vehicle?
The vehicle was blocking the entranceway. It's the road's rather slim. It's got barbed wire on either side. It's to keep animals in and out of the area. Mr. Arriola was a landscaper, so he did a pretty good job with the fence. It wasn't something I could just take down so I could move stuff around.
See there? There's another one.
Out of the way so we could get other vehicles in.
Mr. Arriola he's such a good landscaper.
And
good
what
guy.
items of clothing did Mr. Cummings identify as him having worn?
He said he just put the clothes in the back, and the clothes that I found were a jacket. I believe it was camouflage in color, a whoopee, which is military for internal liner for your jacket, for the camouflage jacket, and I believe a t-shirt.
Did he ever identify any shoes that he was wearing?
No, ma'am. Not that I recall.
So let me mark these real quick. Let's back up a little bit here. Did you assist with any warrant for the residents?
I walked the perimeter and we took pictures. I say we, as in myself and Deputy Gutierrez, walked the scene and made sure that more or less to see what all I needed for the scene, just because we're in such a remote area, what I needed to facilitate it and to get pictures for search warrants.
What is a search warrant?
A search warrant's is a legal document authorizing us to go on a scene and to search the premises and to take things that are in the parameters of that warrant.
Okay, so you go and canvass the scene, you said, to get information for the warrant. What did you observe during your canvass?
Walked approximately 100 yards to the first area. There's an RV as you're walking in a parking area in a rock pit. You continue on, there's a trailer where there was a rifle leaning against the stairs that was already cleared, that had a magazine on the steps next to it. You could also see what appeared to be bullet holes coming out of the porch area.
Okay. And can you describe to the jury what the lighting conditions were like out there?
Again, we're dealing with complete dark, so we're using flashlights. I think there may have been limited lighting because there was a solar system there, so there may be lights inside, but outside there wasn't a whole lot.
And what was the temperature like?
Considering it's February, I'd say pretty cool.
Okay.
That's not an answer.
Your Honor, may I approach?
You may.
I'm approaching you with what's been marked for identification purposes as stage exhibit 24 to 28. Can you please look at those and tell me if you recognize them?
Yes, ma'am.
What is that?
That is the pictures that Deputy Gutierrez took of the white truck that was Mr. Cummings' truck that was blocking the roadway, the back of his vehicle, clothes in the back of his vehicle, the rifle leaning against the stairs, and a close-up of the magazine laying next to it.
The vehicle was blocking. The blocking.
I was present with it. I was pointing out what I needed pictures taken of.
Okay. And do they appear to be in the same condition as when they were taken?
Yes, ma'am.
Your Honor, the state moves admission of exhibits 24 through 28.
They'll be admitted.
May I approach?
You may.
And permission to publish, Your Honor?
You may.
I'm putting under the document camera State's Exhibit 24. What is that a photograph of, sir?
That is a picture of Mr. Cummings' Ram 5500 pickup truck.
Okay. And can you describe a little bit about the environment of the truck?
It's parked right in the roadway, so as you can see, the fences are to the left of it, and there's one right in front where we're taking pictures of, so it's blocking the roadway.
But they stopped him.
State's Exhibit 25. What is that a photograph of,
That's
sir?
showing the bed of the vehicle and the condition it was in.
And I'm putting under the document camera State's Exhibit 26. And what is that a photograph of?
That is a picture of the clothing that Mr. Cummings said he put in the back of it.
And are those the items of clothing that you collected?
Yes, ma'am, they are.
Okay, let's talk a little bit about the items of clothing. You indicated that, tell us about the condition of the clothing when you collected it.
They were slightly wet, like I said earlier. There was no odor to be had for any type of chemical that I could smell. We put them in bags and sealed them.
Okay. And what did you do with those bags?
They were taken back to evidence once I left scene and put into the evidence locks and vaults.
And have you ever been maced before?
Yes, ma'am.
How many times?
Probably 4 or 5 directly.
Have you been present when somebody else has been maced?
Yes, ma'am.
How many times?
Good 20. And that doesn't even include the times we spray near dogs to get them away from us.
How many times have you been present when mace was sprayed?
Probably 100.
Does it have a distinct smell?
Yes, ma'am, very chemically.
Can you please describe it for the jury?
It's a chemical smell. Depending on what type it is, it can have like almost a tangy, if you will. It has that, makes your skin just stand up instantly. It's like taking a really, really, really hot jalapeno, and how that feels. You get it just being in the room from smelling it.
And in the 100 times that you've been present when it was sprayed, has it ever gotten on anybody's clothing?
Oh, yes, ma'am.
How does that affect the clothing?
It's very strong odor. It doesn't go away. It's not something that you just wipe off. This chemical takes a while. Even if you wash it, it takes a little bit to come out.
And in the times that you were present when somebody was sprayed with mace, not a dog, but a human, what are some of the physical things that you've seen happen to people?
Reddening instantly. It's almost a chemical burn on you. Your eyes instantly start shutting. You're watering constantly. It feels like it's hard to breathe while you're getting it.
And does water affect it?
Yes, ma'am, but not in the way you would hope. It causes the chemicals to react a second time, and it's almost like getting maced again. So even if you shower, it can be very uncomfortable getting it off because it spreads.
And in your opinion, when you made contact with Mr. Cummings, did he exhibit any of those characteristics you just testified to of someone who had just been sprayed with mace?
No, ma'am.
So I'm putting under the document camera State Exhibit 27. What is that a photo of?
That is a picture of the AR style rifle that was leaning against the steps.
And is that the position in which the rifle was located?
Yes, ma'am.
And I'm putting under the document camera State Exhibit 28. What is that a photograph of?
That is a picture of the barrel with the magazine sitting on the steps that was cleared from the weapon.
Okay. Did you have any information who cleared that weapon?
I was advised that Mr. Cummings did it.
And do you guys confirm to make sure that the weapon is safe?
I did not touch that weapon.
Okay. So you go through the scene to get warrants. What happens next?
Once a warrant is received, we get permission to do it. State police was notified. Due to the homicide scenes, we have state police come out because they have better equipment. Let's be honest, they get a lot more funding. They have digital imaging and stuff like that that can actually do a better job than we can.
So is it typical for the New Mexico State Police to process scenes for the Sandoval County Sheriff's Office?
Yes, ma'am, major homicides and stuff like that.
And did you remain on scene the entire time while state police processed the scene?
Yes, ma'am.
How long did that take them?
I can't give you an exact time. I didn't leave till the next day at almost 2 o'clock, I believe.
What happened next while they're processing the scene?
They're processing the scene. We're waiting. I eventually go and make contact with them just to check on them. And they kind of walk me through what they had so far about several bullets, walls, etc.
Okay. And were any vehicles towed from the scene?
Yes, ma'am. 2 motor vehicles and a trailer.
Okay. And then after state police finished processing the scene and vehicles were towed, you said you left at about 2 p.m. the next day?
Yes, ma'am.
Where did you go after that?
To the sheriff's office. I have to put all the evidence into the evidence lockers because I signed for it. So when state police does a crime scene, they'll evaluate it, they document it, they box everything up, and then it's signed over to a detective on scene in which we put it into our evidence.
And you were the person who signed for all of the evidence?
Yes, ma'am, I was.
And where did the evidence go when you collected it?
I took it to the sheriff's office and put it in the vault.
And how did the evidence get to the New Mexico Department of Public Safety lab?
That's sent through our evidence tech.
What items were submitted to the lab? Do you know?
I do not know all the answers to that one. That would be the lieutenant who sent them.
Did you happen to bring gloves, sir?
Yes, ma'am, I got some.
Okay.
Oh, man. There's so many things going wrong here. The state has yet to show anything to disprove self-defense.
Yeah, and this absence of evidence, the burden's on them. It's like they're making a defense argument here. It's like to raise reasonable doubt.
Yeah, I don't know. We'll see what happens, but what if they don't provide any evidence to rebut a reasonable hypothesis of innocence of self-defense? It's amazing that what they're doing here, and the fact that self-defense is at issue because his statements make it an issue. So they don't even need to call the defendant for that to be involved.
Nope. Right? He doesn't have to testify. He's not going to testify, by the way. I think he's got kind of a sketchy personality background, conspiracy theories, stuff like that.
Here's another comment. This guy is typical cop. Like, we put it in the evidence vault. Right?
Right, the vault.
You know what the evidence vault was in Bunnell, Florida when I was prosecuting? It was a storage unit at a private company where the fence was like this, and you could walk between the storage. You could climb over to the storage unit to the next one over.
That was the vault.
That was the vault.
Hey, Steve, listen, I'm going to hit the head for a minute. Why don't you talk about your book, the stuff that's in it, where people can buy it. Do a quick review for yourself of the book. Take a couple minutes, and I'll be back in just a moment.
Hey, don't need to ask that twice.
All right.
Yes, and I'll have some more observations when Andrew gets back, because I do want his feedback, because he's the expert on self-defense. This is a crazy case, but If you're interested in this stuff, thank you all for listening. And I love my chatters. I used to be a chatter. I'm from the chats. So like, I love reading the chats. It's like the mosh pit of the trials. And if you want to buy my book, go to crimelaw.net. Oh, there it is. Crimelaw.net. And you can go there and buy my book, or just if you just want to donate to support my work, you can donate. But if you do buy the book, try, I'll sign it for you. And it's got lots of content. It's very much law review quality stuff on a lot of issues that are present in the criminal justice system. And it's a very in-depth analysis of very specific issues. If you go to crimelaw.net, it'll give you a summary of all the chapters that are in it. So please do, buy my book. I've only got a few more left, actually. So if you would like to get it, I've got probably maybe 25 more to go. So I'd like to sell those. Thank you all for everybody that's bought them, because a lot of people in the chats have already bought them, and I really do like that. I'm not somebody, I don't sell. I wish I was as good looking as some of these other LawTube chicks. The skin that I show ain't gonna happen, right? That's not gonna sell any books. In fact, it might frighten people off the stream. I've also started a Rumble channel, by the way, and it's only Rumble only. I'm not doing YouTube or anything else because I have a real job. So if you want to go to Crime Law with Stephen N. Gosney, I talk about music, a lot of music, law, interviews, faith. I believe in faith and my Catholic faith, and also a lot of law tips and parenting tips, and basically whatever's on my mind. So I started it out to kind of support the book, but it's turned into kind of just me ranting about all kinds of stuff. Oh, thank you. This guitar right here, this is a Martin D41. I got that because Andrew hired me to teach his crim law class. So that's what I did with all the pound of money to buy it. Isn't that cool? I love that guitar. So I love guitars. What we're going to do, let me see, what else? I could read chapters from my book. I really, Andrew Branca wrote the foreword to my book, by the way. And he's the one that inspired me. He's the one, because I'm kind of an academic egghead. My wife gets mad at me because she's the practical one, and I'm like chasing after the little silver balls of like, ooh, that's an interesting topic. Like, I've already got 2 more topics in my head that I want to put into the second edition whenever I get around to it. One is going to be a chapter on an overview of the death penalty and all the pro and con arguments about the death penalty. And the other one might be on obstruction of justice, which is, people ask me, one of the things I've striven, how's that word? I've strove to be, I don't know, whatever that word is. I attempt to be a clear writer. And these are law review articles, a lot of them. Some of them are not. Some of them are other stuff. But I work very hard in my writing to write clearly and directly so anybody can read it. It's not, grade school level stuff, but I try real hard to be clear. If you want to see me play my bass, go to Crime Law with Stephen N. Gosney, and I'm playing Iron Maiden, Rush, The Police. So I'll play my guitars. You can see me play them on there. Oh, Brittany, thank you. See, the people are so nice to me on the chats. And I'm very sensitive, by the way. So criticism is, I do listen to criticism, but I try not to. I'm trying to be a YouTube person and avoid the nasty criticisms. But anyway, thank you for all the nice love in the chats, because I am a chatter. And Andrew just brought me in here. Andrew's like making me into this YouTube guy. Let me add a couple things now that Andrew's back. Can you hear me, Andrew?
I can, Steve.
Well, so the evidence vault sounds real official. It's like, yes, we approached with the, garbage. One of the things is about, and this is well, there's a lot of issues here. First is the defense mentioned bullet trajectories and about how the bullet went through the body. My understanding of bullet trajectory evidence is basically it's inconclusive in all cases, because the dynamics of 2 bodies moving and how the bodies move and struggle and firearm shoot is very indecisive. Now, we could talk about front shots versus back shots and things like that, but because things are so dynamic, it's very hard to draw any kind of reasonable conclusion from bullet trajectory through the body evidence. So I'll be interested to see how they play that and what their experts say. But I've always found bullet trajectory evidence to be very tricky when it comes to bullets in through the body because of the way that bodies are very dynamic. Another one is this guy, this cop on the stand was talking about pepper spray, and he's talking about a full blast to the face. But from what the defense said is that he was being struck with a mace, and there was some discharge and a minor discharge. That a little bit of mace can make a minor irritation and can go away once you wash your face and everything. So right. I don't think, it's not like they're trying to make it out that he got a full blast to the face, but that's not necessarily true.
It may have been an incidental discharge as part of the impact.
Right. Or it could have been an attempt and it could have missed, and it could have gotten a little bit. I mean, they're going a little overboard with that. And I hope the defense comes back on cross on that. What do you think about that?
No, I think you're quite right, Steve. I should mention I lost one of my audio channels with you. And you were moving your arms around at the time. Just make sure you didn't loosen the plug on your system there.
Can you hear me now?
Still only one ear. The problem could be on my end.
I think I'm good here.
Oh, you're back. You're back.
Okay.
Got you in both ears now. No, I completely agree. I mean, the defendant here, there's no statement from him. He got blasted full in the face with pepper spray. That would be, tie in with this theory of they talked about the impacts with the pepper spray that could result in incidental discharge, just a spurt into the room. The pattern they showed on the rifle is kind of like a scattered spray pattern, which would be consistent with an incidental discharge of the pepper spray. And I can tell you, folks, a little bit of pepper spray in a combined area is irritating. It's in the air. Your eyes start burning, your throat starts burning right away. I was in a very, very large building one time for a shooting event, the New England Winter Nationals, for those who might do that kind of thing. And outside the building, they did a pepper spray demonstration out in the parking lot, and the wind blew the pepper spray up on the roof of this building, and it got sucked into the ventilation system. And a little spray of pepper spray was distributed through this giant building, and you couldn't stay in the building. I mean, your eyes and throat were just too irritated. So a little bit goes a long way, but it didn't cause any reddening of my skin or sustained reddening of the eyes or anything like that. But I knew there was pepper spray in the air. There was no doubt about that.
Another issue, the chat brought this up, and I'm no expert on ARs, but they're saying that this is a Sig Sauer M400, which is a piston operated, so it's not an AR, which has a blowback system where instead of a piston system. So that's sort of a ticky-tacky gun person, but it's
nobody knows. The people in court don't know the difference either. I doubt it's malicious.
Sloppy. It's sloppy, though. I mean, if the defense, they're going to have some firearm expert, I would expect, to come in and say it's an operable firearm. They should be saying this is a Sig Sauer M400, if that's what it is. And it's this loose language. I remember when every gun is a Glock 9mm. It's like prosecutors, that's the only thing they know. Glock 9mm.
Yeah.
No, it's something else. It's
right.
Let me see. The other one is lots of education. It's one of these battles that someday somebody's going to have to fight. But to me, it is improper bolstering to have the cop talk about all his training and experience. And they do it every time. Oh, I've had so much training. And I've had a lot of training too, but I don't get up there and say it unless I'm an expert.
Right. Unless it's being presented as an expert. And then have him do that. And then the opposing party can make sure that whatever his expertise is constrained to whatever's relevant to the facts. I mean, most of these cops have some kind of training multiple times a year. They could sit there for an hour talking about all the training courses, most of which would be entirely irrelevant.
But they usually get it. They usually just do a little bit of it, enough to kind of bolster credibility. But I think that it's improper. Unless it's an expert testimony, they shouldn't be allowed to do that because, you don't get a defense witness. And so tell me about how hard you've worked your whole life and how much, they object to that because it's improper bolstering. It's the same thing. If it's a non-expert cop, he should not be able to testify to that. But it's one of those things that never gets appealed because it's a minor issue. in the schema of things, and it doesn't get objected to, and blah, 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 blah. Another question is JOA. We talk about judgment of acquittal. So after the state finishes, the defense will move for JOA, which means it should be dismissed. The state has not proven its case, and there's not sufficient evidence to go to the elements. Those are routinely just dismissed. But this case is going to be an interesting one. We'll see how all the evidence plays out, but there's a lot of JOA issues here. And what the judge may do, because judges hate granting JOAs, what they will do is they will say, I will reserve ruling on the JOA. Because then if the jury comes back not guilty, they never have to make the decision. And then it comes back, and then they after it comes back. So that the judge, I don't know, it depends on the judge, though. If a judge had some courage, and this judge seems like he's got pretty good command of the courtroom so far. Of course, he hasn't been tested, but there hasn't been any problems in the courtroom procedure. But the JOA, he might just grant it. He should grant it, I think, on the evidence tampering question, especially if it's on the 911 call that the guy identifies himself. That's absurd. And there's also a requirement in a 911 call if somebody gives a false name. Now, this guy didn't even give a false name. He just didn't finish his name, right? If that does not impede the investigation, that is not a fault. That is not a chargeable offense, at least in Florida. So for that to be chargeable, it has to impede the investigation. I've heard no testimony that's impeded anything. Now, I'd like to ask Andrew, now that he's back.
Sorry, my normally reliable earbuds is giving me a hard time today.
Yes, one of the questions I have for you on the JOA, just walk us through a JOA on a self-defense case where the state has not provided any evidence to rebut self-defense. And the self-defense is an issue because he makes that statement. Those statements of the defendant are in evidence because he says, I was defending myself. So now it's at issue, so they get that instruction.
Yeah, the trouble is the state's almost always careful enough to include at least one matter of factual dispute, a 1% question of fact that the judge feels obliged now to give to the jury. And I think in many cases, it's a situation where the judge shouldn't, because no reasonable jury could find against self-defense on that sliver of evidence. But once there's more than zero evidence on an issue, the judges almost invariably want to give it to the jury to decide. And because it's, they're supposed to weigh the credibility and substantiveness of the evidence and so forth. The judge doesn't want to take on that role by himself. And of course, he's basically stripping the prosecution of their case. Judges work with these prosecutors all the time. I mean, it's just not the normal way things are done. That's why I called it earlier. This could be that unicorn case where it actually happens, because you always ask for it as a defense. Of course, you always ask and you're always denied. It's probably malpractice not to ask for it, but you never expect to get it. But maybe here it's possible if they're not careful, if the state's not careful, or if they really have so little to go on. But of course, from when you're first contemplating whether to charge, you're going to have to meet this threshold midway through the trial. So I've never seen it done myself. I'm trying to think if I've ever even read a case.
It depends on your prosecutor. We have a prosecutor that likes to charge stupid stuff. And so we get JOAs more than you would expect. I mean, our office, of course, we have 80 attorneys over 4 counties. And we have a great defense team, and we have a prosecutor who likes to charge stupid stuff and doesn't drop anything because it's statistics. So we get JOAs occasionally in our office over the breadth. But there's another thing about it. What you're saying is exactly right. If there's a conflict in the evidence, then the jury is the fact finder. But if the jury comes back, say they come back guilty, there's also an attempt something called JONOV in Florida, where the judge is now asked to weigh in as an additional juror.
Right.
And so they
could
then
be reasonable. Could a rational jury have a right? So a jury not simply swayed by emotion or prejudice or whatever. Right.
So even if he's guilty, the defense still has a shot. The judge will have to weigh in as an additional juror in that process.
Very, very rare that happens, of course, favorable to the defense.
Well,
it happens all the time. You always ask, but.
Oh, again, it's mainly because of the size of our office that I've seen that happen. We do get that occasionally. And I actually had a case on appeal that I got a new hearing because the judge refused, like, well, I'm not going to question what the jury did. And that's the wrong legal standard because they are an additional jury at that stage. And
Right.
he applied the wrong standard. So I got a rehearing based on the wrong standard. Of course, he went the other way anyway. But
yeah, JOA is judgment of acquittal. The judge is simply handing down a judgment of acquittal. It's an acquittal by order of the judge. Judgment of Andrew. No, it's not judgment of Andrew, unfortunately. That would be pretty awesome. And some different jurisdictions sometimes use different acronyms, but the underlying legal concept is the same.
Yeah, and so the secondary in Florida, I'm speaking only of Florida, is called JNOV, which is judgment notwithstanding the verdict. So it's a motion for new trial, motion for judgment notwithstanding the verdict. That's when the judge weighs in as an additional juror.
Yeah, I forget the technical manner in which the Rittenhouse gun charge was dismissed. I think it was at the end of the trial. But yes, the gun charge against Rittenhouse was ultimately dismissed by the judge. The argument to dismiss it was made when the state rested. But the judge at that point took it under advisement. It wasn't until just before the case went to the jury that he ultimately dismissed the gun charge. So it wasn't read. The jury was not instructed on the gun charge at the end of the trial. They did get the instruction at the beginning, but then they weren't instructed at the end. They would not have had a jury form for it. So it was off the table.
Yeah, something else I should plug too, and this is an educated chat group and an educated group of listeners, is that our office, we do train. If you've got somebody who's a third-year law student who wants to really learn how to be a great lawyer, I mean, Daytona Beach, our office, St. Johns County, which is St. Augustine, Flagler County, which is Palm Coast, we have a great office, and we have a team of trainers. I do a lot of the training, but we have a whole team of excellent attorneys. So if you have somebody who's a third-year lawyer or a lawyer who wants to come and have fun and be a defense attorney, then apply to our office.
Yeah, man, if you want trial experience, become a public defender.
Yeah.
Single best way to do that. You'll never get anything close to it in private practice, that's for sure.
And I'd say the best job in all of law is misdemeanor public defender. Because the facts are fun.
Low.
What?
The stakes are low. You can't
screw
up too bad.
Can't screw up too bad. And it's fun. The facts are always fun. You get the advantage because you pick the cases because you get to surprise attack the state because they're so overwhelmed. So you say, oh, I'm ready on this one and this one. And the bad ones for the defense, you just plea them out, right? And the good ones, you're picking all your good ones. And they don't get discovery. So you know what's going on because you've talked to your client. And the jury's looking, it's like, okay, why are we here for this stupid stuff, right? And so they're more likely to dismiss, or give you not guilty. So misdemeanor public defender is a lot of fun.
There you go, folks. Inside baseball right there. Now you know. All right, let me attack a couple of these super chats. Let's see. Jim Satala, $5 super chat. Thank you. He says, this case reminds me of the case of Harold Fish, also in New Mexico. The prosecutor charged him because he had a 10 millimeter pistol. It's what led to changes in New Mexico self-defense law. I'm not sure it actually led to changes in New Mexico self-defense law. I believe that the prosecution had misstated the existing self-defense law, and so it got reversed ultimately on appeal. But that was a case where Harold Fish was like hiking on a very narrow path, and he encountered apparently deranged homeless man who had a pack of dogs he kept with him, and the dogs charged at Harold Fish. Harold Fish was carrying a 10 millimeter pistol. I believe it was a Glock. Might have been a 1911 pattern. I don't remember. But he fired around into the ground, into the dirt to scare the charging dogs away. Harold Fish may have thought he was shooting at, the angry man, the attacker may have thought Harold Fish had fired at his dogs. In any case, that homeless man attacked Harold Fish. Harold Fish shot him once in the chest with the 10 millimeter, and that ended about how you would expect it to end. Harold Fish stayed on the scene, tried to provide aid, ultimately hiked out, turned himself into law enforcement, and was charged with murder in that case, and was convicted of murder. And he's an older guy, so a conviction is forever. Then he appealed his conviction. I'm sorry, I just can't remember the specific legal basis of the appeal. I believe he might even have been tried again and convicted again. I'm not sure about that. Ultimately, he was the conviction was reversed, and they decided not to charge him again. Unfortunately, I think he only lived a couple of years after that before he died of cancer. So much of the last decade of his life was consumed with this nonsense. And the prosecution did, in fact, because the appellate court even referred to it, the prosecution made a big fact out of the fact that Harold Fish had a 10-millimeter pistol.
Yeah, what's the
which
right
is
caliber?
nothing but theatrics. That has no legal significance at all. But we'll never know to what extent that influenced the jury to convict. But clearly the prosecution was going to bang that drum all day. He didn't just use a 9-millimeter, he used a 10-millimeter.
10-millimeter is even worse. Well, I prefer
deadly force, folks. It doesn't particularly matter.
I prefer 357 Magnum, actually. I think that's the best man-killing round.
It's probably pretty close ballistically to the 10, I would think. 10 might fire a heavier bullet.
I don't know. I'd have to look at the joules on that, but I've seen injuries from 357, and that's a gun. That's the best stopping round for man stopping, I would think. Now, but the problem with a lot of 9-millimeter shots that get ricocheted is that people are using like target rounds as a self-defense round.
Mm-hmm.
If you've got a 9-millimeter, you should use hollow point. You should use a self-defense round as your normal load when you go to the range and switch it out to a ball. But when you're because a 9-millimeter with a good self-defense round is perfectly adequate. But these ball rounds sometimes go right through and they ricochet and it's not necessarily. Although the first rule of a gunfight is what? Bring a gun.
Have a gun. Makes all the difference. Sean Luby, $10 super chat, says, great coverage, gentlemen. Hi, Steve. How do I purchase your book? I guess you probably just covered that as I was stepping away. Daytime and late night Branker recently is a gift that keeps on giving. Well, that's very kind of you. Shut Up, I Can Cook, $5 super chat, says, hi, Brank and Steve and all. And another $5 from Shut Up, I Can Cook. Brank and Steve, do we know why this escalated to death a gunshot? I'm lost. Been listening since you started the stream. I don't think we know why the initial argument started. I've not heard anything about that. We know that the defense claims that a verbal argument was escalated to a physical level by the victim, who they say pounded the defendant around the head with an object in his hand. The defendant then felt like he was exposed to what he calls a neurological agent. A can of mace was, in fact, found in the victim's hand. So there's good reason to believe there was some exposure in that sense. But it was being the victim of this attack with the mace, the defense says, that led to their client, the defendant, seizing his rifle. There was a fight over the rifle, and then the defendant fired. The 10 rounds were discharged, 2 of which struck the victim and killed him. Someone asked, I can't remember where now, maybe it was in the membership panel, can the rifle be a lawful defense against a pepper spray attack or a mace attack? I mean, these facts are a little more complicated. At the point the shots were fired, the men are fighting over the gun. It's a gunfight. Whoever, as the defense said in opening, whoever gets the gun lives, and whoever doesn't get the gun dies. So it's a gunfight at that point. But can resorting to a firearm ever be lawful against a pepper spray attack? Because pepper spray, we think of it as non-deadly force. A gun, of course, is deadly force. The forces need to be proportional. But the argument there that I've always made is that a pepper spray used defensively is non-deadly force. There's no reasonable expectation the person's going to suffer death or serious bodily injury. But pepper spray being used offensively, I think is different. I think it is a deadly force attack because you can have a reasonable expectation the person who's unlawfully pepper spraying you is doing it to then further their attack upon you. It's not stopping there. Certainly, my expectation would be if any cop were in a confrontation with the suspect and that suspect pepper sprayed them, the cop would just infer that the next step is going to be the suspect taking their gun and shooting them with it. We certainly see that in these taser type trials where the suspect seizes control of the taser. We had one in the Atlanta area. There's one that just got
one with a cop. the cop is struggling with a guy and the guy's trying to go for his taser.
Right.
And he shoots him.
Patrick Leoya. I just did a show on this. I can't remember now where it was, but yeah, the suspect had complete control of the cop's taser. The cop finally shot him in the back of the head. And now that cop has just been charged and it's proceeding to trial.
It's a debilitating weapon. The pepper spray or the taser can debilitate you. There's a firearm in the equation. They debilitate you and they can take the firearm. To me, that's a big problem.
So that cop's going to trial. We'll be covering that trial whenever it happens. I think part of the issue there, that was in Grand Rapids, the one I'm talking about now, Grand Rapids, Michigan. Part of the issue there, of course, it's always an issue where you have a white cop and a black suspect, which is what you had here. So you have that racial dynamic around it. And I think the shooting in the back of the head, although that's not legally relevant, if the cop's allowed to shoot you, it doesn't really matter where he shoots you. But it can be portrayed to the media like some kind of execution shot. And if that can be done in a racially energized case, then the media brings pressure onto the politicians. Benjamin Crump is involved in this case. So he's suing the city for another, whatever, I'm sure it's another $30 million. He wants as much political pressure on the politicians as possible. Politicians are happy to spend other people's money to make their political problems go away. So Benjamin Crump has good reason to believe he's going to get a big payoff here. And as long as he's ginning up all that energy, the prosecutors, who of course are really politicians too, are likely to feel compelled to bring the case to trial, if only for political reasons. That ought not be the case. Prosecutors should not be bringing people to trial for political reasons, but we all know it happens. And so I think the prospects, I think the prospects of actually getting a conviction on that officer, it should be zero on the legal merits. But as we talked about earlier, the prospects of getting convicted, if you're put in front of a jury, is never zero. It's never zero. And that's, I say it's always 10%. I'm just making that number up, of course, but it's some meaning risk.
Well,
and then you have the racial dynamic to it. And
well, a couple things. I mean, actually, I know you're saying 10%. Sadly, we have a saying in our office that even the best defense case is 50-50.
Yeah.
And I hate to say that, but people come in with such baggage and such biases, and especially when you add a racial element. Like, look at these people. Do you think that these January 6th protester people, can get a fair trial in D.C.?
Yeah.
And that's the problem. You get people coming in with all this baggage, and they know what happened, and they're going to get their pound of flesh. They're not going to judge it on the law and the facts. They're going to convict or acquit based on this stuff. Now, that's not the way the law should work. But when you get polarized politics in jurisdictions, it's a problem. I got one question for you, Andrew, too, and that is the victim here. The defense is promising that we're going to see that the victim had alcohol and cocaine in their system, and that was there any allegation about the defendant have any intoxicants, and how do you think that plays into the whole case here?
I haven't heard anything about that. It doesn't mean it doesn't exist. I believe I've read news articles about this defendant that frankly make him seem pretty off. That he was deep into conspiracy theories, that many of his friends thought he might have had some kind of psychotic or mental disorder. I presume all that stuff we're not hearing about in trial because the judge excluded it, because for all the usual reasons, character evidence, things of those sorts. So hopefully the jury won't hear about those stuff. It shouldn't be relevant to a finding of guilt here. But I don't know. No, I haven't. I mean, based on what I've read, would it surprise me if the defendant also had been on drugs and alcohol? It wouldn't surprise me at all. Two drunk guys get into a fight shouldn't surprise anybody. But I've not heard anything about it. No.
Okay.
And I'm not sure someone, frankly, listen, I have a very close friend whose name also happens to be Andrew, who might have had some personal exposure to alcohol and cocaine in his youth. And it never made Andrew feel like he wanted to get into a fight with somebody. But these drugs can affect different people in different ways.
Well, and I might have a little different, and it's all anecdotal. So this is not backed by anything but my experience. But I've done a lot of murder charges. I've seen a lot of murder charges. And I would say 75% of the murders that I've seen, cocaine is involved.
Oh,
and,
no.
And because it's usually, and the
well,
way
you're
I
in Florida, in all fairness.
That's true. Well, but what, my perception, I've never touched the stuff, nor do I want to, but people that really get into cocaine, what it does is, the way I understand it, is it burns out their pleasure centers so that they can't experience pleasure in life except through the drug. And so what happens is, any people, they have no empathy when they burn those pleasure centers out. The only pleasure they get is through the drug, and you're just in the way. And so they will just kill you so that they can get their next fix. Now, as opposed to somebody like an Oxycontin drug, when you get people who have the oxy drugs, it's instead what it does is they become in pain, and they're desperate to stop the pain. And so I've seen people holding up people and say, just give me the drugs. I don't want to hurt anybody. I don't want to hurt. Just give me the drug, because I'm desperate to heal the pain. But they retain that level of humanity, where cocaine just burns it right out of them. And that's just my observations. But I mean, it's amazing how much murder is driven by cocaine from my experience. But this is just me talking.
Yeah, interesting. Yeah, I don't have personal experience with anyone who I knew personally closely who was long-term on cocaine. It was purely recreational use.
Yeah, and like you say, it affects different people different ways. But when you see it present in so many murders, I mean, it's the stories in my head are painful, and like what people do when they're just on cocaine, they're just run right over people, little old ladies, children. No compassion, no humanity. And it's like, because they've just overdosed so many times that those pleasure centers are gone.
Right. I mean, so people not in our profession, their exposure to things like murders are often through movies and TVs and novels. And there's always like some complicated motive for killing someone.
Never.
Most murders are, it's unbelievable how petty the reason is. Sometimes there's no reason at all. It's just the most bizarre thing. An instant decision, a wrong look. It's people kill people for nothing. Yep. Absolutely nothing.
Most murders are over absolutely nothing. It's sad. It's like it's tribalism. It's like, that guy disrespected me, or you're in my area, or there's just absolute insanity. I mean, it's just very primitive. And raw emotion generally is driving these things, or they don't. I don't know. It's bizarre, but I don't think I've ever seen a case where it's like, oh, because the insurance policy, and I mean, those cases do exist, and I know of them, but I've never personally experienced them. Usually, it's nothing, like you say. And one more thing is, those people are out there. That's why you should concealed carry, and that's why you should be armed, because those people are on the street and they'll kill you over nothing. And you don't know
need a rational reason. Yeah.
Yeah.
All right. Let's go ahead and dive back into this. I should have another witness spooled up here. And folks, I'm just playing by ear how long we go with this. I guess until I get tired. I doubt it'll be past 5 o'clock my time for sure. So maybe one witness or two witnesses. It won't get us entirely through. I think we're a little more than halfway through yesterday at this point. And I'll just starting up early again tomorrow morning and try to catch up through the day that way. This trial's not important enough to kill ourselves over.
This is a great trial to watch, though. Very interesting.
I'm having fun. I was. All right, here we go. I think. Why is it? I think I did it wrong. Let me try this again. I did it wrong. Yeah, I did it wrong. Okay, here we go. It should be.
I like the fast witness testimony too. That's fun.
Here we go.
And before you take a seat, I need to swear you in. So raise your right hand. Do you swear or affirm to testify?
Walter White.
This is New Mexico.
Get close to the microphone and speak out loud.
Good afternoon, sir.
Hello.
Could you please state and spell your last name for the court reporter?
David McCullough, McCulloch.
Approach the bench.
Yes.
I'm going to take off his mask so we can feel him better.
Okay, so this guy doesn't have to wear a mask. Obviously, we're talking about a death virus here.
Good afternoon. So, Mr. McCullough, can you tell the jury what you do for a living?
I'm currently retired from the VA hospital.
Okay. And what did you do when you worked at the VA hospital?
I worked at the VA for 30 years as a physician assistant in the GU department, urology.
Okay, great. How long have you been retired?
Since the end of December 2017.
That's great. So we're going to talk about some events that happened on February 29th of 2020. Do you remember that day?
Yes.
Tell us what was going on that day.
I was out for a motorcycle ride. The area up by Cabazon is kind of pretty, and there's dirt roads that go everywhere, so I was exploring that. I drove down to a spot that's about 1 mile directly west of Cabazon Peak. And there's actually a point of interest sign right there. And I was going to read it, but there were a bunch of other people there. So I thought I'll ride on down the road some more.
Do you remember, before you go on, sir, do you
Yes.
remember about what time of day this was?
The afternoon.
The afternoon?
I'm retired. I don't pay attention to that stuff.
Okay. Please continue, sir. You said.
So I rode further down the road. The road really winds a lot, but I came to a Y intersection and it seemed to go straight. So I stayed to the right and I went down until the road dead end. Then I got the bike turned around, and as I started heading back north, off to my left, which would have been west, I could see some buildings, probably 500 yards away. And I thought I saw a man walking over there, but I was more focused on trying to keep the bike upright on this kind of rough, sandy road. I rode back up to the point of interest sign, which I wanted to read. I parked the bike and I was reading the sign. And a man drove up in a white pickup truck, and he was talking about different things. He said he owned motorcycles and he liked my motorcycle. And then he drove off, and I went back to reading the point of interest sign. And then a few minutes later, he drove back, and we talked some more. And then I looked at my watch, and by then it was getting closer to about 5 o'clock. And I was thinking I really needed to get home. I wanted to get home before dark because I don't like driving these windy dirt roads in the dark. So I started walking back to the motorcycle, and he says, "Wait a minute," and he waved me back over. And I said, "What?" And he said, "I'm in a little bit of trouble and I need some help." He says, "I just shot a man and I've tried to call the authorities, but I can't get cell service. If you have cell service, can you call them for me?" So I pulled out my cell phone and called 911 and started talking to the operator about this guy who had just told me he shot somebody. And truly, cell service was bad because the signal disappeared. Actually, it disappeared several times. The calls got cut off.
How many times do you think you had to attempt to call 911?
That's a weird
I
name.
called the first time, and then I just waited, and they called me back. But it was at least my call and 2 or 3 others.
Okay. When you the first time you encountered this male on this road, what was his demeanor like?
Well, he seemed sort of friendly. I mean, he's asking me about my motorcycle and sharing that he had motorcycles. Some of his conversation seemed a little disjointed.
Did he seem to you to be calm or upset, or can you describe his demeanor to the jury?
I guess calm, because I never much thought about it. I mean, if you're asking if was he hysterical or screaming or crying, no.
Okay. Now, the male that you encountered out there at the road, is he in the courtroom today, sir?
I honestly don't know.
Okay. And you can take a minute to look around.
I've already stipulated that this is Mr. Cummings.
Okay. Well, first starters, he has a mask on.
Yes, we all do, right?
You know, his hair is
We're at
different.
1.25 speed.
It's, sort of long and sort of straggly, and so.
Okay. Do you remember what he was wearing when you encountered him?
No. It wasn't a suit.
Okay. When you encountered Mr. Cummings, did you observe any injuries on him?
No.
So you said that he waved you back. How long of a time period did you encounter him or spend with him before he told you that he had shot a guy?
Just the whole thing, the first encounter plus the second encounter. I don't know, 5 minutes, 10 minutes. Not very long.
Was it less than an hour?
Oh, yes.
Less than half an hour?
Yes.
Um,
You know, I think about that because, like I said, I really wanted to read this point of interest. and they're not that long. So, you know, I just wanted to read it and look at the peak and then get bundled up on my motorcycle and get my helmet on and head home.
So after you called 911, actually, Your Honor, at this time, the state would request permission to publish to the jury State's Exhibit 1, which has already been admitted by stipulation.
Yeah, we stipulate.
And Mr. McCullough, I'm going to go ahead and play the 911 audio.
Okay.
Okay, here's the 911 then. Let's see if he identifies as himself by name.
What's the location of your emergency?
I'm west of Cabazon Peak.
Okay, here's on Peak. How far west?
I guess about a mile from directly west of Cabazon Peak. It's Nelson Road.
Yeah.
Okay, and off 1114?
I don't know. I hopped on the motorcycle, went for a ride.
Okay.
You know, there's a paved road that comes off 550 and it goes west.
Okay, what's going on? You lost?
So the reason I'm calling is I ran into a guy here who said he was attacked at a ranch, and he wound up pulling a gun and shooting the guy who attacked him.
Okay.
Okay, so this is the guy on the
He
stand.
can't get cell service. He asked me to call 911.
Okay. Okay, just bear with me. I'm getting all this information in the call, okay?
Yeah.
By the way, folks, I've ridden my motorcycle all over this part of New Mexico, and 99% of the time, if I had to call someone and tell them where I was, I'd have no idea how to describe that other than I usually ride with the GPS, giving them GPS coordinates. But I don't know the name of the road I'm on or what the nearest intersection is or what that peak west of me is called. I'm just enjoying the scenery. So I'm surely sympathetic with him there. Also, I see someone in the comments say, yeah, he just wanted to go on a motorcycle ride. Now he's testifying in trial. That's why I don't stop and talk to anybody.
Okay. Does it look like the other male needs an ambulance?
I don't know. Okay. I was out on a motorcycle. I stopped at the sign that Cabazon Peak, reading about the history, and this guy's truck pulls up next to me and says somebody just attacked him on a ranch down the road somewhere. and he's in a truck that's called H2O Guide Service. His license is lapsed.
Okay.
So, Mr. McCullough, is that the first call you made?
Yes.
And we can hear some talking in the background. Who was talking in the background? Do you remember?
I don't know.
Okay.
Nobody's going to ask him what kind of bike he rides? Come on.
He looks like a BMW rider to me. Or a Goldwing.
Well,
Oh, sir, it's 911 again, okay? We got disconnected.
yeah, like I said, I'm out of cab zone. I'm surprised I can make a call at all.
Yeah, when you call 911, it will run with any service. It doesn't matter which provider you're with. So I'm just going to try and stay on the phone with you as long as possible because this obviously is this is serious. So I just want to make sure that you're okay as well.
Have you tried turning the victim off?
This guy's on the other phone and he's trying to call somebody to get some help.
Okay.
So you think this guy needs
the defendant's also.
Do you see if he's bleeding or anything?
I'm sorry, what's that?
Can you see if he's bleeding or does he look okay?
The guy I'm talking to seems fine. But he says he shot this other guy.
He said he shot another guy?
Yes. Yes, he said this other guy attacked him, trying to kill him. And he pulled the gun and shot the other guy.
By the way, folks, this is why I'm always so nervous. Look at how imperfectly this officer is understanding what's going on, capturing information. This is all going to the record, and it's pretty apparent to me the dispatcher has no idea what's going on here. So just keep that in mind. Whatever you're communicating to a dispatcher, what your brain is telling your mouth to say is not necessarily what's going in his ear and getting captured by his brain. And then he's passing that information on to other officers, in this case, purely by radio, apparently. So they have to hear it. They're translating it. They're testifying, I'm going 105 miles an hour. I could barely hear the radio. The information the cops who arrive at the scene have is likely to be quite different than what you think you communicated at the start of that pipeline of information.
Okay. 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 Does he know if the other male's still alive? Or does he not know?
Do you know if the guy is alive? He says no.
He says he's dead?
Yes.
Unequivocal. Nope. It's a canoe.
Bullet in the head is usually fatal.
Okay. What kind of vehicle is he in? Is he in a truck?
He's in a Dodge Ram 5500. Big sticker on the side says H2O Guide. He said it's some sort of helicopter ski guide service. It's got
That's what the defendant was famous for, helicopter skiing in Alaska.
Okay, and are you safe, sir? Sir? Sir, can you hear me?
Mr. McCullough, was that the second call?
Yes.
And Mr. McCullough, we could hear someone talking in the background on that call. Is that correct?
Yes.
Who was that, if you remember?
I think it was Mr. Cummings.
Now I'm going to play the third audio file.
Sandoval County Police Fire and Rescue. This is Maria. How can I help you?
I've been on the phone with an officer, but I keep getting cut out because I'm.
He's going to have to tell the same story.
Okay, sir, where are you? Is it? Okay. So might be, the line's still open, but there's nothing there.
Yeah, they have a bank of 911 operators, and a lot of times they'll get multiple calls, and they'll start coordinating between them. The other thing is that the 911 operator, people saying he's slow, but a lot of times what they're doing is they're dispatching people. So they're listening, they're questioning, and then they're dispatching and typing that in the information.
Hey, sir. It's Paul calling 911.
Yeah, the phone keeps cutting out.
Okay, are you safe, sir?
Yes.
Okay. Do you know the name of the ranch where this person he shot is?
Do you know the name of the ranch? No, he says he doesn't. He says this guy's first name is Leo. Gio.
Leo or
How do you spell it? Hello?
oh, sir.
Yeah.
Do you know the name of the ranch?
No, he doesn't.
Okay. Okay, no problem. Does he know how far it is from where you are?
Yes. He's up talking to the police officer somewhere. I don't know. He's pretty shook up, but he's trying to get some help out there.
Okay, yeah, we're getting help out to you. Don't worry. But I'm just trying to make sure I can get as much information.
Yeah.
Okay.
Okay. Do you know if somebody's on the way?
We're getting people out that they're being dispatched basically since we started talking. But I would like to stay on the phone with you. Okay, just stay there. If you can turn on your hazard lights.
Actually,
What did he say?
He's asking him to turn on his hazard lights.
Do you know if he's still got the gun on him?
I'm pretty sure he does.
Okay.
What would you like?
It's a little tricky to turn on the hazards on a lot of bikes.
It doesn't mean it's a situation where police officers come out and see where the gun. What would you like him to do?
Okay, if he's got it on him, just to follow the instructions the officers tell him, and to not have it in his hands. Okay, and just to keep his hands visible.
Okay.
Just follow the instructions of the law enforcement. Whatever they advise him to do, just tell him to follow their instructions.
Okay.
Yeah, my hazard lights are easy too. I got a big button on the BMW, but it's also a good way to drain your battery. I'm presuming this guy.
And where does he know where he shot him? Was it in the head and the torso?
Let me ask you.
I hear it is way more handsome than this witness. Come on.
No.
What was this first name?
No. What's up? He's, like I said, he's talking to somebody. I don't know.
He's talking to someone else. Okay.
So.
Okay.
He's not going anywhere. I mean, he's seriously waiting.
Okay.
Just fair warning, folks. If you put profanity in your comment, it gets withheld by the algorithm.
Just stay with me because I'm also
I've got nothing against profanity per se, but
Before we move on, I just have a couple of follow-up questions.
Sure.
So in that first 911 audio, we heard you say that Mr. Cummings told you he was attacked. Can you please tell us what Mr. Cummings told you?
He said this other guy had attacked him and sprayed him with some poison. He said the poison burned his skin and burned his face and burned his eyes, and it made it difficult to breathe. He told me he thought he was going to die from this poison.
Boy, this is just establishing the defense case.
The poison?
Well, I guess the state's going to argue it must be a lie because he didn't have any visible
Did he ever
chemical
tell you
burns on his
that after
skin.
he shot the guy,
But
he
it
washed
should be
his
easy
face
enough
or
for the
shirt?
defense to explain.
Yes.
Tell us what he said.
He said that this poison that was on his skin was burning him in his eyes and face, and so he went to a water faucet, one of those outdoor water faucets with the big curved handles, and he said he got his clothes, got his shirt off, and washed all the stuff off as best he could.
And at this point, are you guys still at the Cabazon Peak sign of interest?
He told me that he wanted me to go with him back to the ranch because he wanted me to be his witness that this guy had attacked him. And I wasn't,
And you went.
witness anything like that, but I did want to see if this man was still alive. If he was still alive, then maybe there's something I could do for him. I've got over 30 years of medical experience.
Come with me if you want to end up a witness at a trial.
And alive, maybe there was something I could do. So we drove down this windy dirt road back to almost that dead end I had told you about. And we pulled in where those buildings were and parked. And we walked over to this brown mobile home and walked inside. And
Hey, sir, you ever
immediately
seen a
to the
canoe
right
before?
was a small room, and there was a guy laying face down on the floor, and he wasn't moving, he wasn't breathing, he wasn't doing anything. To me, he looked dead. He was dead. In his right hand, he had a black canister of some sort, which that's what Mr. Cummings wanted me to see, that this guy had attacked him with this canister of something.
Why do you say that Mr. Cummings wanted you to see this canister?
He said he wanted me to be a witness that this guy actually had this poison in his hand.
So let's talk a little bit about your observations of the residents. When you go to this trailer, was it still daylight?
Yeah, sort of. I mean, at this point, it must have been about after 5 p.m. And in February, that means, it was the sun was getting low in the sky. But yes, it was still daylight.
Okay. And when you enter the residence, was the doors opened or closed?
The front door was closed, but not locked. And when we walked in, the door to that bedroom where the dead guy was, that was open.
Okay. And the room, can you describe the room to the jury?
The mobile home looked like a bunkhouse. It looked like a bunkhouse that would be used at a cattle ranch where you'd have lots of folks bunking. There were bunks built out of 2x4s. You could probably sleep a dozen or so people in these bunk beds. There were some, the room to the left as you went in was a much larger room, but it was still mostly bunk beds. And in the right, there was some bunk beds, and there was a small kitchen straight ahead.
Okay. And when you went into the residence, sir, did you smell anything that smelled like poison?
No.
Were the windows open or closed, if you know?
I don't know.
Okay. The bedroom where you saw the body, was this a big bedroom or a small bedroom?
It's small. I would guess not more than 10 feet wide and 10 by 12, maybe smaller.
Okay. And did you have to like turn sideways to go into the door of the bedroom, or what was the doorway like? Was it pretty small as well?
To enter the building, the door was closed, so I had to go in and around that door to see to the doorway to that small bedroom. But that door was open. I didn't have to go around.
And did you check the mail that you saw on the ground? Can you tell us, was he face up or face down?
Face down.
Did you check his vitals or do anything like that?
No, he looked pretty gray. There was no breath, no movement of the chest. And by this time, it must have been an hour or so since Mr. Cummings had told me that he shot somebody. So he hadn't moved or anything.
Did you touch anything in that room?
No.
And when you observed the living room area part in the small kitchen that you talked about, did it appear that there were chairs overturned or any evidence that there was some sort of fight or anything like that?
Nothing obvious to me. I guess I'm not sure how to answer that because, like I said, it was very much a cowboy's bunkhouse. I mean,
where was Mr. Cummings when you went into the house?
He was with me.
Okay. Was he behind you or in front of you?
He went in ahead of me, and then he was standing to the side of me, and he was pointing out the canister in the guy's hand.
Okay. So what happened next after you?
So we left the mobile home, and he pointed out the water faucet outside where he said he had washed himself, had washed his clothes, and got the poisons off of him. And then I told him that I was going to head back to that point of interest sign to meet the police because for sure they'd never find that spot. If somebody didn't go back and lead him back, they'd never find him. And he said he'd be right behind me. I told him a few things. The first one was, I said that when the police come, do not have that gun in your hands.
So let's talk about the gun. Did he ever tell you where the gun was?
No. Wait, he said it was in the truck, but I never saw it. In fact, I still don't know what kind of firearm it was. I don't know if it was a pistol or a shotgun or what. I have no idea.
Did he say if it was in the cab of the truck or the bed of the truck?
He said it was in the bed of the truck under the clothes.
Okay. Did you then proceed out of the ranch area to meet up with law enforcement?
Yes, I left there, got back on my motorcycle and drove up, and he said he'd be right behind me. I drove back to that point of interest sign. By this time, it was definitely getting dark, and I could see the flashing lights of the police cars closer to Cabazon Peak. And so I just parked right by that sign, turned on my flashers on the motorcycle, and then I just stood sort of in front of the bike so they could see me in my headlights, and I just waited for them.
Okay. And did the man follow you?
No.
No. Okay. How long do you estimate it took for law enforcement to meet you at that sign?
From the time of the calls,
Yes, sir.
it was a long time. It was 45 minutes or an hour. It was a long time. It seemed like a really long time.
Yes, sir. So what happened next after you met up with law enforcement?
So they came to me. I handed them my driver's license because I knew they'd want that information. They asked me what happened, and I explained everything. And they said, "Well, where's the guy?" I said, "I don't know." He said he'd be right behind me, but that was 15 minutes ago. So I don't know what happened.
Did you lead law enforcement back to the ranch?
So by then there were, I think, 3 police cars, well, pickup trucks, and they put me in the back of one. And then we started down the road, and they stopped at one intersection, and they said, "Is right or left?" And I said, "Right." So they went straight down there. They stopped at another intersection. They said, "Is this one?" By then I could barely see. It was really dark. I said, "No, I think it's the next one." And I told them, "Don't worry, because at the very least, we'll go down until we hit the dead end, and then it's the next turn in up from the dead end." So we went down to the next turn off to the right, and I said, "Is this one?" And I could just barely see the reflection of the last bits of sunlight on the roof of the trailer. And I said, "Yes, this is it." So we stopped. They had their lights on. They were discussing what to do. And I mean,
maybe this is a consequence of a poor opening statement by the state, but I'm like, what are we doing here? What is this?
Well, the state actually has no case. They're going to call every witness that has anything that has saw or did anything. They're just going to throw all this evidence up there and then say it amounts to murder.
Did they place?
I mean, they're not going to fail to call this guy. If they have no case, they're going to throw this guy up there, right?
They told him to put his hands behind him.
You're right. It just, to me, it just reinforces that they have no case. I mean, the guy's not speaking to anything substantive. It's
I wrote out something for them as well.
I think
like all this time of day stuff, dark, night, light, dark. Well, I mean, they should have set out in their opening statement why that mattered if they were going to spend this much time talking about it.
10 o'clock when I left.
Well, another thing is there looks to me like they're going to say that the defendant planted the pepper spray. He actually didn't get pepper sprayed. He shot him, then planted it, and now he's trying to set it up. But can they make that argument when there's no basis for it? I mean,
there's no. Maybe that's what happened, folks. By the way, we don't know what happened. Steve doesn't know what happened. I don't know what happened. Maybe that's what happened. But in court, you're supposed to argue from evidence, and there's no evidence of that happening.
Mr. McCullough, other than February 29th of 2020, had you ever met Mr. Cummings before?
No.
Your Honor, I'll pass the witness.
No questions.
Yep. See there, boom. Good. These are great. These defense attorneys are great.
Yeah, very good. Very good. Smart play. There was nothing for them to have to cross on.
No.
His testimony was either a waste of time or helpful to the defense.
It was helpful to the defense because his first encounter with this guy, he said he was shook up.
Yes.
He was shook up, and he says, "I just shot a guy in self-defense," right? Because they're trying to say he's all calm. Remember, the cops were saying how calm he was, but this guy, his first person he encountered, he shook up. So he obviously calmed down over an hour and a half. Another question I have is the pepper spray. Did they DNA test or fingerprint the pepper spray? Because if the defendant's fingerprints are on the pepper spray, then that might be used against him, right?
Right. And would they not have mentioned that in opening?
Yeah. So it doesn't exist. So it doesn't exist.
The evidence will show that it was the defendant's, not the victim's DNA on that pepper spray, right? I mean,
Sergeant Griffin, good afternoon.
I think this will be our last witness, folks, for the day, and then we'll follow up again tomorrow. So, Steve, I'm gonna stream all day tomorrow too. You're obviously welcome. I'll send out the usual guest invites. Don't feel obligated, but just know you're welcome to come.
I appreciate that. I'm not sure. I have doctor's appointments, and I'm going out of town, and I got some issues, but I may be able to pop in a little bit.
The law self-defense community will surely miss you if you're not here, but we all understand we have other commitments.
I have commitments. Who's this guy? Is that the same?
Oh, that's
detective?
the rifle.
Oh, it's the rifle. So it's going to bring in the rifle.
The item I handed you that's been marked as State's Exhibit 29.
Same hair as the other guy, but it must be a different guy.
Looks like the same guy, doesn't it? Same detective guy?
Same hair.
They only got 3 guys in their department, so.
Oh, they handmade the box with the scope. Nice job with all the tape, guys.
Look at the evidence.
Do you recognize that item? And if you can go ahead and pick a corner and open it up, sir, and then tell us what it is.
Let's see how good the chat is, because they said it was a Sig Sauer M400. So let's see what he says on this deal.
Yes, sir.
Yeah, this is the same cop. This is the same detective.
The picture on the box is for a bolt action.
And they like, ugh.
He's gonna cut himself with those scissors. You don't have a pocket knife?
This is
oh my god!
Don't do it.
Scary. Oh my god, that's what's wrong with you? Look, he cut the glove.
Barney Fife. Oh yeah, he did cut the glove. Oh,
now comes the knife. Ah, finally. And then he's holding it like that. Jesus. How do you have fingers?
This is a danger.
Oh my god, it's like someone, it's like
Look
a
at
guy
him.
who wants to stab himself.
This is a joke. This case. Oh my gosh. The Keystone Cops here. All right.
Merry Christmas, son. Oh no, he's not
Keep it in the
done.
box and then
He's
tell
like,
us if that's something you recognize.
do you have a call sign, sir? Yes. Mac the knife. Two finger. They call me two finger.
Two Finger Joe.
Is that the item you signed for from the state police evidence people? Your Honor, the state moves to admit Exhibit 29. Permission to publish?
Right.
Somebody
He's charged
said-
for murder of a box.
Box. Yeah, that's a great one.
Item of evidence to be heard?
Guy, good job, guy.
Yes, sir.
Oh no.
More cutting.
He only became a cop because he dropped out of medical school. He's going to be a surgeon. Didn't work out. Well, that doesn't look anything like an AR.
The cop's DNA is all over the way. Why? What is going on here?
Now I got zip ties holding it in.
Okay.
It looks like the scissors, the blades are bent.
There it is.
Now that doesn't look like an M400 to me.
I don't know. What is that?
No, that's Sig makes a rifle like that. I forget what they call it. It's not an AR.
Is there anything else in that box, sir? Okay.
Okay, just Jesus Christ, dude. It's
He
it's still a
didn't even-
muzzle.
He didn't clear it.
And if you can go ahead and place the item back in the box and then put it here.
Maybe not pointed at me, please. You might not. Maybe.
Did he clear it?
I know guns. I'm a cop.
You know,
I'm sure someone in the chat recognizes the rifle. I fired that rifle when I used to train at SIG, but
bigger professionalism, bigger school of firearms maintenance.
Firearm? Okay. Is there writing on that paper? Thank you.
This is hilarious.
oh, I guess they're just introducing this stuff into evidence.
This
What
is
is
not.
that?
It is an American Eagle green tip 5.56, 45 millimeter FMJ.
Is there also a magazine? Well, we'll have you open that up. Okay, and is this label associated with this case?
Yes, ma'am.
Is the item sealed?
Yeah.
Yes, ma'am.
Can you please go ahead and open this and confirm what
No.
is inside that plastic envelope?
Here, I got something I want to show the chat. Hold on a second.
Don't show any guns, Steve. Oh, hey, dude. Hey,
Oh,
Law
hello.
Talk.
How you doing?
Sorry, if I kept you waiting, I just saw you this moment. Sorry about
No,
that.
I just was on. I was sitting there for like 10 seconds.
Hold on, Steve. Don't show any guns. Don't show any
guns.
guns.
I'm not
okay.
showing
This
Because
is a no gun show, Steve.
YouTube will freak out. Okay. Oh yeah.
Scissors.
Right. Yeah. Scissors.
If people want some good scissors, man.
Not even these.
Guns.
Guns. Hey, Law Talk with Mike. I want to thank you for inviting me on yesterday. Sorry that I missed your invitation until it was too late to be helpful. But you really brought this case to my attention. It wasn't on my radar screen at all. So I really appreciate that. And my audience may not know you. So why don't you introduce yourself?
Hi, I'm Law Talk with Mike. I thought of you right away because I got into this thing and they started with that self-defense argument. I'm like, I got to get a hold of Andrew.
I appreciate that. Very kind
of you. Into this rabbit hole.
Big law self-defense decal behind me, right? That's what gave it away.
Is the prosecution getting any better? I missed today because I had depositions and stuff.
There's nothing going on. There's no traction here at all. I mean, and again, our audience knows we've been saying all day. It's their burden to disprove self-defense beyond a reasonable doubt. They're not getting anywhere near that. If anything, the testimony of their own witnesses is corroborating self-defense.
Yeah. That's what I saw yesterday. So that hasn't changed.
We're actually watching yesterday's testimony, so I'm still playing catch up.
Oh, you're still playing catch up?
Yeah. Yep. So we're about I don't know 2/3 of the way through yesterday. So tomorrow I'll play the rest of today and try to get through all of tomorrow, skipping through the breaks and lunch and all that.
I got you.
But yeah, we're watching yesterday. So if you saw yesterday, you already saw this testimony.
Okay.
Well, the thing I was going to bring up, if anybody wants some great scissors, get these Craft Tool USA scissors, man. They're leatherworking scissors. They're expensive, but these things will cut through anything, and they're American made, and they're great. I'm so sick of those like cheap scissors that they got, and they're bending and flexing. They're dangerous. Get some good scissors. I don't know.
You need to brand them, Steve. Put those in your marketplace, Steve. People buy 5 copies of your book, they get a pair of scissors for free.
These things are expensive. They're very expensive, but they're great. They're leather. So they'll cut through leather. You can cut anything with these things. Craft Tool USA. Anyway, sorry. I don't even know why I did that, except that I'm looking at those flimsy cinders and it's scaring me. This guy's going to cut his arm off.
This whole thing is a mess. I remember this. Oh God. Andrew,
So
here's
Mike,
here's the burning question I have because I'm supposed to be in another stream here. But here's a burning question I have for you. Okay, so the idea behind this, and this isn't brought up in the trial, is that the defendant is not all there. He's gone paranoid and he's not mentally all there.
Right. So this jury doesn't know that.
This jury doesn't know that, but do they need to prove like self-defense, but does it have to be rational? Like, is it, if in his mind, if you're paranoid, maybe this is self-defense.
No, they can't claim irrational self-defense. That's not self-defense. If it's irrational, it's
That's
not.
what I was wondering about, that intent element. It doesn't matter because they aren't proving a squat as far as I can tell. But I was so we're not to that final point right now. But
everything, the state said in their opening that this is a trial about reasonableness, and in a sense, that's true. I mean, all right, folks, I'll do it again. Our 5 elements to self-defense cheat sheet. You can get it for free. lawofselfdefense.com/elements. It's just a PDF download. It's free. But these are the 5 elements that control a claim of self-defense. One of them is reasonableness, and reasonableness is like an umbrella element that sits over all the others.
Okay.
Everything that you perceive, that you decide, that you do has to be the perceptions, decisions, conduct of a reasonable and prudent person. It can't be an irrational fear of harm, for example. That's not self-defense. That's just unlawful use of force.
Okay.
But they're going to need evidence in this event that his belief was unreasonable. So, for example, if he thought he was being pepper sprayed, but in fact, I don't know, it was a medication bottle, not a pepper spray bottle. Nobody could reasonably perceive a medication bottle pepper sprayed them, right? That's just not possible. But the evidence is not inconsistent with a reasonable perception. And all this weird history stuff with this guy, the conspiracy theories and his friends thinking he's going crazy and stuff, that's all going to be, I mean, I presume that we're not hearing about it in the trial because they've already had the in limine stuff and the judges just said, we're not going to talk about that. It's character evidence.
And we didn't hear about it in the opening statements.
Right.
I'd be if I was a prosecutor, I'd be dropping that right away. Here's what we're walking into. You got to know, and laying that out.
If they were allowed, I suspect we didn't hear about it because it's not admissible.
Yeah, it all got motioned out.
Can I can I take that question and rephrase it a little bit for Andrew, because I'm doing Andrew's criminal law class, and we've been talking a lot about objective elements intents and subjective elements. So from an objective standpoint, what we're saying is that the intent is it reasonable in the totality of the circumstances under a reasonable person standard, as opposed to his subjective belief, even if that is unreasonable in the totality of circumstances.
Right.
So which is it? Is it subjective or
both.
objective?
You have to have both. So he had to have that subjective belief. He had to genuinely have a good faith belief he needed to kill in self-defense. But that belief, that subjective belief by itself is not enough. That's the belief. That subjective belief also has to be objectively reasonable, meaning a theoretical, reasonable, and prudent person in the same circumstances, with the same specialized knowledge, the same abilities or disabilities, would have shared that subjective belief. But you can't have a reasonable and prudent insane person. So if it's an insane belief, if it's an irrational belief, it doesn't qualify under the objective standard, even though the insane person had a genuine good faith belief, right? But if a sane person would not have shared that belief, then it doesn't meet the conditions of reasonableness. You lose the element of reasonableness, you lose self-defense.
Okay.
It might do something else. I mean, frankly, in that circumstance, the legal defense is not self-defense. The legal defense would be insanity. Which they're not arguing, probably because that would open the door up to all the psychiatric history, and they don't want to get that in front of the jury, obviously.
Well, but the state has already laid out a good case for self-defense. So they're going to get the instruction. All the witnesses are consistent with the story told by the defense in the opening. And the state, doesn't look to me like the state has anything that can disprove self-defense beyond a reasonable doubt. They might have a reasonable suspicion that he planted the pepper spray.
But it's like they're reversing the roles here for burden of proof purposes. I mean, the state is like saying, well, it's doubtful because of this, or this suggests contrary. But that's the kind of reasonable doubt argument that a defense raises in a criminal trial, not the prosecution.
That's why I was saying in my comments. I'm like, they've reached the level of, sure, it's plausible he did it. That's not the burden that they have to meet, though. They've got a much higher burden than that. It's possible he did it. Is not going to get it done for the state.
And as I said earlier, just a few moments ago, maybe you were already listening, but I don't know if he just murdered that guy or if it was self-defense. I wasn't there. Steve wasn't there. You weren't there, Mike. None of us know, but that's not the question. And the question also is not, do we think it's more likely than not that he killed him unlawfully or killed him in self-defense? That's not the legal question. That's how normal people approach these problems. And that's one of the reasons I'm such an advocate in these self-defense cases for the defense at opening, or even before during jury selection, to drive home to the jury what the burden is. The state has to disprove self-defense, not by a little bit, not by a lot, but beyond a reasonable doubt, and get the jury to emotionally commit to that threshold. Because if you don't do that, they'll approach this question like normal people approach any question, by a preponderance standard. Do we think it's more likely than not? And that's not the appropriate legal standard. If you wait until the end, if you wait to closing to drive that home to them, it's too late. They've already decided what they think the verdict is.
Exactly.
But they didn't do that. Defense didn't do that here. So I think.
Well, we had a mild criticism, but the defense has just been on fire. I mean, I think what you had said, Andrew, earlier was that you think that it was a political decision, and these prosecutors are now appointed to go and just try the case. They're going to throw up every witness they got. They're just going to lay it out and just hope for whatever happens. I mean, and it's a political decision, and they're just told what to do. Now, is there some political background
I can't read any minds, right? So I don't know, but I'm seeing such a paucity of evidence inconsistent with self-defense.
Yes.
This guy was not shot in the back from 100 yards away. I mean, there's scenarios where you'd say, well, shit. I mean, that's just not self-defense.
Right.
But I don't see that here. And in the absence of that, knowing what their burden is, I try to imagine what could lead them to bring this case to trial. And usually it's either political or racial or some combination of the two.
It's a strange one. I mean, they're not done yet, so they have, maybe there's something, but their opening was so mail it in weak that I'm just, and what they've been done so far, I just don't expect them to come up with anything. You'd think there'd be some. What evidence could they possibly have?
The opening sounded like it was done like in a community college moot court environment. You know, it's like, all right, so we spent the last semester talking about what opening. And they show up with their index cards and they start reading stuff, and they drop the cards, so they're all in the wrong order now. And I mean, that's the vibe I got. I'm like, is this the first time this prosecutor's ever argued a case to a jury?
Yeah,
because it had to feel to
the
it.
state will prove that this and the elements are that. I mean, it was very
Their
like
heart's
written.
not in it.
Yeah.
I mean, like the prosecutor, I saw like she could lay foundations and do things. She's not technically clueless, but she just does not seem to be care in the sense that, not in a bad way, just like, I'm walking through this. I was forced to do this trial. I don't believe in it. Here it is.
Well, they're better than Elaine Bredehoff. I'll give them that for sure.
Oh yeah.
You're right. When they're doing their direct questioning, it's proficient's too strong a word. It's technically competent. I mean, they're not just saying stupid things that don't make any sense, but it doesn't seem to go anywhere.
They don't have any case. They don't have any witnesses. They're not saying anything that gets to the issue. The issue in the case is self-defense. So
yeah, there's not a lot of leading. There's not a lot of hearsay. There's not a lot of nonsense we see in some of these trials. So they're technically competent, but it's like you can be a technically competent woodworker, but if you don't have any wood, you don't end up with very much at the end of the day.
Yep.
So, Mike, I don't want to keep you. Do you know, is this guy, I presume right now, is just introducing things into evidence, right? The rifle, the magazine. It doesn't sound like he's going to testify.
He rips his glove and he's like spreading his
when he opened the
DNA out. I mean, it's a hot mess. Points the gun at the jury. I mean,
does he really?
Yeah, we just saw that now.
But it's Keystone Cops the whole way. But all right, well, thank you for letting me crash over here. I just wanted to come over there. I was just happy, I saw your invite, and I wanted to hear your take on that.
Yeah, I appreciate that. I think this is going to be our last witness of the day here. We're just going to wrap up with this guy. I'm going to start again first in the morning. I'll send you another invitation tomorrow. If you don't consider it an obligation, I just want you to know you're welcome to hop on anytime you want, whether it's for a few minutes or longer.
Thanks.
And there's like 5 or 6 lawyers in the world that I like. So you're in the inner circle.
I like it. Thanks a lot.
If you can't make it, don't feel bad about it. But you should expect the invitation in the morning, and I'll probably be talking all day. I'm going to try to catch up totally through the end of tomorrow by the end of the day. So we'll see what happens.
That's bold. All right. Thank you.
Buddy. Take care. Bye-bye. All right, Steve, let me just see how far this guy has to go. It may not be too long.
Do you have a train going nearby?
Oh man, I just got this new office. We just signed the lease a couple months ago, and the train is 2 blocks away. The windows suck. It's like the windows are open. Yeah, but it's an actual train, and the crossing is like street level, so they got to blow their horn every time, and they go through like 10 times a day.
I was wondering what that was like. That's the second time I've heard that.
On that plastic envelope, is that an item that you also collected from the state police?
Yes, ma'am. This is the AR-1 has GPS initials and their information.
Okay. So what is inside that envelope?
There's 10 cases with a projectile and some unspent rounds.
Is there a magazine in there as well?
The magazine's on the counter. Yeah.
And
Oh, look, they gave him a whole box of gloves.
Magazine that was collected from.
I believe so, ma'am. It's in the packaging.
Okay. Your Honor, the state moves to admit Exhibit 30.
Objection.
I'm just unclear exactly what we're moving in. What I saw was just a magazine and something.
You want me to?
Yes,
say
sir.
more
Please
detail
go
on
ahead
it?
and talk about
the
each
brass, the expended brass from the rifle. So when you fire the ammo, that's the brass that comes out. There's actually the projectiles that were removed from, I guess, the wall and other stuff. And then there's the unspent rounds that were in the magazine.
How many unspent rounds are there?
7 unspent rounds.
And then is the magazine empty?
Yes, ma'am.
So where are the other rounds?
Each of these separate items, the magazine should be one exhibit. These projectiles that were extracted from the wall should be a different exhibit.
Yes, of course.
I can label them separately.
That'd be a good idea, or do a sub number such as 30A, B, C, and D, just to keep the record clean.
Yes, sir.
The judge has been pretty clean too, but he hasn't been tested.
So how many items are there, sir?
Well, maybe because they know him and they don't want to test him.
Why don't you go from 30A through 30D?
Yes, sir.
I mean, usually I see even strong judges tend to be tested by the attorneys, but then again, all these attorneys here are women. I don't know if that makes a difference. Normally, I'm seeing the judges being tested by men.
But you know, I don't really even have criticisms of the attorneys on the prosecution, like you were saying.
30D will be admitted.
The prosecutors just haven't had a case to this point, so
Yeah,
it's not that they're bad attorneys.
No, well,
As
except
far
for
as
that
their-
open.
Yeah, the
That was
opening.
bad.
Yeah. But if you don't have a case, what do you do?
Yeah. Yep. Fair enough.
Spent casing. 30C is the
Well, I guess I would say you don't bring the case, but you know they all work for somebody.
Somebody says it's a SIG 551.
Yeah. Actually, I thought it was called the SIG 556. Oh no, 551. Okay, let me take a look. Yeah, that's it. That's the gun. That's a good rifle, by the way. I fired it extensively. That's the very good rifle. It works.
Does that have an identification label on it?
Yes, ma'am, it does.
Do you recognize that envelope?
Yes, ma'am.
Is this the an item of evidence that you signed for from the New Mexico State Police?
Yes, ma'am, it is.
And is this label associated with this case?
Yes, ma'am, it is.
And is the item sealed?
Yes, ma'am, it is.
Can you please cut it open and tell us what's inside?
It's of course it's a completely different design than the AR. It bears almost no resemblance. It just happens to fire the same caliber round.
And it's black.
And it's black. Right.
And is this an item that is associated with this case?
Yes, ma'am, it is.
Your Honor, the state moves admission of Exhibit 31 into evidence.
Oh, there's the mace.
And if you could please hold that up for the jury, sir. Thank you, sir.
So was that DNA tested or fingerprint
And for
tested?
purposes of a clear record, I would
There's also a SIG 516 rifle. The distinction may be what's imported into the U.S.
And that'll be admitted.
Do you recognize that?
Yes, ma'am, I do.
They've done the
Does it
pepper
have an
spray yet?
identification label?
Yes, ma'am, it does.
That's what they brought in just now.
Okay.
And is that identification label associated with this case?
Yes, ma'am.
And is this one of the pieces of evidence you signed forth from the New Mexico State Police?
Yes, ma'am, it is.
Can you please open the envelope and tell us what's inside?
Well, this guy's nice.
Now
What?
when scissors would be appropriate, he's using a knife. Someone give him a hammer. Have him open up the envelope with a hammer.
The cap to the AR style rifle for these stuff. And it has a biohazard symbol, so it has blood on it.
Oh, it's the cap
Your
from
Honor,
the
the state moves admission of Exhibit 33.
Now, the defense made a big deal about
Sir,
the
could you
cap
please
being
hold
under
that
the
item
body.
up for the jury?
Yeah. Because if the cap was tightly on the scope for it to come off, that would suggest the struggle, right? That the
And that's also not a detail that would be planted generally. So like if you planted
Wouldn't
the,
think of
the pepper spray, people usually wouldn't think, well, I'm going to take the cap of the scope rifle, put it underneath the body.
Yep.
Right. So that's a good piece of evidence for the defense.
Your Honor, may I approach?
This guy's got some problems. He's our evidence
Does that
custodian.
item of evidence have an identification label?
Yes, ma'am, it does.
And is this label associated with this case?
Yes, ma'am, it is.
And is this one of the items you signed for from the New Mexico State Police?
No, ma'am, it is not.
Okay, tell us about this.
This one's the shirt, extra large green shirt from me, and it has mine, so it feels like mine.
Is
Yeah,
this the
I think
shirt
it's
that you
right. New
collected
Mexico
from
has
back
no
in
law
Cummings
schools.
truck?
Everyone goes to the American
Can you go ahead
Samoa
and cut
law
open that
school.
item and tell us what's inside there?
A lot of these should just be also a lot of this is just stipulated. I mean, the evidence is what it exists. There's no reason to doubt any of this evidence. So the defense has got no objections on any of it. So it should just go click, click, click. It should all be pre-marked. Yep. Now they want sometimes the state wants to they want to puff their case up.
Yep, that's what they're doing.
So they're going to make this all like, look at this, hold it up, right? And it's going to be all dramatic. So if it's just all stipulated in, it doesn't have the same like substance to it, right?
Yeah, but the state doesn't like that. This gives them a second shot to show it to the jury, right? Not just the substantive testimony component of the trial, but all this theater.
February 29th. Your Honor, the state moves admission.
They brought him better gloves.
Deputy Griffin, could you please?
He needs those fish flaying gloves, the chainmail gloves, or the oyster opening gloves.
Okay, thank you, sir.
So was any of this sent to the lab for testing? That's my question. I mean, what about the spray on the shirt and stuff? I mean, it would seem that would be testable, right?
This must be the clothes here. Hopefully it's not like the victim's head. It would be funny if the guy opened up the bag full of clothes and his eyes started tearing.
Sorry, some kind of chemical here.
Does that item of evidence have an identification label?
Yes, ma'am, it does.
I'll give you a minute to put a glove on.
What was that?
Oh my God, this guy's. Hey, dude, if the glove don't fit,
you must have quit.
Does that identification label to you appear to be associated with this case?
Yes, ma'am, it does.
Does that have your initials on it?
Yes, ma'am, it does.
Neurotoxin.
Do you recognize this piece of evidence?
Yes, ma'am.
Is this something you collected from the scene on February 29th?
Yes, ma'am, this is.
Okay, can you go ahead and cut it open and tell us what's inside?
The question too is, what is if the defense doesn't call the defendant, will they call any? They're going to call experts, right? So they're going to call expert witnesses. What are their expert witnesses again? Self-defense expert.
They didn't say, but they were going to talk about the rounds, the holes fired in the dwelling, and I presume it's going to be a use of force expert doing that. I can't imagine who else it would be.
And what is
someone
that,
who can talk about the pepper spray and the effects and.
And what is that?
It's the liner that was in the back of the pickup truck, as well as the jacket.
And these were the items you collected from the back of Mr. Cummings' truck?
Yes, ma'am.
Your Honor, the state moves admission of Exhibit 35.
Any objection, counsel? They'll be admitted.
Yeah, and I think the defense expert, if I'm betting a betting man, I would say that they're going to get somebody really good, and they're going to swamp them with some credentials and some expertise, and it's going to be really that expert for the defense. I'm really looking forward to, assuming it gets there, assuming it doesn't get JOA, right?
Assuming they're good. Man, I can see those experts. They make or break a case. If they come across as serious, well-informed, they can be amazing. But sometimes they come across like the crazy neighbor gun guy, and that's a bad look.
We had a great gun expert out of Georgia that we use all the time, and he was so good on the stand. He had this Southern accent. He's so reasonable. I mean, a good expert can really paint a picture for a case like this self-defense
sir.
case.
That's all I'm going to have you touch for right now.
It was like a first date.
So earlier this morning, you testified that you were the on-scene sergeant for the Sandoval County Sheriff's Office. Is that correct?
Yes, ma'am, that is correct.
How long were you on scene from start to finish?
From start to finish, I got there at, I want to say 7:30 is when I met Mr. McCullough, so probably 8-ish. And then I got off the scene, I believe, approximately 2 o'clock the next day.
Okay, so that would have been March 1st.
Yes, ma'am.
And when you were there at the ranch during the daylight hours then?
Yes, ma'am.
And this is a remote area, is that correct?
That is correct.
When you were out there, is it possible to see someone driving towards the ranch from a distance?
From a distance, not that far, just because of the way the mountains are. You wouldn't be able to see them. You'd hear them long before you saw them.
Okay. Your Honor, permission to publish what's already been admitted as Stakes Exhibits 1 through 12?
Will be admitted, and I'll let you publish them. Here you go.
Before we go on into your next role in this investigation and what you did, we're going to go ahead and go through some of the photos that have already been admitted. This is Stakes Exhibit 3. Do you recognize this area?
Yes, ma'am.
Taken with a
Describe to the
drone. I
jury
bet.
what this picture represents.
This is actually probably most of the 16 acres of the property.
That's not 16 acres.
No.
Where would the entry to the
Keystone
ranch?
Cop.
If you look at the bottom right corner, there's a vehicle further off this side. I think that's actually mine.
You can touch the screen.
Okay. This is your entrance right with the truck.
Okay.
There are two gates. There's a gate here.
Can
and then
you
there's
show us on the screen where the
the
gate
gate
is?
where this car's at, and then there's a second gate right here. The road that goes this way is for ranchers to go through the property, and then the other one is to the main property.
Okay. This is Stakes Exhibit 5.
That's pretty cool. So I wonder if it's still
Where
for
is
sale.
the mobile home at?
Actual mobile home's right here.
And then Stakes Exhibit 6. I'm just going to go ahead and go through these. Stakes Exhibit 7. Now this is, or at least from these pictures, it appears to be pretty flat as far as terrain.
Well, there's a ridge
Do you
right
agree?
there.
Yes, ma'am, right there.
So where would, let's put this picture up. This is Stakes Exhibit 8. Do you know where the Cabazon Peak area would be based on this photograph?
This direction. That's the way in.
Why is this relevant? I don't get it. Maybe the timing, or I guess, but they really need a good demonstrative aid with the timing if that's an issue. Obviously, they're making a big issue at time. They should have a timeline and place everything on the timeline on as a demonstrative aid, like they did in the Brooks trial. Was great. The prosecution did a great job with that.
From this photograph, where was the mobile home?
Mobile home is right here.
And that's where the Mr. Arriola's body was found?
That is correct.
Where was Mr. Cummings' trailer?
Mr. Cummings' trailer's right here.
And if you know, where was the water spigot?
I don't know the location of that. I would assume on the outside of the house, but I can't.
How does he not know where the water spigot is? This is the lead detective. The guy says, "I washed my pants on the floor," and you don't know where it is?
Come on, Steve. We all
And
know
where
the
was the mobile
truck was
home in this
barricading the roadway. That's all that matters.
This is terrible.
Gotta warm up, maybe.
Let me turn it off and on.
Turn it off and on.
Jiggle the handle. No, really, isn't that an item of interest? It's part of your case.
And
We've
where
been
was
talking
the
about.
entrance where Mr. Cummings' vehicle was?
This direction.
I'm putting under the document camera Stakes Exhibit 11. What is this a photograph of?
That's a picture of Mr. Ariano's vehicle. It's a black F-250.
And Stakes Exhibit 12.
Same vehicle.
And is that the entrance to the mobile home?
That is correct. That is one of the entrances. There is two.
Where's the other entrance?
The other one's in the kitchen living room area. It's like a studio apartment.
Okay, so this is actually a point of interest. I'm a little confused now. So Cummings, the defendant, had a trailer there,
Right.
but he wasn't living in the trailer. He was living here, is my understanding. But now I'm a little unclear about that.
I'm confused too. I thought he was living in his trailer and somehow he gets in here. Because if he's got the AR, why has he got an AR in this trailer?
Right. So that doesn't make any sense. So it must be both. I was conflating the two because I thought they were referring to this as a trailer. I think they did refer to this as a trailer.
They're both trailer. This is a mobile home trailer.
Right.
So there's two different things.
Yeah. Well, it would have been a very different narrative if he was not, in fact, living in this structure. You'd have to explain how the hell he was in there with a rifle.
On the other side.
What did you do next in this investigation? After you signed for the evidence from the New Mexico State Police that we already went through, what was your next role in this investigation?
After that, I logged all the evidence, went home. Monday morning, I went to OMI for the autopsy.
Where are autopsies done at?
At the OMI or SLD labs off of Lomas area.
In Albuquerque?
Yes, ma'am.
Do you remember what date the OMI was, or the autopsy was?
I want to say it's the Monday, the 3rd of March.
And the autopsy you attended, who was the decedent?
Mr. Arriola.
So he didn't screw that up. He didn't go to the wrong.
The New Mexico State Police had processed the scene.
The wrong
Did you ever go into
autopsy.
the manufactured home?
That day, no, I did not. They walked me through their exit. Normally during their processing, they'll do an exit where they walk you through what they found and they walk you through all the evidence at the same time.
Okay, and did they do that outside the manufactured home?
Yes, ma'am.
And did that conclude your involvement in this investigation?
Yes, ma'am, that is.
May I have a moment, Judge?
No questions, Your Honor.
No questions, yes.
One final question. Where this manufactured home, is this in Sandoval County, state of New Mexico?
Oh, yes, ma'am.
Okay. I'll pass the witness.
Okay, hold on. We're going to take our afternoon break, 15-minute break. And this time, what I want you to do is follow my bailiff and go into the first courtroom for your break. Okay.
So there's the big bailiff right there.
15 minutes.
All right.
Yeah, this is all form over substance.
Yeah. All right, folks, I'm going to stop things here. We'll catch up with this again in the morning for those of you who care to join. Steve, if you can just hang in for a couple of the super chats because some of them mention you, I know. Just take a couple minutes. Let's see. Farmhand Tom, another $5 from Farmhand Tom. Very generous day.
He's a good. Yeah. I love Farmhand Tom, man. He's awesome.
He's become one of my favorite streamers. Obviously, genuine guy. Keep it up, Steve. I concur. Shut up, I can cook. $5. Excellent, guys. I'm riveted, loving it. Kyle Mitchell, $2. It's supposed to be a $5 minimum, Kyle. Wasn't the Rittenhouse gun charge JOA? Oh, I talked about that already. Nathan C, $2. Come on. I got to figure out how to set that minimum. Come on, do one more witness after this. No, it's been a long day. I came to the office at like, what time is it now? Almost 12 hours ago to start this early, and then I had internet troubles. But I've been here awake. Shut up, I can cook. I love No Tie and Ty Branca. Thank you. Chat, do not corrupt Steve. Yes, Steve, indeed. Do not allow yourself to be corrupted. That would be a bad thing. And from our law self-defense members, let's see. Did any cameras work? Meaning the body cameras? No. Chuck, from what I see, they should not have charged him. Well, from what I see, too. Donnie O, have they introduced any evidence of an unlawful use of force yet? Not that I've seen. It's been innuendo, which is a tough way to get to proof beyond a reasonable doubt. Joe, today was a good day. The office mail brought both Steve's book and my Brooks Coffee Company serving relevant grounds coffee mug. I presume that's from the just completed
yes
Walker Parade trade.
Yes, I have my coffee cup too. It's a funny that I covered that whole trial with Nick, and it was painful. Great prosecution team now.
Missouri doesn't require a deadly force attack. Only requires reasonable belief in imminent danger of physical injury. Right. So you don't have to be subject to an actual deadly force attack to be justified in using deadly defensive force. You have to have a genuine and reasonable perception of a deadly force attack. For example, if someone were to threaten you with a gun that later turned out to be a toy, not actually capable of killing you, but it looked to a reasonable person like a real gun, that's sufficient to support a lawful use of deadly defensive force. The threat doesn't have to be actual. It has to be reasonably perceived. Let's see. Yeah, this trial's a change from watching Brooks. It sure is. Let's see. Danielle, well, yeah, same point, really. It's a SIG rifle. Okay, we talked about that. Let's see. I think that's it for today. All right. So, folks, Steve, thank you very much. Again, Steve, you should expect an invite from me tomorrow, but I understand you have other obligations. We will not take offense if you can't make it. I'll send out invitations to 5 or 6 folks who I think would be a value add to the conversation, and whoever can show up whenever they can show up would be great. Steve, where to find your book? Hold up your book one more time, brother.
Well, we got to make it big so people can see. Let's see.
Right. Yeah. All right. Good point.
Here
we go.
Yes, here we go. There's the book. It's all ready to go. And it's at, whoops, hey, look at that. I'm in charge. Wait, crimelaw.net. And then you can also see my Rumble channel at crimelaw.net, or Crime Law with Stephen N. Gosney at Rumble. But it's really set up to, well, if you don't get enough of me, you can go there and listen. You'll get sick of me. But please buy the book. I've had several purchases from this, and I'm running out. So I would really love to sell them out. That would be nice. So God bless you all for buying my book. And I'm really not that innocent. I just play it on TV. What happened to Andrew? Did he disappear? Oh, there he is. Who
wrote the foreword to that book?
Andrew Branca, the great self-defense expert. And in fact, I was going to also tell them that the crim law class that we've got going on in law of self-defense, I think, is some of my best work. And I'm very proud of it. We have some great students. And what about the Law of Self-Defense Law School? Tell us about that, Andrew.
Yes, we have a whole series of law school level courses that we're running. The first inaugural one, the Plank Owner one, was this criminal law class being taught by Professor Steve Gosney. It's part of the Law of Self-Defense Law School series of courses. These are law school level courses, just as, well, Steve and I were probably taught them in law school, but without the politics of current modern day law schools, none of this SJW crap that is thick through law schools today. And it's at a fraction of the cost of law school, a fraction of the time commitment. If you've ever wondered how you would have enjoyed a law school level class in criminal law, or we have other courses upcoming, criminal procedure, constitutional law, evidence, almost certainly more, this would be the place to go to have that law school like experience at lawselfdefense.com/law courses.
And one other one is that if you have a student who wants to go to law school, or somebody wants to go to law school, and you really want to leg up, this is what you could really come in there first year law school and crush it with the information we're giving you. So
right, everybody else if you go to law school, first year you'll take criminal law, guarantee it. Everybody else in your criminal law class, it'll be their first exposure. If you've gone through Steve's criminal law class, you will kick ass and take names. It'll be a breeze. So something to think about it. Or if you know anyone who's ever thought about going to law school, you got a kid who's thinking about going to law school, listen, it's not for everybody. They can get a taste of what it's like by taking one of these courses.
Right on. Hey, thanks a lot for letting me on. And
sure thing.
And I'm not sure how much I might be able to pop in, but I'm not going to be.
No worries. Here. If you can, you can. The invitation will be waiting for you. If you can do it, that's great. If you can't, no worries.
All right. Thanks a lot. I'm going to log here off.
Hey, best of the wife, Steve. Take care. And see you in a couple months.
Oh, yeah, for sure.
Still planning on dinner.
Definitely.
All right, buddy. Bye-bye. All right, folks. And whoops. Sorry. Okay. Steve and I are both clicking buttons at the same time. All right, folks. I'm going to wrap up today. It's been just over 6 hours. That's enough for today, given this trial. We will catch up at this point tomorrow morning, and we'll cover today's testimony as well. So hopefully we'll do our best to catch up as best we can. And with the usual commentary, bring in some support characters, hopefully, if people can make it. And we'll see what happens. At the very least, I'll be here for sure. Attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you very much. And remember, as always, if you carry a gun so you're hard to kill, make sure you also know the law so that you're hard to convict. Until tomorrow, stay safe. Bye-bye.